Good morning. This is Colorado Energy and Carbon Management Commission. This is a special Tuesday meeting on October 24th. We will recognize that we exist with a roll call.
Thank you. Commissioner Ackerman?
Here.
Commissioner Cross?
Present.
Commissioner McGowan?
Here.
Commissioner Mesner?
Here.
Commissioner Oates? Commissioner Ray?
Here.
Commissioner Robbins?
Here.
Mr. Chair, you have 6 of 7 commissioners present.
Great to see everybody. We will get into working on our business agenda. We have one docket today. That is 230400117. This is a proposed financial assurance plan by the operator KP Kaufman Company, operator number 46290. With that, we should elevate the parties. That would be KP Kaufman's lawyers and witnesses, as well as staff's lawyers and witnesses. Great. I see Mr. Jacobs and Mr. Boudreau. Mr. Jacobs, would you like to provide a welcome and who you are and who you represent?
My pleasure, Mr. Chairman. John Jacobs, Davis Graham Stubbs, outside counsel for KP Kaufman Company. With me are my colleagues Cole Killian and Nicole Rushevich, associates at Davis Graham, as well as the General Counsel for KP Kaufman, Mr. Ross Watsman. Our witnesses likely to testify today are present, so your direction on swearing in at some point would be welcome. Thank you.
Thank you, Mr. Jacobs. Let's continue with introductions, and then I think we're going to play a little bit with some procedural matters, and then we'll get into witnesses. Mr. Boudreau.
Thank you, Mr. Chair. Ben Boudreau from the Colorado Attorney General's Office on behalf of ECMC staff. Our witnesses are going to be Scott Cuthbertson and Greg Duranlo. I see Mr. Cuthbertson is in here, but we'll need to add Mr. Duranlo at some point.
Okay, great. Mr. Lewis Prescott.
Thank you, Chair. Stephen Lewis Prescott of Hammer Rodriguez, Ostrander, and Prescott, outside counsel to the city of Dacono, and our witnesses will be Mr. John Oborn and Ms. Jen Krieger. She may be discovered under a title of the Daisy Conference Room, just to help get her in when necessary.
Okay, I'm sure that Hearings Manager Thomas is taking good notes of that flag. Thank you very much. Mr. Sura.
Morning, Matt Sura, Special Counsel for the town of Frederick. We've got 3 witnesses, actually up to 4 witnesses. That would be Ryan Johnson, Assistant Town Manager for the town of Frederick, John Lee, Louis Conrad, and Rich Allward. Given the timing that we were given, I assumed that we were going to be heard much later in this, so they don't need to be elevated anytime soon.
Okay, great. All right. We've had entries of appearance. At this point, I think we should take up some of the procedural matters that may exist before we move into case presentations. As I read the record, I believe I find 4 pending procedural motions: a motion from KPK for partial summary judgment, one on the issue of whether the commission can order plugging and abandoning of wells as a part of a financial assurance proceeding. Number 2, whether the commission, it's kind of an argument, whether the commission erred in determining that Rule 702 requires a consideration of remediation costs. Those are the 2 preliminary motions for preliminary summary judgment. I also believe I find within the record a motion to strike Frederick's additional arguments that go beyond just remediation and delve into further reclamation points. And then depending upon the outcome of that motion, KPK has a motion for additional briefing to rebut Frederick's reclamation arguments. I'm not asking for lawyer arguments right now. I'm just asking for lawyers to let me know if I've got the pending motions identified correctly. Mr. Jacobs.
Yes, I believe that completes the procedural matters that we've raised by a motion. Thank you.
Okay. And I failed. I think there's also kind of continuing motions about time allocations as well as motions relevant to exhibits and admissibility. I just from a procedural matter, I'm going to rule that with regard to exhibits and admissibility, we'll take that up on an as-needed basis. And then with regard to time, we've got the time allocations as set forth by the hearing officer. Let's stick with that. If it looks like folks are getting hamstrung on time, I'm happy to sort of revisit that based upon where we are in the record. So those are my two initial rulings on the time and the exhibit admissibility. Mr. Lewis Prescott, did I get the other four correct in your estimation?
Thank you. It sounds like it. Yeah.
Mr. Sura?
Yes, that sounds right.
Mr. Boudreau?
Yes, Chair, that's right.
Okay, commissioners, how we normally approach procedural motions is I sort of ponder my thoughts out there, check in with commissioners to get a sense of whether there's agreement. I think under our delegated rules, I render rulings. I'm not inclined to entertain additional oral argument on the motions. I think they're adequately briefed. With regard to the motion, considering whether the commission has an ability to make an order of plugging and abandoning wells as part of a financial assurance plan, I frankly think we already ruled on this, and the ruling is no, that we're not going to entertain the notion of plugging and abandoning wells as part of a financial assurance plan. That is something that is outside the scope of a financial assurance plan. It is an authority that we have within us. I believe it's Rule 211, AAG Davenport, correct me if I'm wrong. And that is a rule regarding whether a well is considered used and useful. And I believe we've informed the town and the municipality that they can make a filing under that rule in an independent proceeding. And so that's my proposed ruling on that point. With regard to the reconsideration of the ruling that the commission has already made around remediation as being a component of a financial assurance plan, I believe we were clear there as well. I think it was unanimous that we believe that remediation costs can and should be considered when we're looking at a financial assurance plan as set forth in this proceeding. So with that, I would look to my fellow commissioners if anybody has any concerns with those thoughts about moving forward on the preliminary motion for summary judgment. Seeing no hands raised or any concerns, that'll be the rulings of the commission on the preliminary motions for summary judgment. With regard to the motion to strike Frederick's reclamation additional arguments, I'm kind of the opinion that Frederick had their opportunity to make argument around reclamation. They did so in their pleadings. They did so in their pre-hearing statements, and they're going to do so again today when they have their case in chief. And I want to try to keep this tailored to the hearing officer recommendations. And so I'm inclined to grant the motion to strike those additional 4 pages. With regard to the motion for more briefing, I believe that's rendered moot by the denial of the motion for the additional 4 pages of reclamation argument that was tendered. Those are my thoughts on the last 2 motions. Anybody with serious reservations? Commissioner Messner?
Thank you, Mr. Chair. I guess I want to better understand your point of view as far as providing additional argument or evidence associated with reclamation from the town of Frederick. It seems like it is relevant to the decisions that we're going to be making here. And I guess I'm unsure as to why you think that it is not appropriately brought before us.
I'm not saying it's not appropriately brought before us. I'm saying that as far as the written briefings, it's not consistent with the hearing officer recommendation. The town of Frederick can argue today around reclamation in their case in chief, and they've got time to do that. And I think that's the appropriate venue for that argument. That then gives KPK an ability to rebut that. I'm just trying to be cognizant of the direction that was given to everybody with regard to written pleadings.
Okay, so I think what I hear you say is that the written portion of it you are agreeing to strike, but they can bring it up in oral argument. Is that my understanding?
I think they can bring it up in their case in chief, however they desire. But I'm just trying to be cognizant that everyone was under certain direction with regard to written pleadings, and I'm trying to make sure that, in my opinion, is fairly attributed to each party.
Okay.
Further questions, thoughts, comments? All right, those will be the orders of the commission on the procedural matters. Again, we'll take up exhibits and timing as we get to those things. I think at this point, the next question on the dais is for us to sort of play out how we're going to play this hearing today. I'm inclined just to follow the hearing officer's recommended order. I believe that is the second final pre-hearing order that would allow for opening statements by staff, followed by KPK, Frederick, and Dacono. That would give staff an opportunity for presentation on the remediation aspects. If we remind ourselves of the staff and KPK have already provided their case in chiefs on the plugged and abandonment cost as well as reclamation. And we were provided them with an opportunity to supplement the record on around remediation. So staff would go first on remediation, KPK would go second on remediation. Frederick is then entitled to a full case in chief. That includes all aspects, the reclamation, plugging, and abandonment, as well as the remediation. Dacono would then go next on all aspects of its case in chief. Would remind both Frederick and Dacono that we're not entertaining argument on whether we should plug and abandon wells. That's a subsequent matter that they so choose to bring it. We then roll through rebuttal, staff, KPK, Frederick, Dacono, and then closing arguments, KPK, Frederick, Dacono, and staff. Mr. Jacobs, does that order of play align with your understanding?
It does align with my understanding of the hearing officer's ruling, but upon further reflection, I'd like to respectfully request that the order of closing argument, closing statements modified slightly. As you can appreciate, the dynamic of the parties and the alignment of the parties and the adversity of the parties has changed since the hearing began and was continued with this commission's rulings to continue the hearing and a clarification of its interpretation of the applicable rules and the standard. The order now is KPK, Frederick, Dacono, staff, with staff getting the last word. And I don't have an issue with staff getting the last word. That is customary. But I would request that KPK go second to last so that closing argument or statements be town of Frederick, city of Dacono, KPK, and staff. Otherwise, it's three adverse parties piling on in sequence at the very end and all getting the last word over KPK. And I frankly think that's prejudicial.
Mr. Lewis Prescott,
No, no strong opinion here. Thank you.
Mr. Sura,
I'm not concerned about that proposal either.
Mr. Boudreau.
Staff is indifferent, although we agree that staff would customarily go last for closings.
Okay, then let's amend the procedural arguments regarding closing arguments. We'll go with Frederick, DeCono, KPK, and staff in that order. Anything further on the procedural playlist here, Mr. Jacobs?
Not from KPK. Thank you, Mr. Chair.
Anything from your client, Mr. Lewis Prescott?
Nothing from DeCono. Thank you, Mr. Chair.
Mr. Sura,
Ready to go. Thank you.
Mr. Boudreau?
Nothing from staff. Thank you, Mr. Chair.
Very good. Anything further from commissioners now that we've set the script or tentatively set the script? Commissioner McGowan?
Thank you, Mr. Chair. I can't remember if we settled the item regarding salvage value last meeting, or if that's something that we'll also put to rest today. If you could remind me.
AAG Davenport, could you visualize yourself? Now you got to unmute yourself.
Thank you. Commissioner McGowan, I want to make sure I understand your question, and that is the issue of salvage value, whether the commission will consider salvage value in setting the amount of financial assurance. Is that accurate?
Yes.
Okay. So I'm going off my memory here, so forgive me, I could be wrong about this. My recollection is, and this is, I think, directed toward KPK's counsel more than anything, is this was a matter that was going to be reserved for a subsequent hearing, in the sense that KPK, my recollection is, had expressed interest in at a subsequent proceeding bringing up using alternative forms of financial assurance, which may be granting an interest to ECMC on salvage or equipment.
Mr. Jacobs?
Certainly, I was just waiting for your direction. Yes, that is correct. We would seek, depending on the outcome of this proceeding, to determine the amount of financial assurance petition, I believe under 701B, for a form of financial assurance proceeding hearing. And on that basis, withdrew our desire to put on evidence, exhibits, testimony on salvage value. We reserve the right to do that. We've indicated in our list of exhibits, stricken through those salvage value exhibits, for example, based on that prior representation, much like the commission's ruling a moment ago on the plugging and abandonment order. Those will each proceed in, if the parties so desire, in separate proceedings following this hearing.
Commissioner McGowan, does that satisfactorily answer your question?
Yeah, thank you. Sometimes this happens when we have gaps in between meeting and I can't remember exactly what we decided. So that's helpful. Thank you so much.
Agree with gap piece. Commissioner Cross.
Thank you, Mr. Chair. I just want to make sure that I fully understand with regard to the same subject. And Mr. Jacobs, is KPK going to argue that their ability to pay financial assurance is tied to that salvage value being approved at a future hearing?
We reserve the right to put on evidence of ability to pay in any proceeding. I don't believe that it's an issue in determining the amount of financial assurance under this commission's rules. It's not a penalty. Our ability to pay testimony in other dockets, as you know, has been provided in connection with the consideration of appropriate penalties for violations found. That's squarely within the scope of your penalty policy. It may be relevant to a form of financial assurance hearing, a separate proceeding. I hope I'm answering your question, Commissioner.
Well, and I think yes, no, one of the things is under the 700 rules, it specifically requires a certification of financial capability that all obligations imposed by the rule can be met. And so I just want to make sure I understand that KPK is going to say, regardless of the salvage value, they have the financial capability to meet their obligations.
Well, if I may, Mr. Chair.
Go ahead.
We have 90 days to attempt to meet the requirement of financial assurance to be determined by this commission at the conclusion of this hearing. At that time, we'll either meet it or we won't. We'll have proceeded perhaps to a determination of whether a security interest in our equipment, which has substantial value, as our previously submitted exhibits indicate, and as witness testimony would also indicate, although that witness won't be providing testimony in this proceeding, it would be in a subsequent proceeding. So I guess I'm not prepared to take a position on the ability to post financial assurance. It's an obligation for all operators at the conclusion of hearings and administrative proceedings such as these under your 700 series rules.
And I guess I'm not saying that there's not an obligation to provide the financial assurance, but under the rules, as part of the financial assurance plan, you have to provide a certification of financial capability. And so I guess that's where I get hung up on the salvage value issue is I want to know if KPK is saying we have the financial capability to meet our obligations separate and apart from the salvage value issue. Because I frankly have a little bit of a hard time looking at the financial assurance plan absent that and approving something that then we have to look at in the future.
If I may, Mr. Chair.
Go ahead.
I don't think it's quite that cut and dried. I mean, from prior testimony, substantial proceedings in this docket and other dockets, that KPK is a cash flow business. It has established unrefuted testimony that it has an ability to pay issue with respect to $2 million in penalties. That has not substantially changed. Mr. Kaufman testified to that in August. Our ability to certify we can meet your financial assurance determination doesn't mean it has to be a cash bond or a surety bond. We also had provided to this commission substantial information regarding the value of our primary reserves and the option value of our Spindle field assets. That is subject to claims of confidential business information. It was supplied with our Form 3 financial assurance plan. So although we don't have the liquidity to write a check for whatever you determine financial assurance should be in an amount, we have other opportunities to leverage the value of the company to meet those obligations. How we meet them is out ahead of us. I can't predict that. I don't even know the amount yet. That's why we're here today.
Yeah. And thank you, Mr. Jacobs. And I think I'd like to, with all due respect, shut down this line of inquiry. I think at this point, we're here today to make a determination of the required financial assurance for KPK. let's focus on that after the hearing. If we get to an answer, KPK has 90 days to post said financial assurance, and there's multiple methods for doing that. If that occurs, great. If there are concerns, I'm sure we'll hear from KPK about that. Is that fair, Commissioner Cross and or Mr. Jacobs?
I'm fine with that for the time being, yes.
Thanks.
Also fine. Thank you, Mr. Chair.
Okay. Appreciate the inquiry and the mode there. With that, unless there's anything further from the lawyers in the room, which if you've got something further, raise your hand. Without that, then I believe we're going to move to opening statement from staff.
Thank you, Mr. Chair. Good morning, commissioners. We're here today for the second financial assurance hearing regarding KP Kaufman Company, Inc. At the first hearing on August 17th, staff presented testimony and evidence to support plugging and abandonment and reclamation costs on a per well basis for KPK. At that hearing, the commission expressed concern that neither KPK nor staff included KPK's known remediation issues in calculating KPK's demonstrated costs for single well financial assurance. Today, Deputy Director Cuthbertson will testify briefly regarding the director's response to the commission's direction on remediation. Then environmental Manager Greg Duranlo will present a thorough assessment of KPK's known remediation issues and associated costs. Mr. Duranlo and ECMC's environmental staff have performed an extensive spill-by-spill, site-by-site analysis for KPK's known remediation issues. Mr. Duranlo will testify to the method staff used to estimate those costs, and staff ended up calculating $24,344,402 in remediation costs for KPK. Staff considers this a conservative estimate for KPK's known remediation issues, as Mr. Duranlo would testify. Meanwhile, KPK calculated approximately $2.9 million for its known remediation issues. Staff considers this an incomplete calculation. Staff's calculations include costs for reclamation for off-site locations. And this may be a little bit confusing considering the nature of this case, but basically staff views two categories of reclamation. The first is reclamation of permitted locations. That number is already captured in the reclamation cost staff supports from the first hearing. So that's not an issue today, at least from staff's perspective. The second reclamation category is for off-site remediations. In other words, while assessing KPK's known remediation issues, staff noted that a number of spills or contaminations are located off of permitted locations. Because those off-location spills require not just remediation, but also reclamation of the off-location sites, staff included those off-location reclamation costs in our remediation costs. When staff talks about reclamation today, that's what we're talking about, the off-location reclamations that were not previously captured in the first hearing. Staff and KPK are about $21.5 million apart on their calculations. At least part of this difference between the two calculations can be attributed to the fact that staff identified more known remediation issues than KPK identified in their calculations. Staff also used what we consider more reliable sources to calculate those costs. Sources that actually reflect what ECMC might pay to remediate these sites, rather than what KPK says KPK would pay. But most importantly, staff was simply more thorough in their calculations, and that results in a much more accurate estimate of what KPK should post to cover their known remediation issues. At the end of this hearing, staff will respectfully request the commission enter an order that KPK post its financial assurance amount, inclusive of P&A, reclamation, and remediation costs. Thank you. Mr. Chair, you're muted.
Thanks. Sorry, thought I unmuted. I believe we now have an opening statement from KPK. I note that the agenda says followed by commissioner questions, but Normally on opening statements, it's not really procedurally needed for questions. We wait for the case in chief. So if that's okay, we're going to move forward to KPK's opening statement.
Thank you, Mr. Chair. Commissioners, we resume this continued financial assurance hearing to specifically address estimates of remediation expense for known contamination at KPK locations subject to single well financial assurance. And while KPK disagrees with the Commission's rulings that remediation expense must be considered in this proceeding under Rule 702B, and the scope of locations requiring remediation estimates is not limited to those with an approved Form 27 in place, we are of course prepared to proceed with testimony and evidence to support our estimate of such remediation expense. Before turning to that testimony and evidence, however, KPK wishes to also note another significant issue with not engaging in the kind of site-by-site review of Forms 27 contemplated by the plain meaning of the applicable financial assurance rule language in developing an estimate of remediation expense for purposes of single well financial assurance. That issue concerns the sites for which KPK possesses a good faith belief that it is not the responsible operator, but staff has required a Form 19 spiller release report to be filed by KPK, and therefore staff now expects remediation expense estimates to be included in financial assurance for such locations. I bring to your attention just a few such sites to illustrate the prejudice to KPK and likely other operators of this approach. The first is the North Quebec location, the subject of forensic analyses by KPK in preparation for a responsible party determination hearing under the CPA, the Compliance Plan Agreement, prior to its termination by this commission last February. While that responsible party determination proceeding has been stayed indefinitely, KPK has not waived and reserves its right to contest responsibility for historic contamination at that site. Staff has estimated remediation expense at this location of $1,077,533. Next is the Boxer Tank Battery and nearby Salt Kill area. These are two locations that have been the subject of discussions and negotiations with ECMC staff for years. KPK sent ECMC a letter in December 2018 indicating that it was not responsible for remediating the tank battery and Salt Kill area locations, and later met with staff concerning this location. KPK explained that the tank battery and Salt Kill area are outside KPK's oil and gas operations area, and that it only operates wells located in Section 32, Township 2 North, Range 58 West under a surface use agreement dated December of 1992. The nearby Boxer Unit 21 and 22 wells were properly P&A'd by KPK in 1988, and KPK also closed an earthen pit 300 feet east of the Boxer battery in 2012. In short, because the tank battery and Salt Kill locations are outside KPK's oil and gas operations area, KPK should not be responsible for remediating these two locations identified by ECMC staff in Exhibit 10. In addition, the owner of this area has indicated it does not want KPK to reclaim this portion of land, nor are they willing to grant KPK access to the land to remediate or reclaim any salt impacts.
Mr. Chair, I hesitate to interrupt an opening statement, but this is starting to sound like testimony from Mr. Jacobs.
I'll allow the opening to go. We'll have an opportunity for case in chief and direct and redirect, etc.
Thank you.
Thank you, Mr. Chair. Staff has never responded to KPK's last communications on this dispute, but staff now includes the locations, tank battery, in its estimate of remediation expense for this location at $735,000 for the tank battery and $1,200,000 and change for the Salt Kill area, for a total of $1,936,786. Finally, perhaps and most compellingly, is the Guadgnoli Consolidated Flowline location, which involves a groundwater detection of hydrocarbons by the town of Frederick and its consultants over 500 feet from the nearest KPK facility, but immediately adjacent to midstream flow lines. There is no evidence of a prior release from KPK facilities. but staff insisted on a Form 19 being filed by KPK, and it obliged. Staff estimates the remediation for this location at $220,000 and therefore seeks to have KPK post financial assurance with no evidence whatsoever of causation. This borders on strict liability, which is not available under the Oil and Gas Conservation Act, and even strict liability requires evidence of causation. A site-by-site review of remediation expense for locations with known contamination would at least partially alleviate the extremely harsh consequences of staff's approach in this proceeding with respect to this Quadganoli location in particular, and the resulting denial of due process to KPK. Now, turning to KPK's testimony and evidence on remediation expenses for locations subject to single well financial assurance, it will be provided primarily by John Peterson, KPK's Director of EHS Compliance, and also by David Hines with Ramble Consultants. Both of these KPK witnesses are experts in the field of environmental remediation. Mr. Peterson has 30 years of experience in environmental investigations and remediation, focused primarily on the oil and gas industry and almost exclusively here in Colorado. Mr. Hines also has approximately 30 years of experience in environmental remediation at Superfund and mining sites, as well as at oil and gas locations, with experience here in Colorado and around the country. Between them, they've worked on well over 1,000 environmental assessment and remediation projects. Mr. Peterson will describe his consideration of the best available data from Forms 27 for the KPK locations subject to single well financial assurance with known contamination, his use of market rate unit costs, and various conservative assumptions to estimate a total remediation expense of $2.9 million. Mr. Hines will then address the issue of background determinations for inorganics in soil and groundwater and how that background issue affects the staff's assumed volumes of soil remaining to be excavated and also backfilled in the course of remediation at KPK locations, two important cost drivers in staff's overestimate of remediation expense at KPK locations. This KPK testimony and evidence contrasts sharply with the remediation expense estimate prepared by staff that lacks the significant direct and recent remediation experience of KPK's witnesses, a staff that did not consider the best available data from Forms 27, that used a cost schedule from another state agency not involved in upstream oil and gas activities, rather than looking at the voluminous cost information contained in its own COGIS database that is specific to remediation in the upstream sector, and that inappropriately assumed significant additional excavation for sites where all hydrocarbon impacts have been removed and only background inorganics and soil remain, among other significant shortcomings. These significant differences in approach will be illustrated through examination of the two estimates, KPK's in its Exhibit S and staff's in its Exhibit 10, and through consideration of a number of sites specifically by Mr. Peterson and Mr. Hines. Such sites include one with no prior fluid release at all that staff asserts must be further excavated and remediated simply due to the presence of naturally occurring inorganics in soil, and others with very small excavations, no remaining hydrocarbon impacts, and yet staff inexplicably estimates six-figure remediation costs. KPK's expert witness testimony will also illustrate how the staff's assumptions depart significantly from industry norms and cause the estimates of remediation expense in staff's Exhibit 10 to greatly exceed any reasonable estimate necessary for purposes of financial assurance. These departures from industry norms include the use of inappropriately high unit costs, an inappropriately high number of samples required for establishing background and confirming the effectiveness of remediation, the excessive dewatering of sites in connection with remediation, and an overestimate of necessary groundwater monitoring for many sites based on current data. Finally, you will hear from KPK witness John Peterson about how staff's approach to reclamation at off-location spiller release sites is excessive and not in keeping with the restoration of pre-release conditions at most such locations. For all of these reasons, we urge you to accept KPK's estimate of remediation expense for its locations with known contamination subject to single well financial assurance, even if inclusive of locations for which there is no approved Form 27 at present, as better supported by substantial evidence and testimony as well as by the superior experience and knowledge of KPK's witnesses on the subject of remediation in particular. That remediation expense estimate, inclusive of Forms 19 and unapproved Forms 27, is $3.9 million, an additional $1 million more, a figure carefully and reasonably derived in light of available data and using market rates. I thank you in advance for your careful attention to the evidence and argument to be presented on remediation expense estimates for KPK locations subject to single well financial assurance with known contamination. Thank you.
Thank you for the opening statement. We now will hear an opening statement from the town of Frederick. And I see a screen share, Mr. Sura. Looks good.
Great, thank you. Matt Sura, Special Counsel for the town of Frederick. With over 1,200 wells averaging less than 1 barrel of oil a day, KP Kaufman is one of the largest and lowest producing operators in the state. Financial assurance rules consider KP Kaufman an option 4 operator, which is reserved for those companies who represent the highest threat of defaulting on their plugging and abandonment obligations. For that reason, the financial assurance require them to post the highest amount of financial assurance, single well financial assurance, enough bonding to cover each and every well in their portfolio. Town of Frederick has more exposure to this operator than most local governments. Within its 15 square miles, there are 108 KP Kaufman wells. The town would be uniquely harmed if KPK were to default on its plugging and abandonment obligations. Frederick wants to ensure that enough financial assurance exists to plug all 108 wells within the town. They're especially concerned about KP Kaufman proposing and ECMC staff agreeing to a mere $7,834 a well for reclamation. That proposal is not credible, and we are asking that you correct it in your decision today. At the last hearing, KP Kaufman wanted you to believe that reclamation is not even necessary in places like Frederick because of all of its wells in Frederick are eventually going to be paved over or otherwise incorporated into residential or commercial development. We will hear from 2 landowners and developers who will dispute that claim. In fact, there's only a very small window of time when land that is being developed when it's in the interest of the developer to pay KP Kaufman to plug and abandon those wells. Once those areas are platted, KP Kaufman's opportunity to get assistance from developers completely evaporates. The oil and gas locations are then in open space and will need to be plugged and abandoned and completely reclaimed, including bringing in topsoil. Financial assurance regulations require a site-by-site analysis if an operator wants to use demonstrated costs rather than the estimated cost in the rules. A site-by-site analysis is clearly indicated in both the rules and the statement of basis and purpose. It is called single well financial assurance. The statement of basis and purpose defines what ECMC staff and you commissioners believed were the most important factors to be considered for each and every well site. We've already talked about known remediation issues, and we're going to go into that further today. And the town of Frederick appreciates you recognizing that requirement. But the next one is important to see as well: areas of initial and total disturbance for the oil and gas location and any associated facilities. This is likely to be the most important because the amount of acreage disturbed is going to dictate how much work needs to be accomplished on that site, how much topsoil and seed is needed, and in this case, access roads were not considered at all. And we've also heard that they didn't consider any disturbance from removal of pipelines, flow lines. There's also whether or not an oil and gas location has sandy soils and whether the topsoil has been salvaged at the oil and gas location. Again, this is a specific site-by-site analysis at the oil and gas location. KP Kaufman stated that topsoil is not needed on rangelands, and only a small amount of amendment might be needed in farmland. Reclamation expert Rich Allward will dispute those claims today. How are the demonstrated costs supposed to be estimated? It says here down here that you're to look at 3 years of invoices or a third-party estimate of plugging and abandonment costs. Well, KP Kaufman did neither of these. Instead, their staff chose to consider 18 hand-selected exemplar sites. As you will hear in testimony today, even if your rules were to allow the use of exemplar sites, KP Kaufman did not consider whether their hand-chosen sites were on sandy soils, the cost of importing topsoil, and the removal of flow lines and access roads. They also did not use a third-party analysis, but merely borrowed cost estimates from another operator who is not part of this proceeding, Helena Resources. Helena Resources submitted a public comment into the record on August 17th to contest KP Kaufman using its cost estimates. We will hear from Frederick's reclamation expert, Rich Alward, who has reviewed several of the exemplar locations and found that KP Kaufman's estimate of $7,834 a well was underestimated by a factor of 12 for the exemplar locations. The town of Frederick did provide a site-by-site third-party analysis for all 108 wells within its jurisdiction. Dr. Alward found that the locations in Frederick are typically smaller in size and have very short access roads. In Frederick, the average reclamation cost was estimated to be $55,234. This is less than the $100,000 estimated cost in the rules, but 7 times what KP Kaufman has proposed for reclamation. The town of Frederick appreciates that the commission required KP Kaufman to add known reclamation sites to financial assurance estimates. By doing that, the commission followed the rules and the guidance as provided in the statement of basis and purpose and did a site-by-site analysis themselves. In doing that site-by-site analysis of remediation sites, the staff used an average reclamation cost of $45,000 an acre. That is far more than the $7,834 per well that staff agreed to earlier. This is the first opportunity to implement these regulations and for you to identify and put forward some guidance to operators and to staff as to how to consider demonstrated costs. It is important that reclamation estimates are credible. What the town is requesting is that estimated single well financial assurance of $30,000 a well or $100,000 per location be required of all KP Kaufman wells because KP Kaufman failed to offer credible demonstrated costs. As an alternative, the town of Frederick would support financial assurance for 108 wells within the town of Frederick and the 59 wells within the city of Dacono for what the estimated plugging costs that KP Kaufman put forward of $31,626 per well for plugging and the credible reclamation costs of either $55,000 per well, the town of Frederick estimate, $55,000 to $60,000 per well, which was the reclamation estimate from a third party that was put into the record by the city of Dacono, or $45,000 an acre that the reclamation staff has just recently put into the record. Any one of those would be far more credible than the $7,834 that is put forward by KP Kaufman. The town further requests that KP Kaufman post the additional $24 million in bonding for known remediation projects as outlined in the ECMC staff supplemental pre-hearing statement. Thank you.
All right, thank you, Mr. Sura, for that opening statement. I believe we now will have an opening statement from the town or city of Dacono. I think it's a city.
Thank you, Chair, and I'll keep this brief. The commission has heard evidence that KPK does not actually reclaim well sites. KPK's evidence related to reclamation was shown to be unreliable. Similarly, staff's review of KPK's reclamation costs was shown to be deficient and unreliable. The $39,000 single well financial assurance proposed by KPK and accepted by staff for plugging and reclamation should be rejected. Reliable evidence will show the actual plugging and reclamation cost for KPK's wells is much closer to $100,000 per well. The commission will hear about KPK's approximate 150 remediation locations, equal to more than 10% of KPK's existing wells that remain open today. 17 of those open sites are in Dacono. The commission is already aware that KPK does not complete remediation. I encourage the commission to take judicial notice of past orders, such as 901A and 1V-863, showing KPK's inability or refusal to complete ordered remediations. Again, KPK cannot provide reliable evidence about something that it does not actually have reliable information related to. ECMC staff in this instance did complete a sufficient and adequate review related to open remediation costs, which Tacona supports. Tacona believes it is obvious that KPK's demonstrated costs fall far short of believable and should be rejected. Tacona believes the evidence will fully support the figures just now presented by Frederick, noting that Frederick and Tacona are adjacent communities and face identical issues involving KPK. Thank you.
Great. Thank you very much. I appreciate all of the opening statements from the various parties to this proceeding. Moving along, because we've got a long day ahead of us, we will now move toward a presentation by staff. I believe this presentation is going to be limited to the remediation cost issues that staff supplemented the record with at our direction. Mr. Boudreau.
Thank you, Mr. Chair. That's right. First, we'd like to bring on Deputy Director Scott Cuthbertson to briefly address the director's response to the Commission's August 17th order, and then we'll bring on Environmental Manager Greg Duranlo to testify as to staff's calculations of KPK's known remediation issues.
Very good. Let's have both witnesses visualize themselves, and then we'll have AAG Davenport swear in the witnesses.
Thank you, Chair. We'll start with Deputy Director Cuthbertson. Sir, if you would please raise your hand, state your name, and say that you swear to tell the truth.
My name is Scott Cuthbertson, and I swear to tell the truth.
Thank you, Mr. Duranlo.
Greg Duranlo, and I swear to tell the truth.
Thank you.
Very good. Having taken care of the procedural matters, Mr. Boudreau, your witnesses.
Thank you, Mr. Chair. Thank you for being here today, Mr. Cuthbertson. Would you please state your name?
Scott Cuthbertson.
And what is your position?
I'm Deputy Director for Operations with the ECMC.
And you participated in the previous hearing on this matter on August 17th, correct?
Yes.
Did you hear the chair summarize the Commission's position regarding the need to include remediation costs as part of the demonstrated costs for single well financial assurance?
Yes.
And why did you support the applicant's previous demonstrated cost that did not include known remediation issues?
So we supported them based on a protocol that we had developed as part of the review of the initial financial assurance plan, or the initial Form 3s for all the operators. And that protocol was based on a rule interpretation that we believed allowed for the issue of known remediation to be addressed either through the demonstrated cost analysis or through a 703B analysis. And in the interest of reviewing those initial Form 3s in the most effective way, the protocol that we set up was that when the known remediation issues were relatively minor, we included them, and the operator was requesting demonstrated costs, we included that analysis as part of that operator's demonstrated cost analysis. When the known remediation issues were significant and the operator was requesting demonstrated costs, we thought that an equivalent evaluation through a subsequent 703B analysis was allowable under the rule. And we adopted that protocol, believing that either approach was contemplated by the rules, and to enable the initial plans to be approved as expeditiously as possible. Because this plan had significant known remediation issues, we implemented the second prong of that protocol, intending to augment the assurance required by the initial plan as a part of the first annual review using Rule 703B.
Okay, and what is the director's understanding today of how remediation costs work?
We understand and we agree with the Commission's requirement to include costs to address all known remediation issues as part of any demonstrated cost proposal.
Did you take any other action in response to the Commission's order on August 17th?
Yes, I directed our environmental unit to complete the known remediation review we had already initiated in preparation for the anticipated first annual review in time to include that information in this hearing instead of the previous deadline that I had given them for completing it later this year.
And was staff able to complete the review?
Yes, Environmental Manager Greg Duranlo is here to provide the results of that review.
Thank you, Mr. Cuthbertson, for being here to provide that context. No more questions from staff on direct for Mr. Cuthbertson.
Yeah, AAG Davenport, help me here. I'm trying to determine, do we finish up all of staff and then do cross, or do we do cross for each particular witness?
Chair, I think the commission's practice has been to do cross after each witness. So we're not
Right.
recalling folks back.
Okay. And then to be consistent, we now have an opportunity for cross. And in no particular order, Mr. Jacobs, cross-examination.
Yes, Mr. Chairman, I do have some questions for this witness. Good morning, Deputy Director Cuthbertson. Appreciate your being available this morning.
Good morning.
I believe you indicated that based on the commission's ruling with which you now agree, you're requiring remediation estimates as part of financial assurance for KPK. Is that correct?
As part of the demonstrated cost analysis, yes.
As part of demonstrated costs, thank you. But is it not true that the commission has approved a number of operators' financial assurance plans, their forms 3, without remediation estimates included?
Could I ask for clarification? Are you referring to operators that have requested to use demonstrated costs, or just all plans in general?
Some have and some have not, and I can provide you examples, but I'm happy to clarify.
So there are some plans that have not requested demonstrated costs, and there was no known remediation issue beyond the already identified 703B remediation that was in existence at the time the Form 3 was submitted. And those costs were included as a part of that initial plan. There were operators who submitted an initial plan that included demonstrated costs, and every one of those plans that have been approved, the known remediation issue has been included in that analysis.
I would beg to differ. Are you familiar with the Peakview Operating Company financial assurance plan approved just last week?
Well, I'm sure I am. I can refresh my memory here quickly and pull a document up if you like.
I would represent to you that that was submitted under option 3, was approved on October 20th, and that company, that operator, had 3 open forms 27 and no remediation expense estimate. Are you familiar with Brown Oil and Gas Operators financial assurance plan, also approved last week?
Mr. Cuthbertson, before you answer the second question, did you want to dig into the first question at all?
Well, no, Chair. It's probably not prudent to try to dig into the depth of the details. I can say that I think I understand Mr. Jacobs's line of questioning. If I could maybe answer, and thank you.
Please do.
Certainly.
There were a number of operators who submitted demonstrated costs who had existing Form 27s with known remediation issues. The plans were approved with no additional remediation assurance required because of the status of those known remediation issues. And I can't remember the specifics of each plan, but there were examples of an operator who had a known remediation issue of a tire fire, for instance, and they were in the final stages of reclaiming that issue. The analysis at that point was, given the status of that remediation project, it didn't warrant additional remediation costs as part of his financial assurance plan. So to your point, yes, there have been a number of financial assurance plans for operators with requesting demonstrated costs who do have known remediation issues, but for which no additional remediation assurance was required as part of the approval because the status of their known remediation issue was such that there was no substantive work remaining that would warrant a financial risk that would warrant additional assurance in staff's opinion.
For your response, I would beg to differ once again and refer you to the case of Timka Resources Limited with open forms 27 and an open form 19 for over a year with no supplementation, and Web King Fullerton Energy where open forms 19 were not considered. This goes counter to what Mr. Duranlo and his staff have done with respect to the scope of financial assurance in this proceeding. Happy to hear your response to that.
I don't have an additional response. I'm aware of those circumstances, and the analysis that we conducted was that the status of those issues, sometimes the form 19 is opened as a part of a plugging and abandonment to track that through the process. None of the analysis we did for any of the plans that we've approved in staff's opinion were substantive enough activities such that additional financial assurance was deemed appropriate.
Once again, I respectfully disagree, but thank you for your response, and I believe that concludes my cross-examination of this witness.
All right, very good. Cross-examination from Mr. Sura.
Yeah, just let me pull them up. Thank you, Mr. Cuthbertson. And this may be more appropriate for Greg Duranlo, but I was just wondering who was responsible for assembling exhibit ECMC staff's exhibit 10.
In this hearing today?
Yeah, for this hearing.
Yeah, I believe that was Mr. Duranlo.
And more of a general question then, when you did the site-by-site analysis of all known remediation locations, what staff worked with you on those issues, on putting that, on doing that considerable work?
So my direction was to Mr. Duranlo, and maybe he can provide you additional clarification of that.
Okay, thanks so much.
Mr. Lewis Prescott.
Nothing from Dagono, but thank you.
Okay. Deputy Director Cuthbertson, you're now under questions from commissioners if we have any. I kind of like to ask one question, which is, so you are operating under a approach for financial assurance that did not include the remediation cost approach for KPK, and then you received a question, or you received a point from the commissioners at the August hearing, I believe, in which we directed remediation ought to be evaluated. Is that accurate?
Yes, with a slight modification. The director was pursuing financial assurance for remediation issues from the outset. We had just misunderstood that we thought that it would be appropriate to do that as a part of a 703B analysis, because we felt like that rule foundation provided a more effective approach. But we have never not considered remediation issues as part of an initial financial assurance plan. But yes, in this specific case, we had bifurcated our analysis between the initial financial assurance plan, where we did not include the known remediation issues as part of the demonstrated costs, and had initiated a 703B review early this summer, in contemplation of having that finished in time for the first annual review, which we were projecting to happen this coming December, hopefully. So that would be my response.
Okay, and then the sort of a follow-up is, with the direction from the commission, which is our prerogative, are you treating all operators consistently vis-a-vis that direction?
Yes, the point that Mr. Jacobs made is that there have been plans that the director has approved for operators requesting demonstrated costs, where they had known remediation issues in the standpoint that they have an open form 27 or they have an open form 19. But the analysis of those issues were that the status of those projects weren't substantive such that additional financial assurance was deemed necessary.
Great, thank you for that dialogue. Commissioner Cross?
Thank you, Mr. Chair, and thank you, Mr. Cuthbertson. Following up on that last line of questioning a little bit, in any of the open Form 27s, because I know this was something we talked about at the previous hearing, was there any financial assurance required or included as part of the Form 27 that is open in the instances that Mr. Jacobs was referring to?
I don't recall in every case, but there were a number of operators who did have extant financial assurance pursuant to 703B as a part of their initial plan. And I just can't remember if any of those were the operators that would fall into this subset of operators. So I don't remember, I'm sorry.
And I guess not to beat a dead horse, but just to make sure we're all on the same page, there are instances of open remediation where plans have been approved with the known remediation ongoing, but staff's assessment and analysis showed that additional financial assurance beyond what is being proposed in the demonstrated cost was not necessary in those instances.
That's correct.
But in this case, you're saying additional financial assurance is needed beyond what's being proposed in the demonstrated costs.
That's correct.
Okay, thank you. No further questions.
Commissioner Messner?
Thank you, Mr. Chair. Thank you, Mr. Cuthbertson, for being here today. I've got a question about not the remediation, but rather the reclamation and the acceptance of the 7,800, whatever it is, that was included in the director's recommendation associated with this. And so I'm trying to understand, in the reclamation evaluation, and if this is a more appropriate question for Mr. Geronimo, just let me know. But in the remediation analysis, there was reclamation considered, and I do understand that we're talking about offsite reclamation, and so that was clear by Mr. Boudreau, his indication there. But that offsite reclamation came in, I believe, at approximately $45,000 per acre. And I'm trying to understand how different that offsite reclamation associated with the remediation figures could be so drastically different than the accepted $7,900, $7,800 reclamation demonstrated cost amount that was provided by KPK as being adequate reclamation in determining demonstrated cost. Does that question make sense?
Yes, sir. And so at the time that we did the analysis of the proposed reclamation costs of 70 whatever $100 per well, and just to be thorough, right, the reclamation analysis is on a per location. And so when you translate that per well to per location, it's about $8,600 per location. Something like that is my memory. At the time that we were reviewing that information, the primary information that we had to rely upon was our own experience with the orphan well program. And our orphan well program average location-based reclamation costs for properties similarly situated to this operators in Northeast Colorado, flat, small, not complex, meaning basically they're just wellheads, not tank batteries on every location, agriculturally proximate locations, Weld County type locations. The costs that our orphan well program had been seeing for those kinds of locations were $8,000 to $10,000 per location is what they were averaging. And so 8,600 is reasonably within the 8,000 to 10,000. And so the director really had no reason to believe that that estimate was not reasonable given our experience in the orphan well program. The other dynamic at play here is that there are two different foundations. The detailed specific analysis that you'll hear in just a minute was done with granular data for specific sites with known acreages, whereas the 900 plus locations included in the previous assessment don't have granular areas. It's a per location, it's not a per acre. So you take the 45,000, if it's a 1/10 of an acre site, it's $4.5 grand per location, right? If it's a 2/10, it's a $9 grand. So they're on two different foundations, and we do not have the data in hand today, but our anticipation is that with every operator, as we annually review these plans, which I think was part of the intention of the rules to have these plans be reviewed annually, is recognizing that as we go along, we will continue to refine and develop additional data that can be relied upon in those annual reviews to amend the foundation for the financial assurance that has been approved. The rules contemplate that. In fact, the rules direct that, right? So in the analysis that was done at the time we had that data, our relevant information that we had was our orphan well program experience, which was 8 to 10 per location for similarly situated and type of sites. And so that was the reason that we developed the position we did. Does that answer your question, Commissioner Mester?
I mean, it does. I just want to clarify one thing though, but in that analysis to review that reclamation number, that analysis wasn't done on 900 some wells. It was done on the 18 example wells that was provided by KPK. Is that correct?
Yes, and while I was the one who reviewed that plan. I reviewed all the plans. We did not project our contextual understanding of operations onto any operator's plan, but we also have a general contextual understanding of the kind of operations that the plan has. And so for this operator, I felt like the 18 surrogate wells to demonstrate different types of mainly well abandonments was reasonable. And the location really was not specific to that, right? The location was much more generic, which was to say, here's what we're seeing on an average per location. One location could be 100 grand. Another location could be $100. It averages out. When you have 900, there's some opportunity for some flexibility in scale. And so that was the analysis that we did.
Okay, thank you.
Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Mr. Cuthbertson. I guess mine is a broader question, which is, in the past, if staff has discovered that a rule was not interpreted exactly how the commission intended, or there was a change in a rule, would the staff continue to apply it the same way it had previously, or would it make the change and update immediately and start applying it to everybody henceforth?
Yes, thank you. If I understand your question, absolutely. Not only is the director's response consistent with any director's response to a ruling of the commission regarding a matter of law and interpretation of the rules, that is the commission's responsibility, and the director would always just simply accept that, I think. And I can't think of a time when the director wouldn't just immediately adopt that and begin implementing the rules the way the commission interpreted. In this instance, we also did our own analysis and said, yeah, in hindsight, our protocol may not have been as well-founded as we had thought it was to begin with. And we fully agree with the commission's rule interpretation.
Thank you.
All right, I believe commissioners are done with questions. Mr. Boudreau, you have an opportunity for redirect.
Staff has no questions on redirect for Mr. Cuthbertson.
Okay. Mr. Jacobs, you have your hand up.
Yes, I was hoping to have an opportunity to recross following commissioner questions.
Ever so slightly, please.
Yes, thank you. Mr. Cuthbertson, just a couple of questions. I believe you mentioned in your response to questions that you made a distinction, or staff had made a distinction between Forms 27 associated with P&A work as not being of significant concern. Do you recall that?
Something like that.
And
trust you on your wording.
I'm sorry, I didn't mean to.
I'll trust you on your wording. I don't recall exactly what I said.
I do recall hearing that, hence my question. Are you aware and would you agree that Mr. Duranlo and his staff have included P&A Forms 27 in the estimate of remediation expense in staff's Exhibit 10?
I believe that's correct.
Okay, that would seem to be inconsistent treatment, but I'll move on. Last quick question. The mention earlier of the Wepking Fullerton Energy operator financial assurance plan, that's operator 96340. Were you aware that they had a recent spill in June of this year and did not note the existence of that spill in their staff's Exhibit 8, the Form 3 and notes from the operator submitted on August 18, 2023? So how could staff have considered the significance of that spill or the need for remediation associated with that recent spill?
I'm sorry, I don't remember those details. I would have to look into that.
Okay. No further questions, Mr. Chairman. Thank you.
Mr. Boudreau, any redirect?
No, Mr. Chair, I believe that's all for Mr. Cuthbertson.
Okay, then we'll let you move on to your next witness.
Thank you. I'd like to call Environmental Manager Greg Duranlo, who I believe has already been sworn in. And if I can figure out how, I'm going to share my screen. Okay. Good morning, Mr. Duranlo.
Good morning.
How are you?
I'm well, thank you.
Will you please state your name?
My name is Greg Duranlo.
And what is your title?
I'm the Environmental Unit Manager at ECMC
And how long have you been the Environmental Unit Manager at ECMC?
since 2014.
And in preparation for today's hearing, did you review any of the filings made by any of the other parties?
I did review KPK's Exhibit S, where they described their calculations for known remediation issues, and reviewed KPK's response to staff's supplemental pre-hearing statement, as well as some additional exhibits here and there in brief.
And were you and your staff charged with calculating the costs for KPK's known remediation issues?
Yes, we were.
How many members of your staff worked on that project?
Including myself, there were 6. So a manager, 2 supervisors, and 3 staff members.
And how long did that take?
It took a lot of hours. I worked on it, on parts of the Exhibit 10 spreadsheet for, numerous hours over a few days. Our reclamation supervisor worked on it for hours over 2 days. Our DJ Basin environmental supervisor worked on it for numerous hours. And then we had 3 staff members working on it off and on over 2 weeks. They were reviewing sites, developing costs and assumptions, tuning and double checking the numbers that were in there, testing our assumptions, doing research on comparable sites. All told, I would estimate we were in for 120 to 140 staff hours.
Okay. And after all of those hours put in, what were the total costs that staff calculated for KPK's known remediation issues?
Staff calculated $24,344,402.
And based on your review of KPK's response and Exhibit S, what did KPK calculate as their total cost?
Just under $2.9 million.
Can you offer an explanation for the difference between KPK's number and what staff calculated?
It really comes down to me for a difference in approach. Obviously, the numbers are an order of magnitude different from one another. And by my review, some of those differences come from omissions by KPK, including the omission of necessary reclamation costs that will likely be discussed at length, the omission of numerous sites that are not yet subject to an approved Form 27, as well as the omission of work that needs to be done on existing remediation projects. Some differences are from staff's use of standardized and accepted cost as the basis for our estimates. And there are other differences like soil boring costs that I'll discuss later, where KPK's numbers just don't make sense. Our staff developed thorough cost estimates, and we believe these cost estimates sufficiently protect the state should the state become burdened with the completion of cleanup at these sites. But staff believes strongly that these are reasonable estimates, and we believe that they're likely on the low end of what projects could actually cost.
Okay. And how did you and your team approach this task?
So we look to each remediation issue individually. We evaluated each concern individually, and then we developed the cost necessary to complete site investigation, to bring the site into compliance with Table 915-1, and to complete final reclamation of the project area. Staff approached this by breaking down the project costs into categories. The categories are shown on this pie chart, and they're also represented in the column section headers to Exhibit 10.
And what were the categories that staff identified?
I'll talk about them in brief here, and then we'll talk about them in much more detail further on in my testimony. But we'll start on the right side of the pie chart there with excavation and backfill. And staff assumed this to be the primary method for mass contaminant removal at sites, and it represents a little over half the staff cost estimate of nearly $13 million. Next, along moving clockwise, soil sampling and analysis. And these costs are necessary to collect samples from open or future excavations for remediation confirmation. And they're also collection of soil samples from soil borings as necessary for assessing background concentrations for inorganics analysis. And we've included $1.35 million in our estimates for that task. Next is in situ remediation techniques, where contaminated soil or groundwater is actively remediated in place, but without further excavation. And staff has included a little over $3 million for conducting in situ remediation at site where it appears to be technically feasible, or where there are constraints to excavation, or where KPK has already proposed consideration of in situ techniques. I'm going to skip facility decommissioning for now. And so the next category is groundwater monitoring and remediation. Shallow groundwater is known to be present at many of the remediation projects. And so where the pathway to groundwater is known or suspected to be complete, we've included $2.7 million of groundwater sampling and monitoring, including the installation of monitoring wells where necessary. Next is reclamation, where we calculated $2.5 million of necessary and appropriate costs to bring the remediation sites into full compliance with the reclamation requirements of the 1000 series rules. And these are where the remediation site is not co-located with oil and gas locations already subject to the KPK financial assurance plan already discussed. Last is report preparation, where we've included $1.3 million of report preparation costs as necessary to establish an approved site investigation and remediation work plan where necessary, provide periodic reporting on a quarterly basis as required by rule, and request final closure of each of the known remediation issues. And then I skipped over the facility decommissioning because separately we've just included sort of flat rate unit cost estimates for remediation projects opened by a Form 27 initial related only to facility closure. And I will talk about those all in detail.
Okay, thank you. How many sites did staff identify as requiring remediation for KPK?
146. We performed this cost analysis for remediation costs for all current and unresolved KPK spills as reported on Form 19s, and remediation projects, open remediation projects as approved on a Form 27. And those projects, we kept it up to date up until September 29th, 2023.
So you included sites for which KPK does not have an approved Form 27 remediation work plan?
That is correct. Staff determined that it was not necessary or reasonable to wait until a Form 27 was in place and approved to consider a project a known remediation issue. And one of the reasons that we were led to that was the definition of remediation, which is shown on this slide. It's the process of reducing the concentration of contaminants in soil or groundwater to the extent necessary to comply with the concentration levels, the cleanup standards of Table 915-1. And this is not, we did not conduct an annual review of individual projects. Here we were looking at all known remediation issues.
Thank you. How did you perform the cost analysis for all of these sites?
So I mentioned, our staff did a ton of work on this, and I'm greatly appreciative of the work that they did. They dove into available data that's available in ECMC files. They used current 2023 aerial imagery in Google Earth. We reviewed field inspection reports and inspector notes on those reports. We looked at Form 19s, Form 27s, and the attachments for those projects. And through all that, we recognized that there are still data gaps because 105 remediation projects are not in compliance for quarterly reporting, and 29 spills are open past 90 days. We had to make assumptions to fill those gaps. And those included assumptions, surrounding the undefined extent of impacts to soil and groundwater, defining the horizontal and lateral or vertical extent of contamination, the scope and scale of remediation projects, and the methods for remediation. We've listed all those assumptions in our Exhibit 10. And based on the assumptions that we've made, we feel that this estimate is a reasonable but low estimate on what projects could actually cost. And obviously, any estimates that we made here will be expected to change as data comes in and as projects progress or move, towards closure.
And were there any factors for which staff did not calculate remediation costs?
Yeah, there were numerous site-specific unique factors that were not factored into our cost estimates. Some of these are listed on the screen here, and you can imagine that dealing with any one of those issues on a given site would significantly increase the project costs, whether that's engineering the excavation due to size or stability of slopes, or remediation such as salt kills that rapidly ramp up the costs.
Okay. And how did you calculate the cost for those factors which staff did analyze?
The list of costs used for each remedial activity it is included in Staff Exhibit 10 and spelled out in the spreadsheet attachments. Staff relied on several sources to establish our unit costs. So for current projects, our cost estimates are based on the Colorado Department of Labor and Employment, Division of Oil and Public Safety reasonable cost guideline rates. And those rates apply to hydrocarbon remediation sites. Our laboratory analytical costs were taken directly from ECMC contracts with approved laboratories, and our reclamation costs came from estimates and real costs from third-party contractors who've done work for us in the past, including through the Orphan Well program.
Okay. And you testified that you've read KPK's response to staff supplemental pre-hearing statement, correct?
That's correct, I did.
In their response, KPK asserts, quote, staff's reliance on the Colorado Division of Oil and Public Safety reasonable cost guideline is inappropriate, end quote. Do you agree with that?
I don't. Without conducting, and obtaining site-specific cost estimates to do the work, utilizing well-established costs is the best method to ensure standardization across project sites and across operators throughout the sites. The reasonable cost guidelines, or RCGs, are a set of established rates for reimbursement by the state for work performed at hydrocarbon contaminated sites. The cost of the work, it's not substantially different on a unit cost basis, whether the hydrocarbons are refined products at a gas station or crude oil or condensate at an upstream location. The primary differences are in the approach to the project due to the site constraints and limitations found at gas stations, the likelihood of a subsurface source at gas stations, and the general accessibility at upstream oil and gas operations. So the reasonable cost guideline tables that we utilized, they're reviewed and revised periodically, and they take into consideration feedback from contractors performing work under the leaking underground storage tank program at the state. The rates are publicly available and well vetted, and we do believe that they are, as the title implies, reasonable. And just to kind of put a little finer point on the differences, between a gas station type site and an upstream site, the site constraints of working at a gas station do not impact the rates to perform the work, but they do impact the feasibility of performing certain work. So, for example, soil borings, which are performed at gas station sites and at upstream sites for this, they're performed for the same mobilization rates. The same hourly or daily work rates would apply to that work. One difference might be that at a gas station, concrete coring costs are necessary to cut through the concrete before you do the soil boring. But those costs are not included in our estimates because they're a separate line item in the reasonable cost guideline tables. So we were able to tailor the use of the tables to the work that is applicable at these sites. And, you know, similarly, and I've testified about this in the past, delineation of impacts by soil boring and in situ remediation are much more common at gas station sites due to the typical surface use constraints limiting initial excavation operations. And while excavation as the primary means of delineation and remediation is more common at upstream sites, the rates for mobilization, excavation and loading, and trucking don't change. Those rates are fixed by the cost of equipment, fuel, labor, and maintenance. So, and Mr. Cuthbertson, acknowledged this when staff was laying out our processes for conducting the annual reviews under Rule 703B, we found it necessary, reasonable, and appropriate to use these standardized costs across the state. And so therefore we used them in this analysis as well.
Thank you for that explanation. I believe earlier you testified that staff's remediation cost estimates are broken down into categories, and for each category, staff used methodologies and assumptions to arrive at a reasonable remediation cost. Does that sound correct?
That's correct. That's what we did.
So I'd like to go through each of the categories and have you explain to the commission the methods and assumption that staff used to calculate the costs. So let's start with excavation and backfill, which I believe you said is typically the largest category. What were your methods and assumptions in calculating costs associated with excavation and backfill?
So as I said, staff developed our cost estimates using the principle that the most frequent method for contaminant mass removal will be excavation. For many sites, excavation is already underway. Our estimates account for existing open excavations, and we used a variety of data sources to obtain the excavation dimensions, including field inspections, data on Forms 19 and 27, and 2023 Google Earth imagery. Our costs include excavation, transportation, and disposal, as well as import and placement of backfill material. Where necessary, due to known or anticipated shallow groundwater, we've included costs for dewatering.
And can you talk about the assumptions staff made regarding excavation?
We made some significant but reasonable assumptions while considering the project needs. First, we had to make assumptions regarding excavation size. For sites with no prior excavation or soil boring data to guide us, we assumed an excavation size of 50 by 50 by 10, which equates to 925 cubic yards. For sites with open excavations, but no clean confirmation samples on record, we assumed that sidewalls would have to be pushed out 5 feet and excavations deepened by 2 feet. And for sites that had complete or partial delineation through soil borings, we used those data to help develop our excavation sizes.
Is there any other relevant information?
Yes, so a couple points regarding KPK's pre-hearing response document. KPK asserts in that document that their typical excavation size is 20 by 20 by 10, which equates to 150 cubic yards. That's not correct, and it's not supported by the data that staff reviewed. The measurements that staff made of 57 existing, not expanded excavation sizes come up with an average of 77 by 34 by 9 feet deep, which yields an excavation volume of 872 cubic yards. By KPK's own backfill estimates, as submitted on Exhibit S, their average excavation size is 1,150 cubic yards. So their assertion that their typical site has a small excavation is baseless. Second, KPK stated that staff assumed an additional 10 feet of horizontal excavation and 2 feet of vertical for any of KPK's sites exceeding 915.1 values for any parameter. And that's not true. We assumed 5 feet horizontal expansion where confirmation samples had not cleared table 915.1. And granted, this could result in a 10-foot expansion, 5 feet on both sides of an excavation. but we only calculated costs where confirmation samples did not clear. But we also did conduct an evaluation of sites where only inorganic parameters were present in excess of table 915.1. And if we determined through that analysis that it was likely that a background evaluation would clear the excavation, we did not include additional excavation.
Okay, so that's excavation size. Did you make any assumptions about excavation rates?
We did need to make some assumptions about excavation rates, but it really only affects the dewatering costs. And our assumption was an excavation rate of 200 cubic yards per day or 1,000 cubic yards per week.
Okay, but KPK assumed 1,000 cubic yards per day. Why didn't ECMC accept that excavation rate?
Because that's an extremely high rate of production that could really only be borne out in ideal conditions. It's not reflected in our experience with reality with this or other operators. I would not consider that an industry standard rate for a typical upstream remediation excavation site. Staff reviewed, part of our analysis was, we looked at that number and we reviewed the waste manifests from 6 sites. And on average, KPK removed 8 truckloads per day with a maximum of 30 when a contractor was used. Although many of the truckloads were listed on the waste manifests at 10 or 12 yards, staff assumed a more typical volume of 18 cubic yards per truckload. And even with that, per truck estimate, KPK only would have averaged 150 cubic yards per day. And on one day only, when working with a dirt moving contractor, they removed over 500 yards. We also found numerous records of one truckload being removed in one day during the active excavation period on sites.
Okay. I believe you also mentioned dewatering. Can you tell us about that?
Yeah, both staff and KPK acknowledged that numerous excavations would have to be dewatered during the course of the remediation. And staff identified 35 sites where dewatering would be necessary based on depth to groundwater, compared to KPK's estimate of 25 sites. To calculate costs for that, staff figured a weekly rate for dewatering costs, which included frac tank, trash pump rental, trucking, and disposal of up to 500 barrels per day. And we then factored that cost with the excavation production rate I just described, 200 cubic yards per day, and then determined the dewatering cost for the project.
So based on staff's review of all these excavation and backfill issues that you just discussed, what are the total costs that you and your staff calculated for excavation and backfill of KPK's known remediation issues?
The total is just under $13 million.
And is this the biggest category of cost that staff calculated for KPK's known remediation issues?
Yes, as shown on the pie chart earlier. And, note that we've got that broken down here by different tasks, where there's $2 million worth of actual excavation, $5.5 million of disposal, $700,000 in dewatering, and $4.5 million of backfill, import, and placement.
Thank you. So I believe the next category is soil sampling and analysis. What were your methods and assumptions in calculating those costs?
Sure. So as far as our methods goes, staff calculated the total number of confirmation samples required for a site using the size of the excavation and then relying on the guidance of Table 1 from the ECMC guidance document for Rule 915E2. We included background samples where appropriate based on our review of each file, and we typically assumed 4 background soil borings would be installed for each excavation.
Okay, so that's your methodology for confirmation samples. Did you need to make any assumptions regarding confirmation sampling?
Yes, we did. So if adequate confirmation samples have been submitted and show all or part of excavations are below Table 915-1, then those areas of the excavation would not need to be resampled. So we relied on the data that we had. If additional sampling for background determination was necessary, we included costs for soil borings and analysis. And again, we assumed there would be 4 borings per excavation if it was necessary. If there were already 3 borings, we probably only assumed 1. And our estimates account for a full table 915-1 analysis for all samples collected. We use vendor rates from contracted accredited labs that the state uses on a regular basis. And staff assumed that only 1 round of resampling would be required for projects requiring in situ remediation techniques. In other words, we assumed that the in situ remediation would work. Other assumptions we made, staff didn't include labor required for sampling in its estimation of soil analysis costs, because in all sampling activity, staff presence on site would already be required, such as for excavation or soil boring oversight.
Okay, and you mentioned that you included background samples where appropriate. I'd like to discuss that a little further. See, KPK asserts that ECMC is inconsistent in its administration of Table 915-1 with respect to background determinations. Do you agree with that?
No, I would argue that staff appropriately applies footnotes 1 and footnote 11 to Table 915-1 based on our site-specific analyses.
But KPK states that guidance on this was, quote, promised well over a year ago. Is that accurate?
They do state that in their pre-hearing statement, or I guess the response to staff's pre-hearing statement. And staff did consider development of such a guidance, and we devoted resources to that task. We reviewed EPA's 85-page guidance document on the same topic. And what staff determined was that there is no one-size-fits-all solution that's appropriate for this. A site-specific background determination is key to ensuring that staff are consistent when reviewing the documentation that's submitted by operators. And it's up to operators to demonstrate their compliance with Table 915-1.
And how have you developed that consistency?
I've worked with my supervisors and their staff to ensure that we are consistently reviewing the aspects of the site that affect the validity of a background determination. And I've directed staff to work closely with operators on a site-specific basis.
What aspects are those?
We really review all aspects of the site that could affect that background determination. So we look at soil type, sample depth, land use, lithology, sample location, sample numbers. We look for anomalous samples, duplicative samples, timing of samples, etc. So, all of that to say, it's up to the operator to propose a sound background determination. And in that process, our staff may find that one background sample is sufficient in one location, and numerous samples at numerous depths are required for a different location. So it really is a site-specific analysis that has to be conducted.
Okay. And how have you addressed background sampling in your cost estimates for KPK's remediation issues?
So in remediations where we determined that additional background samples would be necessary, we assumed 4 boreholes would be necessary around, for example, an open excavation, and soil samples would be collected every 5 feet to the assumed excavation depth. We found this appropriate to capture different soil horizons often seen on location. And for example, in the walls of this excavation shown here, you can see on the far wall under the pipe that there are significant visual changes in the lithology. Exactly where you're highlighting a horizontal color and texture break, which indicates non-homogeneous conditions in the shallow soils.
And how many background samples did ECMC assume?
So based on the known and assumed excavation depths, the average number of background samples collected per boring in our cost estimates is 2.
Is that the same or different from KPK's estimate?
KPK assumed 3 background samples would be collected per boring.
Okay, so staff is actually assuming 1 fewer background sample per boring, correct?
That is correct.
Can you provide us with an example of a background investigation where this consideration might be a little more complex?
Sure. So while recently reviewing a site, I noted the data that's shown here on this table, and it really stood out to me. If you look at the column on the right, you can see that there's a significant difference between the calcium concentrations at the two depth intervals listed in the column on the left. It's 2 orders of magnitude difference, in fact. And this indicates a significant lithologic difference between the shallower and deeper samples that is consistent across all background sample locations for this project. So that tells me that it may not be appropriate to apply background concentrations from the shallow depth confirmation samples collected at the deeper depth, or vice versa. Or it might even be inappropriate to average those samples across the depth. So, like the visual observations noted in the previous site, these are the types of considerations that operators should be making when conducting their site-specific background determinations.
Thank you for that explanation. Can you talk a bit about the cost for soil borings needed to complete site investigation and to conduct background sampling?
Yes. So ECMC estimated a total of 70 sites that require additional site investigation or background investigation through soil borings. We used the reasonable cost guidelines to develop a reasonable cost to drill a 2-inch borehole to 25 feet, and that cost was $837.50. And then looking at those 7 sites, we estimated 374 additional soil borings would be necessary to complete delineation or evaluate background at those sites.
How did that differ from KPK's estimates?
KPK estimated a total of 92 sites that required additional site investigation or background investigation through soil borings. But KPK estimated a cost of $200 per soil boring. And it's not clear how that per boring rate was applied. None of the costs listed for soil borings on KPK's Exhibit S is a multiple of 200. So 26 sites on KPK's sheet had less than $200 estimated for additional site assessment boring costs that need to be completed on the location. So costs adding up to not even one complete soil boring. In reviewing Exhibit S, staff found the minimum amount dedicated to installing soil borings was $45, or about a quarter of a boring at one location. We also found the maximum amount for soil borings on Exhibit S was $855. That was at 3 locations. And each of those 3 locations required 19 additional borings according to KPK's own estimates. And so, 19 borings, I think, would be $3,800. And yet they claim that those borings can be installed for $855.
Okay. So based on staff's methods and assumptions associated with soil sampling and analysis, what did staff calculate as the total cost for KPK's soil sampling and analysis?
$1.35 million, $1,348,391.
And how much of that was for soil borings?
The soil borings themselves totaled 316,000, and the sampling and analysis totaled just over 1 million, which was, as I mentioned earlier, just all analytical costs.
Okay. In their response to staff's pre-hearing statement, KPK noted that ECMC recently approved closure of the SAC 811 request for no further action. Are you familiar with that site?
I am, to some degree.
Can you give us some details about whether it was closed out as no further action?
Yes. Staff, it was closed out for no further action, and I believe that to be an error. On Friday, October 10th, Friday, October 6th, staff conducted a routine review of the inventory of KPK remediation projects, and we noted that the SAC 811 had been closed on September 29th. The DJ Basin Environmental Supervisor reviewed the data and found that closure did not appear to be supported by the records on file. ECMC received KPK's response document on October 11th, and we found the reference to the SAC 811 closure. Therefore, the supervisor and I discussed the project and tried to determine what a path forward would be, including discussing rescinding the closure as had been done in similar erroneous circumstances in the past.
But are there remaining remediation issues at the SAC 811?
Yes, there are. There are boron exceedances along the flow line that are not addressed by the documentation provided. There are the background. So first, footnote 1 to table 915-1, as I mentioned earlier, allows the director to consider background concentrations for boron. And in this case, the background concentration, the highest boron concentration was 2.11 milligrams per liter, and yet 2 samples along the flow line path exceeded that amount.
Okay. Sorry, go on.
Yeah, so the other thing to note is that per footnote 3 of table 915-1, with prior approval from the director, the concentration for boron may be modified based on land use, depth, or characteristics of the vegetative community. And no prior approval was given to establish a modified cleanup concentration for boron.
Were there any other issues besides boron at the SAC 811?
Unfortunately, yes. Would you like me to go into details?
I'm not sure that's necessary, but all the issues should have been thoroughly addressed by KPK prior to approval of the no further action. Is that right?
Yes, they should have.
Mr. Chairman, I have to object to this line of testimony regarding the SAC 811, primarily on the issue of unfair surprise. This is not addressed anywhere in the staff's presentation. You'll note there's no slide on this. We didn't get anything with last night's filing of presentations from opposing counsel. This is an ambush on an NFA location. And as you can tell, they understood from our pre-hearing filings that we did draw a distinction between SAC 811, other SAC sites, other sites with inorganics background issues. And to get this thrown at us without prior notice, with no discovery afforded in this proceeding, is prejudicial and objectionable.
May I be heard, Mr. Chair?
Yeah, Mr. Boudreau.
I have a hard time imagining how it's an ambush, considering it was in KPK's filing. We are attempting to clear up a discrepancy about the SAC 811 so that the commission can understand that an administrative mistake was made regarding that site, and we'd like to address it here so that the commission can have a full understanding of the situation.
If I may
Thank you. Note the objection will continue to allow the line of questioning, and you will obviously have an opportunity for cross, Mr. Jacobs.
I would request time to alter our cross and prepare our cross and even our rebuttal testimony, which relied in part on that prior determination by staff, of which we've learned about 2 hours into the hearing.
We can figure out an accommodation there. Thank you, Mr. Jacobs. Go ahead, Mr. Boudreau.
Thank you. Before we move on, I was wondering if we can get a time check.
Mr. Thomas.
Hello. Yes, you've used about 38 minutes and 36 seconds during your presentation in chief. I can get you a real number into the chat in a minute.
Thank you. First of all, thank you, Mr. Chair. Mr. Duranlo, I want to get back to wrapping up the SAC 811 discussion. My last question here is, can you reopen this remediation if it's necessary?
Yes, the no further action does include a standard condition of approval that allows the director to require additional investigation or remediation. And that's also afforded in our 900 series rules.
Thank you. I'd like to move on to the next category of remediation cost, in situ remediation techniques. What were your methods and assumptions for in situ remediation techniques?
So we determined in situ remediation would be appropriate for remediation of organic impacts at several projects based on our experience and the evaluation of the sites. We limited our evaluation to the three most commonly used active in situ methods as described on this slide. So air sparge soil vapor extraction, enhanced fluid recovery, and chemical oxidation injections. In situ remediation was identified as the appropriate method at projects sites where in situ remediation is already ongoing, has been requested by KPK or approved by ECMC for the site, or where technical limitations are known on the site, such as active pipelines or flow lines in the open excavation, or where the excavation has been backfilled, but organic impacts remain in place in the soil or groundwater.
Can you tell us about your assumptions regarding in situ remediation techniques?
We assumed again that removal of impacted soil by excavation would be the standard remediation method unless it was impractical. And based on that, we assumed one or more in situ remediation techniques would be required on 13 projects. So that included 9 air sparge SVE locations, 2 EFR location enhanced fluid recovery, and 7 chemox locations. You'll notice that adds up to more than 13, and that's because at some sites, more than one in situ remediation technique would be used. We also made assumptions for the time duration or level of efforts and chemical oxidation amounts that would be needed based on maximum efficiency of the remedial technology. And for the sake of groundwater monitoring later, we assumed that the chosen technologies work.
And what did staff calculate as KPK's in situ remediation total?
Just over $3 million.
Thank you. Let's move on to the next category. What were your methods for calculating groundwater monitoring and remediation?
So before I dive into this completely, I want to acknowledge that groundwater remediation and monitoring is challenging, and there's kind of a lot to cover on this and some subtle nuances to how our calculations were made. Shallow groundwater, as I stated earlier, is common in many of the areas where these remediation issues exist. We use the data available to us to determine whether groundwater was likely to be impacted or the pathway to groundwater is complete. In most cases, depth of groundwater is known, but staff also use data from nearby remediation projects and from DWR, Division of Water Resources, well permits. And where shallow groundwater is complete or the pathway to groundwater is, where shallow groundwater is present or the pathway to groundwater is complete, 5 monitoring wells must be installed to establish points of compliance around the source. And a point of compliance is a monitoring well that is clean outside of a contaminated area. Staff estimated that when the duration of monitoring events, based on reported analytical data where it's possible, based on site observations from open excavations, and based on operator reports. And then our groundwater monitoring costs were developed to include mobilization to the site, labor to collect the samples, field equipment and supplies to collect field parameters such as depth to water, pH, dissolved oxygen, and other aquifer stabilization characteristics, and then also includes analytical costs.
Can you tell us about the assumptions you made for monitoring well counts?
Sure. So I mentioned points of compliance. And so where there are monitoring wells already installed, but there is not a point of compliance, in other words, the farthest out well it is contaminated, we assumed that one additional well would be necessary to obtain a point of compliance in each direction that we don't have a step out or that we don't have a point of compliance. We would need to step out it in one direction. And then where shallow groundwater is present and no monitoring wells have been installed, we included the installation of at least one source well and at least one well in each direction for points of compliance. So sort of the minimum expectation would be 5. If no excavation or site investigation has been done on the location and staff anticipates the depth to groundwater to be less than 20 feet, then we assume the pathway to groundwater is complete and 5 monitoring wells would be required on those sites as well.
How did you calculate the number of sampling events needed to achieve compliance?
Sure. So this definitely required some assumptions on staff's part. And there's sort of 3 scenarios where monitoring wells have been installed at the site, and that we'll need to consider how many rounds of sampling will be necessary. So the 3 scenarios are where free product is present, where free product is not present, but the data show exceedances of table 915-1, and where monitoring wells have been installed and there are no exceedances. So in the first case, we assume the longest time to closure of 7 years, which equates to 28 quarterly groundwater monitoring events. The second case, where there is contamination but no free product, we assumed 3 to 5 years, depending on the level of concentrations of contaminants of concern. And then lastly, those sites with no impacts still require 4 quarters of monitoring in order to demonstrate compliance with table 915-1. And that's just a standard provision for closure. Once you get past the last contaminated sample at a project, you still need to demonstrate over the next 4 quarters that you don't get any rebound.
Okay. How about for projects where there are no monitoring wells installed?
So projects where no monitoring wells have been installed, or monitoring wells have been installed and we don't have analytical data, we've made similar sort of buckets of assumptions. If free product's been observed on groundwater, such as in an open excavation, then we assumed 5 years to achieve compliance, because we also assumed that that free product would have been removed during, from the excavation, such as by a vac truck during that excavation process. If groundwater samples were collected from the excavation and show exceedances of table 915-1, then we assume 2 to 5 years of groundwater monitoring based on the concentrations of contaminants in the groundwater. And so we would vary our rates depending on the severity of the impacts, or vary our lengths of time. And then lastly, if groundwater has been observed in contact with impacted soil and we have no groundwater samples and we have no data for the water, then we just assumed 3 years to achieve compliance. So that would be 2 years of monitored natural attenuation and 1 year of post remediation monitoring. And then lastly, for projects where no open excavation is present, and impacts to the groundwater are unknown but anticipated, and if staff concluded that the pathway to groundwater would be complete, then we assumed 3 years of monitoring to achieve compliance. So similar to that last scenario with an open excavation.
How did staff and KPK differ in their assessments of groundwater monitoring and remediation?
So first, we included groundwater monitoring for 60 sites. KPK included costs for 45 sites. The biggest discrepancies between staff's estimate and KPK's estimate are in the assumed length of time that it will take to achieve closure. And that's what's shown on the chart on the right. ECMC assumed 1 year would be the minimum, and 7 years would be the maximum to achieve closure on projects where we assumed groundwater monitoring would be required. Based on the methods and assumptions I just described, and based on our review of available project data, the most common estimate that we came up with was 3 years or 12 rounds of monitoring. However, KPK's analysis assumed only 4 quarterly groundwater monitoring events to get to closure on over 35 sites. This includes sites where groundwater is known to be highly impacted, or where free product has been observed on groundwater in the monitoring wells. It's simply not reasonable to assume that monitored natural attenuation of impacted groundwater can occur over 4 quarters, especially when 4 quarters is required after the last contaminated sample is documented. Additionally, KPK did not include groundwater monitoring in Exhibit S at several sites where groundwater was observed in the excavation, and therefore, consistent with our application of the 900 series rules, ECMC will require groundwater monitoring prior to closure. KPK also only identified a single site as requiring more than 8/4 of groundwater monitoring. It's an unreasonable assumption that is just not typical with groundwater monitoring remediation projects throughout the state.
Okay, and this chart that we're looking at on the screen right now, the numbers on the x-axis, that's the number of quarterly monitoring events, correct?
That's correct. So the first, the farthest left shows the number of the farthest left pair of columns shows KPK's estimate of how many sites would require only 4/4 of monitoring compared to ECMC. So they've got over 35, we've got less than 5. We're fairly close on how many sites would require 2 years of monitoring. But KPK only estimated one site or counted one site that would require more than that. So staff estimated, 27 or 28 sites that would require 12 quarters of monitoring and so on and so forth out to the 7 years.
Okay. So based on those assumptions regarding groundwater monitoring and remediation, what did staff calculate as KPK's total for that category?
The total cost for monitoring well installation and groundwater sampling analysis is $2,673,183.
Thank you. Staff also included reclamation costs as a category of remediation cost. Is that correct?
We did.
Can you please explain your methods and assumptions for calculating those reclamation costs associated with remediation?
Yeah, so first we had to estimate the areas that require reclamation. And so we looked at the project sites or the remediation areas on typically 2023 Google Earth imagery, and we calculated the acreage of all disturbed areas, including any access roads created solely for remediation. The reclamation costs include equipment mobilization, topsoil, site prep, seeding, and also include 2 years of stormwater management and weed control post, active reclamation to ensure reclamation success. For the purposes of this calculation, this is a per acre reclamation cost that we developed, and then we ascribed it to each location based on the project size. And as far as assumptions go, we assumed that after the 2 years of monitoring, we would achieve full final reclamation of the site. We did not calculate reclamation costs or acreages for remediations occurring on active oil and gas locations where they would be subject to other reclamation financial assurance. And I will also note that staff included costs to import topsoil, since we've rarely observed KPK salvaging and protecting 6 inches of topsoil when excavating as required by Rule 1102B. Excuse me, 1002B. My notes are wrong.
So you said that staff did not calculate reclamation acreage and costs for remediations occurring on active oil and gas locations. Is that right?
That is correct.
So can you?
Yeah, sorry, go ahead.
Can you explain what the reclamation costs you just went through actually do represent then?
Yeah, the costs that I went through are only the costs for reclaiming remediation projects where the project footprint doesn't overlap a permitted oil and gas location that's subject to other forms of reclamation financial assurance.
So the reclamation costs in Staff's Exhibit 10 only represent what it will cost to reclaim contaminated lands off of permitted locations. Is that accurate?
Exactly. That includes off-location flow line spills and releases that are frequently found during flow line decommissioning. And so we intended to not overlap with other financial assurance instruments.
Did you review the reclamation costs associated with active oil and gas locations?
And not for this operator.
So do you have any information about KPK's standard reclamation cost calculations other than those for off-location reclamations?
No.
And what does staff calculate as KPK's reclamation costs for off-location remediations, excuse me?
$2.5 million, a little bit more than that.
Okay. And I believe you said another category was report preparation and submittal. What were your assumptions and methods there?
Yeah, so we assumed that one Form 27 would be submitted to establish an approved site investigation remediation work plan for excavation, backfill, and then monitoring well network approval. And then additional Form 27s would be submitted each for each quarter of monitoring as required by rule. And then a final Form 27 would be submitted to close out a project.
And what did staff calculate as KPK's total for report preparation and submittal?
$1.3 million.
Thank you. I believe staff also calculated costs for what you called facility decommissioning. What were your methods and assumptions regarding facility decommissioning?
So these are for projects, remediation projects created for the decommissioning of a tank battery, a wellhead cut and cap, flow line abandonment, or pit closure. And we took and reviewed Form 27s from this and other operators on previous Form 27s to develop sort of a standard cost for those types of decommissioning. And these data, again, are taken from Form 27s submitted and the financial assurance data field on those Form 27s. So then as far as assumptions that we made in using those numbers, we estimated that the remedial activities would occur once the oil and gas facilities have been removed from the location. So all we kind of included in that was environmental oversight, sampling, and report preparation. And then importantly, we assumed that there are no impacts discovered during the facility decommissioning. And so, we certainly acknowledge that many of these 24 sites that we identified could require additional costs for site investigation and remediation.
Okay. So what did staff calculate as KPK's total for facility decommissioning?
$370,000.
So based on all the methodologies and assumptions you just discussed regarding all of these categories that you worked into the final number, what are the total costs that you and your staff calculated for KPK's known remediation issues?
So our total cost for known remediation issues was $24,344,402.
And what was KPK's calculated remediation costs?
$2.9 million.
Do you see the chart that I have on the screen now?
I do.
Can you explain to us what this chart demonstrates?
Yeah, so this chart compares the remediation cost estimates made by KPK and staff across the different categories that we've discussed. As you can see on the left, there's a significant difference in our excavation and backfill costs. And I believe that I've made clear why staff's costs are reasonable in this area. You can also see that for the other cost categories, the difference is less striking, but still significant, especially in the in-situ remediation and groundwater monitoring and reclamation categories. On the right is the total. And again, this shows an order of magnitude difference between the two estimates.
Remind us again, how many sites did staff identify as having known remediation issues?
146,
And how many did KPK identify?
109.
I put a new chart on the screen. Can you see that?
Yes.
Can you give us an explanation of what we're looking at here?
Sure. So this is a little bit different in that the subtasks that this shows across the x-axis subtasks to the broader categories that we've identified and discussed. But what you see here is that with one exception, ECMC identified more sites requiring remediation than KPK. The exception is the background investigation site. And significantly, staff included all known remediation issues and did not limit ourselves to only projects with an approved Form 27.
Do you have an explanation for why KPK and staff got such different total numbers on remediation costs?
It goes back to what I said at the beginning. It's a different approach, and it's one that does not seek to minimize the significance of environmental issues. We're an order of magnitude different. More sites were identified by staff, and as I mentioned, that's due to KPK omissions of sites that do require site investigation or remediation. I believe that staff applied more reasonable costs per site. The excavation rates and volumes are consistent with what we see on the ground on project sites like these. We used credible sources for unit rates, and we used standardized and accepted costs. Our costs were developed to protect the state, again, should we become burdened with completing these remediations, and our costs are reasonable.
Do you consider KPK's cost reasonable?
No.
Can you give us some examples of why you may consider them unreasonable?
So the first example I would point to is the compliance plan agreement GRIP sites, or Global Remediation Implementation Plan sites, versus what they provided in Exhibit S. According to their testimony earlier this year, KPK reported spending $7.2 million on CPA projects in the 18 months between November of 2021 and February of 2023. In that time, they closed out only one project as a direct result of their remediation efforts. 2 others were closed out on paperwork. During that time, KPK averaged $480,000 per month in remedial costs. So their $2.9 million cost estimate in Exhibit S would cover only 6 months of remediation work at the same dedication of resources. It's unreasonable then to think that KPK can bring over 100 sites to closure for less than half the amount spent during the CPA period.
Can you give us examples of remediations for which staff and KPK got different numbers for locations that KPK did identify?
Yes. So numerous sites where where staff identified that additional excavation would be necessary. We found 85 locations would require additional excavation, and we totaled that additional excavation to be 136,000 cubic yards of petroleum contaminated soil. Conversely, KPK estimates that only 38 sites require additional excavation, and totaled only 7,060 estimated additional yards of petroleum contamination. Again, that's not borne out by our experience on sites, observing excavations progress over time. And so, some site-specific examples, one of which is pulled up here, have discrepancies between, how we approached a project. So this is a project with known impacts in situ, as shown by the samples and the soil boring locations that are circled in red, that KPK did not address in their cost estimates with either in situ remediation or excavation. Staff used the data on this, provided in this project file to estimate a excavation size of 13,000 cubic yards that needs to be removed.
Please go on.
Yeah, sure. So another example, and in this case, KPK assumed an excavation which is much smaller than the extent of known impacts based on the soil borings. So there's a black outline on this screen that shows the extent of proposed excavation, and yet there are soil borings up to the left that are, have exceedances of organics outside of this. So staff estimated, based on those dimensions, that 6,000 cubic yards of soil would need to be removed, and KPK estimated 70, still 2 orders of magnitude.
Okay, so what we're looking at here, the black shape is what KPK proposes to excavate. Is that right?
In their Form 27, yes.
Okay, and the red here indicates that these are sites that need to be included in the excavation. Is that right?
Yes, those are samples which are exceed table 915-1. And I believe, looking at this also, we determined that 70 cubic yards wouldn't even reach the extent of the limits of their excavation as drawn.
Okay. Are there any projects where KPK assumed no or limited excavation when confirmation samples are necessary?
Yeah, so the site that's shown here is an excavation which clearly it's a large excavation. A large volume of soil has been removed. In the center of that excavation, there's visible and documented additional hydrocarbon contamination. And on the base of the far wall of the excavation is also contaminants that remain in situ. And so, for this site, staff estimated that an additional 2,500 cubic yards of material would need to be removed, and KPK estimated that no additional soil would be removed, and they provided no costs for in situ remediation.
Okay, so would you consider KPK's remediation cost calculations to be complete?
No, I believe that KPK did not include necessary and reasonable costs for all known remediation issues.
Were there any other major discrepancies between staff's remediation assessment and KPK's?
So in situ remediation was a place where there was significant discrepancies. Staff assumed in situ remediation would be appropriate at 13 sites. And these are projects where in situ remediation is already ongoing, or has been requested by KPK or approved by ECMC, or where there's technical limitations to excavation, such as pipelines within the open excavation, or where excavation has been backfilled, but organic impacts remain in situ. And KPK's Exhibit S includes only 2 sites with in situ remediation estimates. KPK has proposed in situ remediations via their Form 19 or Form 27 on 9 locations. So in Exhibit S, they didn't even include all 9 locations that they've proposed to the state already that they would use in situ remediation.
Can you give us an example of that?
Sure, the Grant Tank Battery. So this is a site where KPK estimates that the remediation can be completed for $31,000. Yet their estimate did not include any costs for in situ remediation. And that contradicts their recent Form 27 submittals, which proposed pilot tests for both in situ chemical oxidation and in situ air sparge soil vapor extraction. In their Form 27, KPK estimated that the ChemOx pilot test alone would cost $16,000. On the other hand, staff estimated that air sparge, SVE, and ChemOx injections would be pilot tested and implemented as proposed by KPK and would successfully remediate the site in about 5 years. So pilot testing, implementation, operations and maintenance of those systems, and monitoring costs over 5 years, plus post-remediation monitoring, add up to over $600,000, according to staff's reasonable estimates. And as noted on this slide, the delineation of impacts at this site is not even complete.
Okay, thank you for providing us with that example. We discussed earlier that staff calculated reclamation costs for off-location remediations as opposed to those on location. Has KPK accounted for any reclamation costs in the context of remediation?
No, KPK accounted for zero reclamation at these remediation issue sites, despite land being disturbed outside of permitted oil and gas locations at 102 of 146 sites identified by staff. Again, staff only included reclamation costs if the impacts were not on an active oil and gas location and if the remediation was not for facility closure. So our estimated low cost estimate for these sites is $2.5 million. And this assumes a fairly straightforward, simple reclamation project. I say low, this cost may be low for a number of reasons. Many of the sites have stormwater or weed issues already in place. Salt kills are examples of sites where remediation is more challenging. We did not include costs to develop a detailed reclamation plan for sites where soil suitability for reclamation parameters will be left in place. And then we included an economy of scale, to scale these sites down to, their small project sites, but that doesn't necessarily work when you consider things like costs like mobilization, and monitoring visits. Those sites actually scale up. And then lastly, we assume the same costs would be incurred on a unit cost basis in the Front Range when compared to the Walden assets, and obviously reclamation is more challenging at higher elevations.
Okay. So based on you and your staff's review of KPK's known remediation issues, do you consider about 24 million to be a reasonable estimate for KPK's cost for known remediation?
Yes, I do.
Do you consider KPK's estimate of about 2.9 to be reasonable?
No.
Mr. Duranlo, I want to thank you for making yourself available here today, both to you and your staff for taking the time to do all of these assessments on relatively short notice and for doing what seems like a pretty thorough job. So thank you for appearing today to explain staff's calculations.
You're welcome, and I'd like to just echo your thanks to staff for the hard work that they did on this.
Thank you. Mr. Chair, that's all for direct from staff for Mr. Duranlo.
Okay, thank you very much. Let's take a break. Let's return in 13 minutes at 11:45. Okay, we are back. This is the Colorado Energy and Carbon Management Commission. It is 11:45 on October 24th, docket 230400117. Mr. Boudreau, you just finished a direct examination of Mr. Duranlo. Is that accurate? You're done with direct?
Oh, yes, that's right, Mr. Chair.
Okay. All right, then I think the next step will be redirect on behalf of Mr. Jacobs, on behalf of his client KPK. So we'll just launch into this. Just for everybody's purposes, we just took our first break. That first bit was quite lengthy. We'll probably go, say, an hour or so, or 30 minutes or so, and then take another break for lunch. Mr. Jacobs, I see you have your hand raised. Did you have a procedural question?
I do, Mr. Chairman, and I would request that we take an early lunch break to allow me to further prepare for cross-examination of this witness.
Okay, I'm okay with that. What I was anticipating is you probably got a lengthy cross-examination. I know some of it you wanted some additional time, the SAC 811 issue. I was wondering if you wanted to start and then take a break, but I'm also happy to take lunch break now if my fellow commissioners are okay with that. It's going to be a lengthy day. Commissioner McGowan's already eating lunch. All right, let's take a break now then. Why don't we return at 12:30? That'll give you a 45 minutes or so, Mr. Jacobs.
Thank you, Mr. Chairman. I appreciate it.
All right, we'll return at 12:30. All right, welcome back. This is the Colorado Energy and Carbon Management Commission. It is 12:30 on October 24th, and we're undertaking docket 2304-00117, the KPK Financial Assurance Plan. We just finished our lunch break back here live, and at this time, barring procedural matters, Mr. Jacobs, I believe you are up for cross-examination of the witness, Greg Duranlo.
Thank you, Mr. Chairman. Mr. Duranlo, thank you again for your availability for some questions. So, would you agree that this is a unique exercise, preparation of such a large remediation expense estimate in the experience of you and your staff?
This is the first time in my recollection that we have undertaken such an effort.
Thank you. And I believe you said approximately 120 person hours of time were spent in the preparation of Exhibit 10.
I estimate 120 to 140.
Thank you for that clarification. And you don't have a significant experience in preparing remediation cost estimates like this, since you've never done it before, do you?
I've prepared many remediation cost estimates in the course of my career.
But for a portfolio of so many sites under these circumstances, I believe that's what makes this unique, correct?
Yeah, this is probably a pretty fast turn on a project, but it's not unlike a due diligence project of which I'm familiar with in my consulting days.
Your COGIS database has mountains of data in it. Would you agree?
It has a lot of data, yes.
Including cost data, does it not?
There is some cost data scattered throughout.
But you chose to use the oil and public safety schedule for costs rather than cost data in your own COGIS database, didn't you?
Yes, we did.
And given the uniqueness of this exercise, isn't it true that you did not prepare such an estimate of remediation expense for any operators whose demonstrated costs and financial assurance plan were approved prior to August 17th, correct?
I was not involved in any such cost estimating.
Nor anyone on your staff?
Not to my direct knowledge, but that's not to say that they weren't.
And you didn't prepare such an estimate of remediation expense for any operators seeking financial assurance plan approval under other options, not option 4, under the 700 series rules, correct?
I want to make sure I get the negative Right, but yes, we did not prepare any other cost estimates to the best of my knowledge.
And you did not attempt to confer with KPK or Mr. Peterson at KPK in the course of preparing Exhibit 10, did you?
I did not.
And to your knowledge, none of your staff did either, correct?
I don't believe, other than reviewing the submittals that were provided to us by KPK.
You did not develop the cost data in the OPS Lust Us cost schedule, did you?
No, I did not.
And it's also accurate that you did not review KPK's rejected forms 27 in the course of preparing Exhibit 10 either, did you?
Rejected or denied?
Either.
Yeah, I don't believe we did. I believe we relied on information that was available through approved Form 19s or 27s. I can confirm with staff whether or not they dug into denied forms or rejected.
Now, for excavation estimation purposes, I believe you referred in your testimony to looking at an average for excavation size across KPK's open remediation locations. Is that correct?
Yes. Open excavations, to clarify.
Sorry, go ahead. Go ahead.
Open excavations that we identified for on staff exhibit 10.
Thank you. I didn't mean to step on your answer. But averages can be skewed by outlier values, can they not?
Certainly.
And KPK has some smaller number of very large excavations where naturally occurring inorganics in soil remain an issue, right?
I will have to take your word for that.
You did not exclude any outlier sites, any largest excavations across KPK's open excavations in your calculation of an average, did you?
No, that's correct. We did a straight line average.
Regarding excavation rates, I believe you referred to a review of manifests in your prior testimony. Do you recall that?
I do.
And is it not correct that manifests reflect transportation rates, not excavation rates?
That is correct.
Regarding in situ remediation, staff has not approved many of KPK's requests to use in situ methods, has it?
I don't know that I can qualify that to staff has not approved many. I don't know how many times other than the I believe 9 that I referenced KPK has requested.
Mr. Peterson can address that later. Thank you. Staff does not direct the method of remediation as a general matter, does it?
We do not.
But you selected specific methods for purposes of estimation in preparing Exhibit 10, correct?
Yes, we did. As I testified, we selected 3 commonly used remedial techniques and techniques that KPK had proposed on various Form 27s as well.
Thank you. You used a slide, and I'll perhaps ask my associate to pull it up in your presentation that identified the Kamenish location. Do you recall that?
Yes, I do. There were several examples that we had included in various slides. So I need to see it specifically if you do want to go down, if you do want to ask me specific questions about it.
Do you recall, and you also indicated that you did a painstaking review of each location, which was the subject of your Exhibit 10 preparation. Is that also correct?
Relying on the work of staff, yes. Yes, I do recall this slide. Thank you.
No problem. Are you aware that the photo in that slide is approximately 2 years old and does not reflect current site conditions?
Yes, I'm aware, and I was made aware by my staff during the break that the black line that I testified to as being the proposed excavation is an actual excavation dimension. So I did get that wrong in terms of what that black line represented.
Thank you for that clarification. Turning to the SAC 811, it's your understanding, and I think you testified that no further action status was approved for that site by Mr. Canfield of your staff in September, correct?
I did testify that that site was closed on September 29th.
Thank you. And I believe you said boron was the parameter of concern causing you to rescind or plan to rescind that NFA determination, correct?
Boron was a contaminant of concern that was not addressed appropriately by the Form 27 requesting closure, but there were other issues as well.
That decision has not been memorialized in writing to KPK, has it?
No, it has not been discussed with my supervisor.
It's only been communicated for the first time to KPK this morning in your testimony, correct?
I believe I testified that the condition of approval on that no further action allows for the director to consider additional investigation at the site or
That's
remediate.
not my question. Shall
I'm
I
sorry?
repeat the question? That was not an answer.
Oh, okay. Yes, please.
That this was only communicated for the first time by your testimony this morning, correct?
I would say the condition of approval communicated that clearly to KPK. That could be
no further
reopened.
action would in fact be withdrawn, or that you have the right to withdraw it?
That additional remediation or investigation could be required.
That's a standard condition of approval in every no further action determination, is it not?
Yes, it is.
And you first communicated your intention to exercise your rights under that condition of approval this morning, never in writing to KPK, correct?
If I communicated it as an intention and a guarantee, then I would say no. But if I did indicate that it's a possibility, then yes, that was my intent to say that my supervisor and I had discussed reopening that project.
And isn't it true that Mr. Canfield has approved other sites for NFA for other operators with similar inorganic issues?
I can't speak to that. Can you provide examples?
Well, that can be determined by a review of NFAs granted in the COGIS database, can't it?
Yes, it could.
But you've not performed such a check, have you?
We did in the course of following up on what we consider mistaken closure of the SAC 811. We did identify that there were a number of sites that were closed a number of Form 27s and Form 19s that were approved in a short period of time with what I would say was an incomplete record of review. And I'm not sure if there was a process error or what led to that, and we are still reviewing it internally.
And you did listen to my opening statement this morning?
Unfortunately, I was distracted.
Okay. Well, let me represent to you that I indicated if all open forms 27 and unapproved forms, approved or unapproved forms 19 sites were added to KPK's estimate, that the total remediation estimate would be $3.9 million. You understand that from the proceedings this morning?
In other words, your estimate for the 146 sites that staff identified would be 3.9 million instead of 2.9 million. Is that what you're saying?
That's correct.
Okay.
And you understand that KPK's adopted scope of remediation estimate was based upon its legal interpretation of the plain language of Rule 702B, correct?
I believe that was stated in KPK's response to staff pre-hearing statement.
And with this commission having taken a different interpretation, even over our objection, that would pull in the other sites, increasing the cost estimate to 3.9 million.
That would increase KPK's cost estimate to 3.9.
That's correct.
Okay. I haven't seen those numbers presented, so
Very good.
I don't really know how to respond.
I have nothing further for this witness on cross-examination. Thank you for your time, Mr. Duranlo.
You're welcome.
Okay, thank you. Mr. Sura or Mr. Lewis Prescott, do either of you have cross-examination?
Nothing from Dacono, thank you.
Yes, I have a few questions.
Go ahead.
So, Mr. Duranlo, good to see you. There are reclamation experts within the ECMC staff, are there not?
Yes, there are.
And who is involved from that reclamation? What reclamation experts were involved in this work in preparation of Exhibit 10?
I worked with our reclamation supervisor to develop those costs.
And the name of the reclamation supervisor?
That's Dr. Denise Arthur.
Was there anybody from the Orphan Well program that was involved in the preparation of Exhibit 10?
I personally talked to 2 individuals within the Orphan Well program.
Were they?
Oh, go ahead.
Yeah, and the names of those folks?
I spoke with Catherine Roy, who is a reclamation specialist in the Southwest, and I spoke with Dave Andrews, who is the reclamation, the Orphan Well program manager, so not a reclamation specialist or expert.
And if we could turn to slide 31, and if you don't have it, I can pull it up and share my own screen. Can you see that?
Yes, I can.
Would you mind reading that assumption that comes under?
I'm going to look at it on a different screen because
Okay,
it's
no,
pretty
that's
small on that one.
Yeah, that's fair. So where first of all, where does this slide come from?
So this slide comes from the assumptions, the cost assumptions on staff exhibit 10.
Correct. And where do these cost assumptions come from?
I'm sorry. Can you rephrase that?
Who created these cost assumptions?
Again, I worked closely with my reclamation supervisor on these with Dr. Arthur.
Okay. And if you can't read it, I can read it. Okay, go ahead.
Would you like me to read it to you?
Please do.
Okay, so this says, it assumes 1 acre recontouring, decompaction, topsoil and stormwater, weed maintenance, and stormwater and weed maintenance for flat, sandy soil with no cut and fill within rangeland. Note, this does not equate for facility abandonment as gravel removal was not included.
And what is the unit rate there? What does that mean, that 45,050?
So it is a $45,050 per individual acre to conduct reclamation according to our estimates for these remediation issues.
And as you say, those assumptions include recontouring and decompaction. Are recontouring and decompaction also required for reclamation of a well site?
Generally, yes.
What about topsoil and stormwater and weed maintenance?
Generally, yes, though topsoil should be, for locations built after, I believe, 1996, topsoil should be salvaged and available on site, so would not be necessarily required for import. Stormwater management and weed control are typically part of ongoing monitoring of reclamation.
Is your understanding that most of the sites, KP Kaufman sites were created previous to 1996?
I really couldn't answer that without looking, pulling a query of the database. It's many of them are, I can say that, but I couldn't say most.
When you have the note here that this does not equate for facility abandonment as gravel removal was not included, that is meant to indicate that it would potentially be more if gravel was on site and you were, say, scraping gravel from an access road or a well pad. Is that correct?
Yes, that would be an additional cost.
So this 45,050 per acre may not be enough if it was an access road or a well pad. Is that correct?
That may be correct.
So did you hear the testimony of Scott Cuthbertson?
Yes, I did.
And when he's talking about, when he said that the cost per location is typical for similarly situated sites is 8,000 to 10,000 per location as approved by the orphan well staff. Do you know what orphan well staff he's referring to?
No, I don't.
If you wouldn't mind, Chair, I'd like to call Scott Cuthbertson. I didn't have an opportunity to request to ask him about this because it happened during the commission's discussions with Mr. Cuthbertson.
Well, let's finish up cross-examination of Mr. Geronimo, then we can take up that matter.
Okay. Thank you. I have no further questions.
So I think the procedure here, Mr. Boudreau, there's likely some commissioner questions. Do you want to do redirect after commissioner questions or redirect now?
Staff is happy to wait until after the commissioners ask their questions.
I think it's more efficient.
Mm-hmm.
Commissioners, questions for the witness who just disappeared? Commissioner Cross?
Thank you, Mr. Chair. And thank you, Mr. Duranlo, for your testimony today. I wanted to go into a couple things, both that were talked about in your testimony, as well as it was referenced back to some of the briefing as well. One of the things that sticks out a lot to me is you indicated that there was 146 sites that you looked at, but KPK did not look at 146. It was 109, is that correct?
I believe that is correct. 109 is what was on Exhibit S.
Okay, and one of the things that was brought up in briefing was the idea that they were not looking at sites that did not have a Form 27 approved. And I want to go into this in a little bit more detail because I believe there's also some discussion of, well, Form 19 isn't talked about in the financial assurance rules, and so that wasn't done. And I want to get an understanding of was the difference between the 109 and the 146. Can that all be attributed to whether a Form 27 has been approved or not?
I believe primarily, yes. There may be one or two or a few outliers that were not included in KPK's Exhibit S, maybe despite having a Form 27. I think there are a couple of examples of sites that we could not find on their Exhibit S that we felt did have approved Form 27s or Form 27s in process or something like that.
Meaning
But
even though there
largely,
was-
that's the case.
Okay, so meaning even if there was ongoing remediation, there was instances where KPK didn't identify those sites as part of their estimates.
That is my understanding, but there's few sites that fit that description.
So mostly it would be in connection with the Form 19 versus the Form 27.
That is my understanding. And there are also sites where a Form 27 initial has been submitted and denied by staff. And those sites we would have included just because because they've submitted a Form 27, that's a known remediation issue to us.
Okay, and I'm going to get back to the Form 19 part of it in a minute, but I just want to make sure that there are no instances of the 146 sites that you talked about that are not pending some kind of action currently, whether it's Form 19, Form 27, meaning it's not something where you said, I think we're probably going to file a notice of alleged violation, or we're going to file something like that. We think that there's an issue here. These are all instances where there is documented known remediation ongoing.
Yes, there are documented known remediation issues on all of the 146 locations. In some cases, it may be down to, the last rounds of monitoring or just reclamation or something like that. But there are known issues at all of the sites that staff identified.
Perfect, thank you. And then going back to the Form 19 issue, and I apologize, I didn't have written down the number slide it was, so maybe Mr. Boudreau could help me with that as well. But in one of the slides, it was also talking about the Form 19 is talking about the spill closure, and it has not been closed yet, and so no Form 27. So could you, for everyone's benefit, kind of go over the differences between the Form 19 and the Form 27 and how each of those applies, especially in a chronological order?
Sure, and I'll try and it does get a little convoluted because there's two paths and they intersect. So the first pathway is a Form 19 is filed for a reportable spill or release when that's discovered under any circumstances. And the Form 19 gets filed, the initial gets filed, the operator collects additional data, files a supplemental, and then there are requirements that they either bring that site to closure, i.e. remediate that site within 90 days, or by day 90, they should have filed a Form 27 initial and they will transfer that site over to a Form 27. There's other necessary required reasons that they would also do that. If there are groundwater impacts or surface water impacts, then those automatically trigger a Form 27. So that's the pathway from a Form 19 to a 27. When that Form 27 is approved, then the operator also files a supplemental Form 19 requesting closure of their Form 19. So the spill file gets closed because the work is being conducted under an approved open remediation project. The other pathway is for facility closure. If an operator is intending to close out tanks, pits, flow lines, cut and cap a well, then they start the process by submitting a Form 27 that says, we're going to close out these facilities and we're going to conduct an investigation in this manner to ensure that there's no residual impacts from our operations. If during the course of that facility closure, they find a reportable spill or release, they're still required to file a Form 27, but in that case, they file a Form 27 initial, follow it up immediately with a Form 27 supplemental that requests closure of the spill because their work is already proceeding under an approved Form 27. And typically at that time, an operator will also file a supplemental Form 27 because now that they've identified contaminants, then the scope of their investigation and remediation project changes. So those are sort of two pathways through which that Form 27, Form 19 process happens. And hopefully that made sense. And if it didn't, please ask clarifying questions.
No, I think that did make sense, and I appreciate it, and I think for everyone's benefit listening in, I think it was important to talk about that again, partly because there was discussion of Form 19s and not Form 27s in the briefing, and so I wanted to make sure that everyone was on the same page with that. So is it safe to say that in many of those, that discrepancy between the 146 and the 109, there's ongoing Form 19s, and it hasn't hit that 90-day period where a Form 27 would be submitted and the Form 19 closure would be done?
Yes, I believe that's the case. There are numerous open spills in that list.
But it is, as we said before, still a known remediation issue.
Yes, the operator is still obligated to remediate the site to the compliance standards of Table 915-1.
And kind of following up along the same line of questioning, I believe you spent some time testifying about the Grant tank battery. And that's one where there is a Form 27 that has been approved and remediation work is occurring with respect to that Form 27. Is that correct?
Yes, that is correct.
But the Grant tank battery is not one of the sites listed as the 109 that KPK had on their known remediation sites.
I think it is. I'm looking at Exhibit S right here, and yes, the Grant tank battery is included. What my testimony was that they did not include in situ costs for in situ remediation, despite the fact that in their approved Form 27, they stated that they would conduct in situ remediation of residual contamination at that site.
Perfect. Thank you for that clarification. And then I want to, during the cross-examination, Mr. Jacobs talked about the, I believe it's pronounced Kamenish site with the flow line. And so again, for everyone's clarity, the picture that you put up is an older picture, but the black outline is accurate to what excavation was done. Is that correct?
I believe that is correct. It was the extent of excavation, and the soil borings outside of that excavation indicated that there was still residual contamination, which is why staff calculated additional excavation costs for that site.
Okay, and so the red dots outside of that black marked box is what you're referring to as additional remediation needing to occur, but that's not something that's marked as either excavation work to be done or in situ work to be done.
That's correct.
Okay. And then I just wanted to make sure, and I think this is my last bit of questioning, but there was a little bit of discussion during the cross-examination about the manifest being the transportation rate. So there was two things discussed. There was the dewatering rate, is that correct? As well as rates for how often the monitoring boring is done with respect to groundwater. Is that correct?
Yes, the excavation rate was discussed primarily because we used it to help calculate the dewatering costs associated with certain sites. And
so
then, yeah,
with respect to the excavation rate, so Mr. Jacobs brought up that the manifest are referring to the transportation out. Given that the fastest it has been transported out has been, I think you said, one instance in which it was more than 500 cubic yards, but usually between 120 and 150, I believe, cubic yards in what they've done, and you estimated up to 200 yards, cubic yards being excavated. Does the actual excavation rate, your estimates on the excavation rate, differ based on the manifest being the transportation out, or do you still kind of stick with that 200 cubic yards?
So I guess for perfect clarity, a waste manifest actually doesn't necessarily represent transportation either. It represents disposal at a landfill. But in terms of the rates that we calculated, our estimation of 200 yards per day as an excavation rate is actually fairly consistent and supported by the reasonable cost guidelines assumption of $16 a yard. An excavator, from talking with an excavation contractor, an excavator and an operator lease out or rent out daily or cost out daily at about $400 an hour. And if you calculate that across, a site, and they move 200 yards, it back calculates pretty close to $16 a yard. So we feel pretty comfortable with the excavation rate of 200 yards per day. I would say from the 6 sites that we reviewed where excavation was done, I would say even 200 yards a day would be on the high side of what they were able to complete, with that 1-day exception where a contractor was employed.
And the importance of that excavation rate, the disposal rate that you're talking about, is that if KPK is indicating that they can get everything excavated and disposed of in 2 days, so that $400 an hour, if it's done on a per day basis, whereas they're saying they might be able to get something done in 2 days, you're actually saying, no, this might take 2 weeks.
That's correct. I mean, and so therefore the truly where it impacted our cost estimate was then we would have to dewater the excavation for a longer period of time before we could get it backfilled. So I don't think I'm not sure the material effect of the rate discrepancy, other than I do believe that the rate that we ascribed was more reasonable than 1,000 yards per day. If you're not talking about transporting the soil off site, then where are you stockpiling the soil? And then you have to bring a loader on site to load trucks. And how many trucks does it take to get that 1,000 yards of soil off site? And does the surface owner object to having 1,000 yards of soil stockpiled? So there's issues such as that. The most efficient way to operate is to direct load the trucks from the excavation. The contractor that I talked to, as soon as I started talking about 1,000 yards a day, he said, yeah, give me, 2 of my good operators, 2 excavators and 20 trucks, and I'll, and $20,000 a day, and I'll get it done. It can be done. It's just not a reasonable estimate for the remediation projects that we see.
And thank you. And then I do have one final question, and sorry for kind of conflating the issues before. There was some discussion about the groundwater monitoring. And so there was a lot of situations where you said the majority of the sites identified by KPK, I believe you said there was 45, whereas you had 60. For their 45, the vast majority of those sites, they're saying monitoring can be completed within 4 quarters, whereas a lot of viewers were saying more than 4 quarters. Could you just provide a little bit more context on that?
Well, the first bit of context I would provide is post-remediation monitoring. So regardless of what your method of remediation is, whether it's in situ, air sparge, SVE, active remediation, whether it was an excavation where groundwater was, encountered in the excavation, or whether it's a site where you have known impacts and you're conducting monitored natural attenuation. Post-remediation monitoring, we require consistently 4 quarters of groundwater monitoring after the remediation is complete. So, any site that is asserted to only need 4 quarters of groundwater monitoring, the corollary to that is it has to have the last groundwater monitoring sample has to be clean. Because that's when you can start your 4 quarters of post-remediation groundwater monitoring. And we do not have data on file to support that the majority of the sites are in that situation. We simply don't have the data in our records.
So a lot of the groundwater monitoring, where you're saying it could be 24 or 28 quarters, is because that monitoring is already going on, already being paid for, already being analyzed, while the remediation is still ongoing.
Not necessarily the 24 or the 28, like those are the sites where there was, significant contamination, maybe free product still on site that's not undergoing active remediation. Or maybe it was free product encountered in the excavation and not dealt with at the time. But certainly where staff had estimated 3 years or 12 quarters of groundwater, that was the majority of our sort of assumed duration. And that's where we assumed that, if active remediation is wrapping up and there's still some residual contaminants, a couple of years of attenuation is pretty reasonable to assume. And then, that followed by the post-remediation sampling. So you'd maybe get 8 quarters while you're still watching the last of the organic compounds, dissipate and attenuate. And then you would then commence your post-remedial monitoring.
Perfect. Thank you very much. I appreciate it.
Other questions? Commissioner Messner?
Thank you, Mr. Chair. Just one question, Mr. Geronimo. And thanks for your presentation today. Were you or your reclamation staff ever asked to review KPK's demonstrated cost associated with reclamation in their financial assurance submittal?
In their original submittal?
That's correct.
I was not. To the best of my knowledge, Dr. Arthur and her team were not either, but I'm not sure of that.
Okay, thank you.
Commissioner Ackerman?
Thank you, Mr. Chair, and thank you, Mr. Geronimo, for your testimony and for being here. Thank you for the considerable, once again, amount of staff time that's been dedicated to this operator. Just one question from me as well. I know that you weren't able to listen attentively to some of the opening statements, but one of the opening statements by KPK was that some of the areas that you considered, they would argue would be outside of their responsibility to remediate. In your opinion, did you include in your facts and figures and in your analysis any locations or any obligations that arguably could be not KPK's responsibility?
By staff's position, no. An example, however, is the boxer tank battery that was then later mentioned as well. And, I recognize that the boxer tank battery is a significant, that was a significant remediation cost that we factored into this, because the salt kill going off-site from a remaining active pit, as well as older historic but still open pits, or still unclosed in our records pits, that salt kill is widespread and will be very challenging and costly to clean up.
Thank you, Mr. Geronimo. Nothing further, Mr. Chair.
Further questions? All right, I'm not seeing further questions. Mr. Boudreau, your witness on redirect.
Thank you, Mr. Robbins, or Chairman Robbins. Just a few questions. Mr. Geronimo, I want to talk about the SAC 8 real quick. Can you remind the commission why you and I discussed the SAC 811 in the first place?
Well, it primarily because it was included in KPK's response to staff's pre-hearing statement. You know, and staff had identified an issue with the what I would call incorrect closure of that site. And we reached out to you in our discussions to determine what we should do about it.
And is that one site out of the 146 that you and your staff identified, is that is that a majority of the cost that you calculated?
No, and in fact, the costs that we included for that particular site include backfill, reclamation, soil borings and background analysis, and form submittal. So no further remediation on that site. We identified that background determination would probably be appropriate.
Okay. And I believe you and Mr. Jacobs had a discussion about why the possibility of reopening the SAC 811 was only disclosed today. Do you have an explanation why staff didn't address that earlier, or didn't mention it to KPK earlier, or find it earlier?
Well, to clarify, I'm recalling our conversation now. The DJ Basin supervisor and I contacted you because, you know, we'd identified the issue, then we saw it in the pre-hearing statement. And, you know, we kind of wanted to talk with you as in terms of whether or not there would be an issue with reopening it immediately prior to this hearing. And we just felt like, let's talk about it at the hearing, and then we'll figure out what to do with it after.
Okay, thank you. Actually, I believe that was covered by Commissioner Messner. So that'll be it for me. No more questions on redirect. Thank you, Mr. Chair.
All right. Thank you, Mr. Geronimo. Appreciate the testimony and the work on behalf of staff. At this time, Mr. Boudreau, do you have other witnesses to call?
I do not, Mr. Chair.
All right. Do we need to deal with any exhibits on staff's behalf?
Staff would like exhibits 1 through 10 admitted into the record. We submitted a global list or table of contents with our global exhibits yesterday. And so to the extent that we need to specifically request that it be included in the record, staff does that now.
All right. Any objections?
Mr. Chair, I had raised concerns about Exhibit 10 with the hearing officer previously, and based on Mr. Geronimo's testimony, I understand that it was prepared by him or his staff under his direction. And so I think with the detail provided, we don't have the authentication or other evidentiary concerns that were raised to the hearing officer. So I'll withdraw any objection to Exhibit 10. I think that was the only one we had an issue with.
Okay, thank you very much, Mr. Sura. You're muted.
No objections.
All right. I'm not seeing Mr. Lewis Prescott visualize, so assume there's no objections there. Thumbs up. All right. Exhibits 1 through 10 are admitted. All right, at this time, I believe we turn next to the KPK presentation on remediation.
You'll permit us a few minutes. Our witnesses are going to our witness room.
All right, why don't we take 5, and that'll give you time to get your witnesses up and running. Commissioner Messner?
Yeah, Mr. Chair, I just wanted to follow up. I believe Mr. Sura had asked to be able to ask questions of Mr. Cuthbertson as part of staff's presentation, and I don't know if that's still the case or not, but certainly wanted to provide process to be the case.
Thanks, Commissioner Messner. Mr. Sura, you're recognized.
Thank you. It would be probably about 3 minutes. I've got 2 quick questions.
All right, any objection?
Only that we be afforded similar latitude.
Sure.
Thank you.
I don't know if it's an objection or just a curiosity. I'm not sure how this fits into the procedure here, seeing as how we already called Deputy Director Cuthbertson, and then he was subject to cross, including commissioner questions.
Well, we're fairly relaxed with regard to the approach we take here. I think if we were in district court, you're probably right. But we're just trying to get to the bottom of all this. So I'm going to allow it unless you've got a more vigorous objection, Mr. Pedro.
No, that satisfies me. Thank you, Mr. Robbins, Chairman Robbins.
All right. Is Mr. or Deputy Director Cuthbertson with us? Yo, good to see you. Thank you. A couple of minutes of questions, and then perhaps there's some cross as well. So you're back in the hot seat. Mr. Sura, your witness.
Thank you. Deputy Director Cuthbertson, did you hear the discussion that I had with Mr. Duranlo about the $45,000 estimate per acre for reclamation?
Yes.
Do you believe that that is consistent with your statement when you were speaking to one of the commissioners that for similarly situated sites, Orphan Well staff estimated it would be $8,000 to $10,000 per location for reclamation?
I believe I testified, or at least I intended to testify, that there are two different foundations for the two different numbers, and I have not attempted to correlate them in any way. The reclamation unit cost that this rigorous analysis that Environmental Manager Duranlo has gone through is different. It's a different analysis than the more contextual, generalized foundation that was used for a average location cost that was in the initial plugging, abandonment, and reclamation demonstrated cost numbers. So they're two different foundations, and so I could not testify that they are consistent or not consistent. It's difficult to it would be difficult to correlate them without some pretty more a fair amount of a more detailed analysis that has not been done.
And can you tell us which staff were involved in coming up with validating that $8,000 to $10,000 per location?
I had a conversation with Dave Andrews.
Okay. No further questions. Thank you.
Unmute. Any other questions for this recalled witness from Mr. Jacobs or Mr. Lewis Prescott first, and then you'll get him on redirect, Mr. Pedro.
No further questions for KPK of this witness. Thank you.
Mr. Lewis Prescott.
Nothing from Dacono. Thank you.
Mr. Pedro.
Staff has nothing other than to thank the Deputy Director for appearing weekend.
Yeah, thank you, Deputy Director Cuthbertson. Appreciate it. All right, let's take a short break to get the next set of witnesses lined up. It's 1:23. Let's return at 1:30. All right, this is the Colorado Energy and Carbon Management Commission. It is October 24th. It is 1:30, and we are undertaking docket 230400117. At this time, I believe, Mr. Jacobs, you have an opportunity to present a direct examination of your witness concerning their remediation issues. If you want to bring all of your witnesses to the floor, we'll have AG Davenport swear them in.
Thank you, Mr. Chair. We have John Peterson and David Hines on camera in our witness room. Probably won't have a third witness until rebuttal. So let's swear these two witnesses in.
Thank you, Mr. Peterson. Mr. Hines, if you would in turn raise your hand, state your name, and say that you swear to tell the truth. And we'll just start with Mr. Peterson.
My name is John Peterson. I swear to tell the truth.
My name is David Hines, and I swear to tell the truth.
Thank you.
Your witnesses, Mr. Jacobs.
Thank you, Mr. Chairman. Mr. Peterson, could you please state your name and current employment for the record?
John D. Peterson. I'm the Director of Environmental Health and Safety Compliance for KPK since May.
Thank you. And as I recall, you have post-secondary education that you're going to summarize for us, if you would.
Yep, I have a Bachelor of Science degree in Geology from Illinois State University and Executive Education complete at Stanford.
Thank you. And what professional licenses do you hold?
I have a registered professional geologist license in Illinois, Wyoming, and Kansas.
Can you briefly summarize your work experience for us?
Yeah, I have.
I believe we're going to have your resume up on a share screen. There we go. Go ahead.
Yeah, I have 30 years of environmental consulting experience and now in-house experience working for KPK, centered around geologic, hydrogeologic, site characterization, spill response, remediation of contaminants in soil and groundwater systems, assessment and mitigation of fugitive methane gas from coal outcrops, oil and gas infrastructure and landfills. Over the course of my career, I've performed more than 1,000 site assessments and remediation projects for 6 of the world's 10 largest oil and gas companies across the U.S.
And the bulk of your employment prior to KPK was working at the LT environmental firm and then briefly at WSP after it was acquired or after it acquired LTE. Is that correct?
That's correct.
What sort of firm was the LT environmental firm? What was its primary focus?
Sure. We were a full service environmental consulting firm. About 75% of our work was focused on the environmental consulting and engineering services for the oil and gas industry. It was founded in Colorado and then ultimately established 8 or 9 offices across the Rockies.
Thank you. Did LTE perform work for COGCC during your tenure with that firm?
Yeah, we did quite a bit of work for the OGCC from about 1998 to 2012, including work for the Orphan Well Program that involved plugging and abandoning wells, reclamation, baseline groundwater assessments, and some remediation work.
What was your role in the conduct of such work for COGCC while at the LTE firm?
I was the client manager for the Oil and Gas Conservation Commission for many years. So all that work was basically funneled through me as the lead.
And with whom did you primarily interact at former COGCC while employed at the LTE firm?
Sure. I primarily interacted with Debbie Baldwin, but also on projects with Randall Ferguson, Bob Chesson, Peter Gontatis, and Karen Lyons.
Thank you. Do you recall ever encountering any significant disputes over the technical soundness of LTE's work for COGCC over those years?
No, in fact, we were a preferred contractor for the OGCC based off our quality work, technical expertise.
Thank you. Is the technical soundness and rigor of your work for KPK materially different than the work you and others performed at LTE for the COGCC?
No, we're doing the same type of work at KPK as we did at LT Environmental that we did for OGCC. In fact, the technical approach now is probably more rigorous because the rules have become more stringent over time. So we're doing now probably more now than we ever did.
Very good, thank you. Turning to KPK Exhibit S, did you prepare that exhibit?
Yes, I did.
And is that KPK's estimate of remediation cost for all wells subject to single well financial assurance?
So that's all the locations with known remediation with an approved Form 27, because that's what the language Rule 70B calls for.
Is that 702B?
702, sorry, 702B.
Thank you. So that excluded, that estimate excluded locations covered by open forms 19 and sites without an approved Form 27?
Correct. That rule, in my review, it doesn't have Form 19 costs associated in it, asking for Form 19 costs.
Thank you. And of course, you heard the commission's ruling earlier at the beginning of the hearing today that was countered to our motion for summary judgment on that point on the scope of remediation expense estimates being confined to locations with approved forms 27, correct?
Correct.
So will those locations under forms, if we were to prevail and only estimate approved form 27 locations, would the form 19 locations and the unapproved form 27 locations never be the subject of financial assurance?
No, they'll be subject to the financial assurance in the upcoming future annual reviews, as those sites migrate into Form 27 phases of work. For the sites that do, the ones that aren't fully remediated before you get to that phase, they would be included in those annual reviews.
And you've subsequently estimated the expense associated with the excluded locations that staff estimated at an additional $1 million. Is that correct?
That's correct.
So with that understanding, how did you go about preparing your estimate of remediation expenses for that category of KPK locations?
Sure. I think the biggest lift was going through all the available soil and groundwater analytical data that we have for each site. This includes all the data that we have submitted in Forms 19s, Forms 27, even new data that's been collected from remediation that's currently being performed, and where we're preparing submittals for the ECMC review and approval. If you go to this slide here, you can see some of the other components. We were assuming background samples for borings. We did 4 borings with 3 samples intervals for each boring, with sites that are off location. If we had organic soil impacts remaining, or we had high levels of SAR present in the root zone, we assumed that we would need to be doing additional excavation. Sites that did not have excavation completed yet, we estimated those higher. It's a judgment call as far as the volume based off of what we saw during the emergency response. And so we just assumed a volume there for those ones that we haven't started excavating yet. We also assumed that we would not be remediating naturally occurring compounds, naturally occurring metals, and we would not be remediating SAR below the root zone or those soil suitability parameters for reclamation where reclamation wouldn't be applicable. We also assumed there would be groundwater impacts present on any of the sites that have groundwater less than 20 feet, and that those would need monitoring wells. If there were sites where groundwater was estimated to be more than 20 feet, we did not assume the installation of monitoring wells. So on the next slide, you can see a continuation.
20 feet below ground surface, correct? I just want
20 feet, yeah, 20 feet below the ground surface.
Thank you.
We assumed that for the sites that we'd do anywhere with borings and monitoring wells, we'd put anywhere from 5 to 10 different points per site. That's a pretty common number, and I basically decided those quantities looking at the data that we had, the site maps that we have, and where I might want additional data to be collected for both soil and groundwater. For sites where we had monitoring wells already, but there was no impacts in those samples that we've collected already, I just assumed we would do 4 more quarters of sampling in order to close, just like Greg Duranlo testified. You need 4 consecutive quarters following remediation to close those sites, and that's what we assumed. If there were groundwater impacts present, we assumed there would be anywhere from 4 to 8 quarters of groundwater monitoring. A few of those sites had more sampling events, where maybe 16 to 20 quarters of sampling. The sites that we knew had maybe in situ remediation or free product, we might need to monitor a little longer. The backfill volumes, so we used a GPS with sub-meter accuracy. We went and surveyed every open location that KPK currently has with that GPS, And then we measured with a tape measure the depths to the bottom of the hole and the depths to water in that hole to calculate the remaining backfill volumes for each of those holes. And our calculation for those backfill volumes is really conservative, because while we use the area and the depth, it would assume that the sidewalls of those excavations were vertical, and in most cases they're sloped, even just through the natural repose of the soil. So we're overestimating the amount of backfill that is required with our calculations. A few of the sites had really impacted groundwater at elevated levels, and so we assumed that we would be doing some in situ remediation there. And injection is, injection or chemical oxidation or some other injectate. We've estimated about $50,000 per injection, and then ASSV, air sparge SVE systems, those were estimated a little bit higher, $200,000 or so. The reporting costs were just based off of the amount of additional work that's needed, the amount of additional assessments that's needed, and where we're at in the reporting process for all the data that we have. Those sites that require a lot more assessment or mitigation had larger reporting costs. Those that have completed remediation and we are requesting closure or arguing that the remaining concentrations are within background, those reports had smaller reporting costs associated with them.
Thank you, Mr. Peterson. And after evaluating those data and applying those assumptions you've just described, were you able to calculate an estimate of remediation expense for KPK's locations subject to single well financial assurance with known contamination?
I did. It was about $2.9 million for the sites on that list.
And again, just to be clear, that's just for locations with an approved Form 27, as we discussed earlier.
Yeah, but I also ran numbers using those other sites with just Form 19s and unapproved Form 27s, and it added $1 million, which is proportional to the amount of sites. There's about a third of the sites not included, so we have about a third of an increase, 30% increase on that.
Thank you. Mr. Peterson, have you reviewed staff's supplemental pre-hearing statement and exhibits regarding their remediation estimates for KPK locations subject to single well financial assurance with known contamination?
I have, yes.
And have you reviewed staff exhibit 10 in particular?
Yes, I have.
And you heard the testimony of Mr. Duranlo earlier regarding the preparation of staff's exhibit 10, correct?
Yes, I heard his testimony.
You agree with staff's estimate of remediation expense subject to single well financial assurance determination in this proceeding as tabulated in exhibit 10?
No, I do not.
Can you elaborate for us on the bases for your disagreement?
Yes, of course. In fact, I reviewed the exhibit 10 in particular quite carefully to understand the level of staff's analysis and KPK's locations with known contamination, that they arrived at their value of $24.3 million. How
would you describe that level of analysis by staff?
It's grossly overestimated, and that's based off of poor assumptions, missing data, improper remedial solutions given site conditions, and conflicting and contradictory positions about staff's preferences for regulatory compliance and remediation.
Did staff seek to consult with you or others at KPK about the level of remediation remaining at any of KPK's locations, which are the subject of their estimate?
No, they did not.
Did they raise concerns about your estimate of remediation expense other than in their pre-hearing filings?
No, just the pre-hearing filing.
Does it appear to you from your review that staff took all available location-specific data into account in estimating remediation expense for purposes of single well financial assurance?
No, it does not.
And are those data contained in Forms 27 and Forms 19 for KPK locations with known contamination?
Yes, they are.
What's the status of most of those Forms 27 currently and open Forms 19 over the last 60 days or so when staff was preparing its estimate of remediation expenses tabulated in Exhibit 10?
Yeah, many of the Forms 27 or 19s that we have been submitting have been denied for various reasons, some for no apparent reason at all, in some cases without a comment indicating a basis for the rejection. In some cases, the form was denied without any ECMC review
Were any rejected on the basis of insufficient data quality, to your knowledge?
Not to my knowledge. The majority of the denials of the forms are rooted in misunderstanding of our provided information, minor administrative inconsistencies, semantics, word choice that we've put in there that they deny, KPK's misunderstanding of exactly what it is ECMC staff is requesting. And so any of those subtle changes or discrepancies or misunderstandings or differences of opinion automatically elicit a denied response from the ECMC.
But the forms that received such treatment included more recent data prepared and submitted by KPK, did they not?
Yeah, I think even on one of the slides I saw this morning where they referenced the amount of money that KPK had been spending on remediation of $400 and some odd thousand a month. There's been quite a bit of remediation performed by KPK, lots of sampling, lots of analysis, and that data is in those Form 27s that have been denied by ECMC staff. And of course, there's data that we have that has not yet been populated into a Form 27 for submittal.
So do you believe staff considered the many data points contained in the Forms 27 rejected or denied for other reasons or no apparent reason at all?
I don't believe they, I believe they considered the ones in the Form 27s that they have approved. I think I heard Greg testify that they didn't review the data that was in the denied forms. And so there's quite a bit of data in there that is being ignored to arrive at remedial estimates for closure.
On what do you base the opinion that they ignored those data?
There was a lot of assumptions in order to drive their estimate. The assumptions are in their staff exhibit 10, and they don't account for the current data. They don't account for the extent of the source removal that we've done, the excavations and disposal that has already been performed. The issue of naturally occurring background compounds in excess of table 915 are not addressed. Those considerations significantly impact the amount of remediation that's required, and that those considerations and data are required to develop appropriate and reasonable assumptions. And without that, you would get a really grossly overestimated number.
So I gather you've reviewed staff's assumptions made to derive its estimate of KPK's remediation costs.
I have reviewed them, yes.
Do you agree with those assumptions?
Most of them I do not. They are not very good assumptions, in my opinion, for doing this type of work.
And where are those assumptions indicated in staff's exhibits?
So there's an Excel spreadsheet. It's got 3 tabs. One tab is the site-by-site evaluation with the dollar amounts. Then there's a tab with cost assumptions, and there's a tab with remediation assumptions.
And those are all in the Exhibit 10 spreadsheet of staff?
Yes, that's correct.
Can you summarize those assumptions briefly with reference to the text in that tab of Exhibit 10 that will be shown on several slides that I'm having pulled up?
Yep. We'll start with the cost assumptions here from the cost assumption tab in Exhibit 10. So the ECMC used excavation and loading cost of $16 an hour. Like Greg testified, we had assumed 1,000 cubic yards a day at $120 an hour for an operator. This is about $1 a yard. So their number is 16 times more what we have. But if you look at what an excavator might do in an 8-hour period at $16 an hour, you're looking at $2,000 an hour for an equipment operator. I think that he said that they were quoting reasonable cost guidelines of $400 an hour for an excavator. These are extraordinary. I've never heard of anyone paying those amounts for equipment operators. Another one is this transportation of soil. They were using manifests to establish a rate at which we could excavate soil, but the manifests established the rate at which soil is transported off-site for disposal, not the rate at which they were excavated. And so you can excavate soil at a rate much different than what your trucking is, because the trucking is really dependent on how many trucks you have to load onto this day on a given day, rather than how fast the excavator can dig. So you can stockpile soil on site and truck at a slower rate than you can dig. But on the trucking itself, it's about $118 equivalent per hour for a CDL driver. My estimate had $68, I believe, for a truck driver. And the other piece of that is that the landfill is very close to our sites. On the map, you look at as the crow flies for the landfill, the Erie landfill that we use, Front Range landfill. It's about anywhere from 3 to 20 miles from our KPK release sites. So it doesn't take much time to get there. I think I assumed 45 minutes of travel time for each of those loads.
Thank you. Next tab or slide. What about their excavation and backfill assumptions, or excuse me, water sample and cost analysis assumptions?
Sure. They have a $305 for groundwater analysis. My cost is quite a different than that. Our lab analysis is only $110 a sample for groundwater, so that's a third that price. And for sampling monitoring wells, it takes less than an hour to sample a single monitoring well, and the going rate for field technicians is about $70 an hour. You can sample a groundwater well with the analysis and labor included for about $180 an hour.
Thank you. Do you have concerns about their assumptions? Oh, I'm sorry. Go ahead with the next.
Yeah, I was just going to say this is an invoice from Origins Laboratory. It's an accredited laboratory that we use. And this is just an invoice for the Walden water flood sampling site. But that's a full suite of table 915-1 analytes for groundwater, and it's $100 per sample. There were 2 samples there.
Thank you. Next slide. Let's turn to their remediation assumptions.
Sure. I think this is where the biggest cost differences come into play. And Greg also mentioned that approach was a big factor in their costing exercise. And I think that's a critical element for the derivation of these costs. Approach is everything. And this is one of the things that consultants are constantly faced with is what's the approach that's going to be the most effective and the most cost conscious and the most protective of human health and the environment. And I don't believe that the methods and the approach that the ECMC used are reasonable assumptions given what the industry commonly does every day, day in and day out across the United States for this type of work. They also assume that excavation is the primary mode of remediation. And I would disagree with that approach in that I think excavation is the primary mode for source removal and not necessarily remediation in the subsurface. There comes a point of diminishing returns when you're excavating for plumes that are beyond the source area. A lot of the ECMC excavations assume we're digging out 1 foot thick smear zone impact that's well outside the source area. So when they use a boring, they show the excavation and they use a boring that shows there's an exceedance. If you look at the depths of those exceedances, they are down at the groundwater table where you would expect to find contamination that's migrating via the groundwater, not migrating via gravity from the source. And so to go and extend your excavation all the way out to those borings that are well outside of the source area, they're in the groundwater plume where there's smear zone impacts, and assume that you're going to excavate that whole bunch of soil. It's absurd. It's not a standard practice to do that in the environmental consulting and remediation industry. It's a waste of resources. In fact, their estimates include the disposal of clean overburden that would not be impacted because its travel mechanism is through the groundwater. So all that overburden is clean, yet they're assuming that we have to dig it out, transport it, excavate it, and dispose of it at the same way that we would contaminated soil. That's a gross overestimation. The other thing is that you might not necessarily need to be able to excavate soil to that extent. The landowner's trying to run a surface operation. I think it's ironic that they use the oil and gas, the oil and public safety reasonable cost guidelines to look at excavation. And in those circumstances, in underground storage tank sites, in most cases, they're in urban areas where you cannot excavate offsite. And so they're not excavating smear zone plumes, they're excavating a source area, and the rest of the contaminants that remain in place are being remediated by natural attenuation, in situ remediation, some injection of some sort. So the excavation approach that they're expanding, that's $16 an hour for excavation on OPS sites, to the types of excavations that they're trying to dictate that be done for oil and gas upstream. It's a mismatch. The other thing is that their assumption is that it's dig and keep digging until it's clean. And this goes from the point where you notify the spill to the point that you get clean in soil. And so any of the opportunities that you might have in a normal set of circumstances in this business to assess the extent of contamination, the magnitude and extent, before you decide on a remedial alternative, are rendered moot because the state wants you to continue excavating from the moment you discover the release to the moment that you can get clean samples on the sidewalls of the excavation. And in lots of cases, particularly with excavations deeper than 20 feet, or the contaminants have come in contact with groundwater, that's when your mindset starts to change about, well, excavation might not be the right approach here. I need to understand the extent. I've gotten rid of my source area. I've prevented the continuance of a release. I've gotten rid of a huge amount of mass that would allow us to understand how the site should be best remediated by going out and doing an assessment. And that is a typical standard practice in every other industry other than Colorado's oil and gas industry, where you have an emergency response, you remove that source, you do a site assessment, you design what's the appropriate remedial technology or design, and that may be excavation, it may be in situ, it may be monitored natural attenuation. You do an economic and technical feasibility study to understand which of those approaches are correct. And then you decide on that implementation. The state agrees or disagrees with that, or asks for some preferences along one of those remedial designs, and then you implement it. And then you do monitoring to closure post-implementation of that remedial method. And with the state's approach that we've been forced into is keep excavating until the end. Else is not acceptable.
Thank you for that. One clarifying question. You refer to a smear zone. Can you describe what you're referring to in smear zone hydrocarbon plume terminology?
Sure. And if I had a whiteboard, I would diagram for you because I love whiteboards. But if you think about a cross section of the ground, look at it as a slice of cake. And the frosting is where our equipment is, and you have the layers of cake beneath that frosting. And if I had a tank on the surface or a pipeline that's a couple of feet below the ground surface, and those that infrastructure leaked, it would start to release those hydrocarbons, and it goes in a vertical manner because gravity. Right, gravity pulls those contaminants down, and they kind of make like just a oblique angle. There's some surface tension and other forces that are moving those contaminants a little bit wider as it goes down, and it goes down vertically until it hits the groundwater table. At which point, the dominant transport direction starts to become laterally in the same direction as the groundwater flow. The smear zone piece is the part of that lateral migration that varies vertically up and down on the seasonal groundwater flow or the groundwater table elevation differences. So in the fall, groundwater flows or groundwater elevations are lower, and so that vertical transport of oil vertically downward is a little farther. If it's springtime, that groundwater table is higher, and so the vertical transport is shorter. But that same difference in high to low groundwater is that groundwater spear zone, which can be a couple of feet. Lots of times it's a foot. Depends on the soil type. With the finer grain materials, it can be thicker. Sometimes it can be 5 feet, but in most cases, it's around 2 to 3 feet in Weld County. And so that smear zone of impact goes laterally as the groundwater is going up and down. And so once you excavate the source area and that smear zone is still there, there's no more source loading onto the groundwater. And so what happens is the groundwater starts washing up and down on that soil column, and it's dissolving hydrocarbons into that water piece on the down gradient side and allowing that natural degradation as the groundwater comes through for the biodegradation, dispersion, dilution, and all those other factors that happen for those smear zone impacts to be remediated with groundwater. It's not very common practice to collect samples from the smear zone as your soil. It's more indicative of the groundwater concentration or the groundwater impacts. And so smear zone impacts are typically remediated as part of the groundwater flow system rather than the soil vadose zone system.
Thank you. Appreciate that. Next slide.
These are more excavation and backfill assumptions. They talked about if there was excavation samples submitted and they were above the table 915-1, that they assumed 5 feet horizontal. That would be in both sidewall directions, so 10 feet laterally and another 2 foot vertically. This is a bad assumption because the standard operating procedure for us and the standard dictating of how these sites are to be remediated by the ECMC is you have the release, you keep digging until you run out of compounds at table 915-1. And we do that in the field by using a volatile ionization detector. We can screen soil samples as we start digging out to find which areas are really contaminated and which areas are not. And so KPK standard practice is to continue to excavate until we start getting PID readings around 1 ppm, 0 ppm. We can obviously see that the petroleum hydrocarbon impacts have been removed. It's at that point that we would collect a sample. Up until then, we don't collect the samples because they're highly contaminated. We know they're contaminated and we know they need to come out. So we start to collect them as trying to demonstrate that it's clean. We're trying to find clean samples as we move out. And so the assumption that you're going to be excavating, in this case, if you took a 20 by 20 foot excavation and increased it by 10%, I mean, 170% larger excavation than what you've already done. That assumes that the majority of the remediation that you're costing is yet to be done. When in fact, when we grab these samples that they have to compare to table 915-1, we've already done a majority of the excavation. We're trying to demonstrate that we've reached the end. So the concentrations remaining are very low in the parts per billion, parts per trillion range, not source area impacts. And so to assume that you need 170% more excavation when you're in this parts per trillion, parts per billion range of contaminants on the sidewalls is a bad assumption. We assume that only a small amount of additional excavation would be needed in those cases, and not more than what we've already done.
So you agree with that 1,000 cubic yard of soil disposal per release assumption of staff?
No, they create an average of excavation sizes, and those excavation sizes based off visual notes that we put into the Form 27. So they're like, well, how big is the excavation? Well, it's about 40 by 10, or it's by 20 by 20, whatever it happens to be. They're nominal estimations of what the excavation size is, but not a good estimate of actually what the excavation volume was, because of that that vertical sidewall equation, and because the excavations themselves are generally not that big. In the cases of their average, there are, I don't know how many sites, probably 10 to 15 sites that have enormous Olympic swimming pool size excavations. And those excavations are not because the release has spread that far and we have this ginormous release. It's because the previous consultant was excavating and trying to grab samples of naturally occurring metals, to which the state would deny them cleanup, and so they would go excavate more. And so those huge excavations were chasing arsenic, barium, cadmium, these naturally occurring metals, and that's why those are so large, and that's why they're skewing that number. If you look at, and I have pictures of a lot of release sites, and we could go up there. Well, we're getting a fire alarm here.
I do apologize, but we've just had our safety training recently, and we are obligated to honor this fire alarm in our building. So I'm going to have to beg your forgiveness, Mr. Chair, and pause until we can return. I'm happy to call or text you when there's the all clear, but, and I'll leave this open, but we need to evacuate our building.
All right, understand. Why don't you text me? I think you've got my number, or Ms. Larson, when you guys are available to reconvene.
Apologies. Thank you.
We'll be on a extended break until we get these folks back. So at this point, everyone just kind of stick around, stay close to your computers, and when I revisualize, I'll try to update the panel with a return time. Probably, I don't know, how long does it take to turn off an alarm? Maybe 30 minutes? We'll see. Has anyone heard, or are we just returning because it said 2:37? Oh, there's our witness.
Yeah, we're back.
Mr. Robbins, I did text you. I also texted in the chat function of the Zoom platform to Ms. Larson and exchanged information with Hearing Officer Thomas.
Great. All right. This is the Colorado Energy Carbon Management Commission. It is 2:38. It is still October 24th, and we are still undertaking docket 230400117. Mr. Jacobs was in the middle of direct examination of his first witness, and we had a fire alarm that has been taken care of. And so I believe we are ready to proceed.
That is correct. Apologies for the interruption.
I'm just glad you guys are all okay.
We are, thank you. It was a successful evacuation and return to the building. Mr. Peterson, we were discussing remediation assumptions. And I believe we were prepared to leave the excavation and backfill assumptions moving to dewatering. Next slide.
Correct. On the dewatering costs, I heard in Greg's testimony that we had agreed to dewatering, or that was part of our approach, and that's not accurate. In fact, it's just the opposite. I don't think dewatering is an appropriate remedial method for these types of sites. I think it's rarely ever been applied. It certainly in my 30 years, I haven't done a dewatering at an oil and gas site to conduct excavation. But perhaps on my, Mr. Duranlo was looking at my assessment or the estimates and saw the water removal, and that is, there were costs in there for water removal, and that's because we have a good number of excavations that have been sitting open for more than a year that we cannot get closed, that have background levels of metals in the soil, and they're filling up with surface water. And so our remediation costs are elevated from what they normally might be, because we have to get rid of that water in order to backfill the site. So that's maybe the difference there. But in any effect, dewatering is not an effective remedial technique. It's analogous to the old pump and treat days of the late 90s. It's just really expensive and not appropriate. And I certainly haven't ever done dewatering on any of the sites up in the oil and gas industry sites. I've done it at some downtown Denver sites where we needed to excavate deeper for a subsurface garage. But excavating with dewatering is highly unusual and rarely applied for this. So I disagree with that assumption.
Thank you.
Go to the next one. This is a big component of the background sampling, and while their estimate said there was less samples, it's not so much about the samples as to what actually constitutes background. And they mentioned that it's up to the operator to determine that and to demonstrate background, and every single determination and demonstration that we've done has been denied. And so we are arguing about background concentrations, and yet their assumptions in their estimates is that we're going to excavate them. And I'm staunchly opposed to excavating naturally occurring compounds that are not put there by KPK. I think they have an inconsistent method of applying background to us and to other operators, and from site to site, different regions of Colorado. I think different EPSs apply different background concentrations or standards for background demonstration. I think it's an overcomplication of the whole background determination process, given the our understanding of geology and hydrogeology. I think there's misunderstanding about statistical analyses associated with these data. I think there's a lack of experience in regulating and understanding metals, in particular, in the ECMC and risk-based exposure evaluations for those compounds. And I think that essentially they have unlimited discretion with respect to granting NFA when it comes to naturally occurring conditions. And I think it's one of the biggest disagreements that KPK has with the ECMC, and is a big component of what remaining remediation is needed. They're assuming we're remediating naturally occurring compounds, and I'm not. So that's what my assumptions are, or the default and assumptions I see on the ECMC's estimate for these background concentrations.
Thank you. How about groundwater remediation assumptions?
So there's a lot of difference in the monitoring periods for groundwater monitoring post remediation. It's surprising to me that they have chosen to use so many extra monitoring events than what I proposed, because their desired or preferred or encouraged remedial response is excavation, and even to the point where dewatering and excavating. So we're essentially eliminating the groundwater plume to a large degree. So that means once we put in monitoring wells, they're generally non-detect or very, very low concentrations. And so you wouldn't require long periods of monitoring. And you'll see some of that in the site-specific examples that I have up ahead. But yeah, I think that the assumptions for groundwater monitoring are contradictory to their remedial approach of excavating everything to the extent, unless it's impractical. So,
thank you. Next slide is concerning other staff assumptions.
Yeah, I think these are some other assumptions that obviously add a lot of cost to the ECMC's estimates. The SAR, sodium absorption ratio, the inorganics, boron, for example, EC, pH, and SAR in the soil. Those parameters on the rules are soil suitability parameters for reclamation, and not soil remediation standards. And so they're really designed to make sure that vegetation can grow in the surface post remediation, so that you can grow vegetation. That's what those parameters are there. And so to start chasing SAR in the subsurface at 20 feet or 15 feet, or on the extents of an excavation at depth when you're out of the root zone is it's excessive. It's not necessary, and I don't believe that's what the rules are really trying to do. The reasonable cost guidelines, we went through that. The assessment that those are reasonable for this application, I think, is a little misguided. Those sites are heavily developed. They have surface completions of asphalt and concrete. They have buildings. There are pump islands. There are traffic for on-site filling of vehicles. Lots of things that we don't have in the oil and gas upstream area markets. We don't have traffic control needs. We don't have surface completion needs. We can do stick-up monitoring wells with no surface completions. We can do subsurface active injection and remediation projects with surface. We don't need to dig and bury trenching for piping. Build buildings. We can use mobile trailers to remediate these in situ. So there's a lot of costs that are associated with those reasonable cost guidelines that just don't apply to upstream oil and gas, and actually add cost to the UST type project. The topsoil, there's a lot of discussion on topsoil from all the testimony. Just reclamation in general. The reclamation when it comes to remediation, or reclamation when it comes to plugging and abandonment wells, this is a very small component of the whole process. It seems like there's lots of debate about reclamation costs when it's really a minority of the total costs that we're trying to estimate for purposes of financial assurance. So I think it's just misguided and misunderstood. The cost for Form 27s, or for sites without Form 27s, It's $1 million we put in there when we included them, but obviously that was missed on, or a difference in the two analyses. The sites that require in situ remediation, it's been my experience that in situ remediation is generally discouraged, not approved, or not allowed when we're trying to gather data to evaluate such a procedure. They deny those requests in the Form 27 and demand that we continue digging. So it's surprising to me that they would use 8% of the sites for in situ remediation. I don't know that 8% of sites in all of Colorado and upstream oil and gas sites have in situ remediation. It's a very high number from what I'm used to seeing. And then many of the assumptions that they have are directly opposed to the empirical data that we have for these sites. Obviously, they've been denying the data or denying the forms in which that data is contained, but it doesn't invalidate the accuracy of those data points. Lots of remediation excavation, lots of soil samples, lots of groundwater well installations, lots of groundwater samples that don't appear to be in the ECMC's analysis.
Thank you. Next slide.
This is just this is the importance of this slide is that the approach that ECMC took with their remediation costing and this approach that we took, they're very similar, right? You're looking at the same types of tasks. The biggest difference comes in the sensitivity of some of those input parameters. So if you have really poor input parameters on excavation costs or trucking costs, it grossly inaccurately inflates the number. And I'm not sure if ECMC did a sensitivity analysis on their modeling, but if you were to decrease the soil volumes that they proposed by 20%, let's say, I would bet that the costs are not linear or proportional to that. They are much bigger decreases in costs when you start adjusting those really sensitive parameters, one being the amount of soil that requires excavation or the amount of sites that need in situ remediation. And so there's a lot of inflationary costs in ECMC's estimate associated with those poor unit rates that are just too conservative for a reasonable collaboration or consolidation of an entire portfolio of sites.
Thank you, Mr. Peterson. Do you have some location-specific examples of staff's assumptions being inappropriate in your opinion?
I do. The SAC 811, I know that we heard testimony on that. There was an NFA just recently granted for that site. The state ECMC estimated that there was still $50K of remediation costs remaining at this site. I think that's inaccurate. Our estimate was $9,000, and essentially that was the backfill and reporting of the final reclamation. That's where that dollar figure comes from on ours. The other thing that's interesting and important to note is that this site, the SAC 811, there are 6 other sites located within about 200 yards of this hole that you're seeing. Same farmer's field, same types of soil, same types of infrastructure that KPK had. Similar concentrations were found in the releases that KPK documented and reported, and similar concentrations of background contaminants, metals, SAR, EC, pH. All of those compounds are very similar at each of those other 6 sites. And those other 6 sites had a remediation estimate of $500,000. And in my opinion, based off the concentrations that are there and the site conditions, these sites are all ready for a no further action determination, just like the SAC was. And that's what our consultant proposed in the Form 27 was a request for no further action based off of these site conditions. And like I said, the ECMC has yet to agree with any of our positions regarding background conditions. But I know that they are approved with other operators because my consultants are doing work for other operators. So they do get some of those things approved, whereas we don't. So we're sitting there looking at the SAC 811 and talking about how it might be reopened to continue remediation. And I've got 6 other sites that are within 200 yards of it with the same conditions that all deserve to be closed. And I agree with the state's determination that SAC 811 should have an NFA. It's the right approach to meet the rules.
Thank you, Mr. Peterson. Next slide. This
This
is
is just the document, the Form 27 from September that they received on September 11th that talks about that no further action, based on the information presented, no further action is necessary at this time, and they approved their closure request. So that's would be nice to have at these other SAC sites that are very similar as well.
Thank you. Next slide.
This is the concentrations of soil. So this one just shows the arsenic highlighted there. You can see arsenic, the standard for arsenic in table 915-1 is 0.68 milligrams per kilogram. I defy you to find a single soil in the Front Range of Colorado that has that value, because all of the soil in the Front Range of Colorado is higher than that. And that's indicative of the samples that we have. Both the background samples, those ones that are in gray, and the ones that are in white are the confirmation samples. You can see that all those samples are essentially the same concentration when you're talking about metals in soil.
Thank you.
This is the SAC-G Form 27. You can see the reason for the denial. It just says that we haven't conducted a review of this form, and so it's denied. It's unfortunate that we have to do this, because we have lots of sites like the SAC-G where we're trying to present data that shows that the remediation has been completed and we're ready to close this hole, and we can't even get to the point where we're looking at data. We're getting denials without even being without forms being even reviewed. So.
Next slide. Other site-specific examples, of course.
Here's another example. This is the ACNO 2 well site. The picture on the left is the ACNO 2 wellhead. We had a OGCC inspection on this day, and there was a release in the tank battery at this site. And at the same time, the inspector noted that the wellhead itself was leaking oil around the flanges, and that we needed to report that release. So we did at their request. What we learned about this ACNO 2 wellhead was there were some loose threads on the flanges that needed to be tightened. We tightened those, the leak stopped, and we dug out by hand the remaining surface soil contamination, and it's less than 2 yards. This site has $80,000 worth of remediation attributed to it. We have $1,000, $1,200. And you can see from the pictures on the right that that surface soil staining was removed. So it's just another example of gross overestimation of remedial requirements at these sites.
Next slide. This is the Greeley National Bank. This is the site where the state directed KPK to continue digging for inorganics. We do have monitoring wells associated with this release. They're all around the perimeter of that huge excavation. We've sampled those wells many times. There are no contaminants of concern in those wells. The last detection of benzene was 6.87 ppb back in October. Basically a year ago, we had 1.87 ppb over the standard of benzene left in the groundwater. And yet there's $500,000, $431,000 estimated remediation for the ECMC at this site. We've got 16,000. This site's already been backfilled with approval from the state. And the groundwater is clean, yet we can't agree on the closure parameters on whether or not that groundwater is actually clean. We've been requested to add more data points and explain and try to establish background, which we've been unsuccessful at this far. This is the Facility 9 flow line at County Road 19. This release was a release of a flow line underneath County Road 19, and the construction of these flow lines, they put a steel casing around the flow line underneath the well or the road crossing, and then you put vents on each side of that so that that casing comes to that vent. So if there's a release underneath the roadway, that fluid would go into that casing and actually come out those vents, which is what happened at this site. We had a release underneath the roadway. The casing worked as it should. It came out the vents and spilled oil on the ground at the surface. We immediately notified this, immediately noticed this because our head of construction was driving by the site on his way to work, the same route he takes every day, and could smell the oil at that crossing, and we got right on it and cleaned it up.
There's $150,000 worth of remediation costs associated to the ECMC's estimate. We've already dug out the soil. You can see the extension of the impacted soil right around that excavation, which is not 50 by 50 by 1. It's like 10 by 10 by 2, 10 by 10 by 3. Our estimate's about $7,800. So it's about 50 yards worth of dirt that we were able to take out and deal with this spill. But again, just like I said, the assumptions are bad, is grossly overestimating the amount of work that's required at any one of these sites. The Guadagnoli consolidated flow line release, the state has estimated $220,000 of remediation costs. We have $18,000 in there, and really this release was identified by the city of Frederick, town of Frederick. Smith Environmental was putting in monitoring wells, and they got a detection of petroleum hydrocarbons in this well. And without any other evidence, the ECMC told us that we must report this release. And we don't have any reason to believe that the stuff that's in their well came from our release. You can see our battery off in the distance there, about 500 feet away. There's a little tank near the horizon there. There's no evidence that impacts in that well are from us, yet we're attributed with the release and then slapped with $220,000 worth of remediation costs for something we can't even confirm that a release occurred from our facilities.
Mr. Peterson, are you aware of whether there's any other more proximate oil and gas infrastructure at this location?
Yeah, there are flow lines in that area. I believe we even have a flow line, but it's further to the west than the flow lines that run really close to this this wellhead. But I mean, the potential sources of the contamination in this monitoring well could be one of 5 or 6 different things, but it didn't make the cut for us. We get $220,000 remediation costs associated with it.
Thank you.
This is the 3 farms consolidation line. You may have seen this in the Denver Post recently. This is a site excavation that we removed all of the contaminants to the extent we could. We grabbed some sidewall samples. It turns out there were some really low levels of petroleum hydrocarbons that remained in 2 of the sidewalls and a little bit on the floor. We're talking in the parts per billion range because, as I talked about before, we excavate until our organic vapor meter shows it's clean, and then we start grabbing samples to try and document that it's clean. And so this hole has been sitting open mainly because it's been full of water. The landowner irrigates that field that's about 5 feet to the east of this picture, and during that irrigation season, the excavation filled with water. That water is now gone, and we actually excavated this site this week and grabbed resamples of the scraping that we did. We did another foot or 2 on the northeast corner and the northeast corner and the floor, and a little bit more scraping to get rid of those parts per billion. And so our remediation estimate is $40,000. They have $135,000 in their estimate. This site has monitoring wells. Those wells are clean. No contaminants in those, and so I'm not sure how you derive $135,000 to remediate this site when you've dug out all the source, you've dug out the residual hydrocarbons from your confirmation samples, and you have 5 monitoring wells which have no table 915 compounds above the standard.
Thank you. I appreciate your review of those location-specific examples, Mr. Peterson. Were you surprised at the number of assumptions made by staff in preparing Exhibit 10 and the sources of cost information that they did employ?
Yeah, I was surprised because this CODIS database has probably the largest source of such data in the state when it comes to background levels or remediation cost levels. Literally tens of thousands of data points from operators across different geologic regions, different operating areas, yet they didn't use any of those costs to develop what's reasonable to remediation. So that's surprising to me.
You. And do you believe such assumptions in non-upstream unit costs contributed to an overestimation of KPK's likely future remediation expenses for locations subject the single well financial assurance?
Absolutely. I think the unit rates that were employed by the ECMC are overly inflated, given the scope of work that is generally done at sites like this and that are required at sites like this. And so not only are you grossly overestimating the amount of remediation that needs to occur when you apply units that are grossly overestimated, it just compounds itself, which is it's no surprise that the difference between the two volumes is an order of magnitude. When you start making assumptions that are grossly in error, it's easy to get order of magnitude differences in final results.
Now, we've got a chart up on the screen here regarding assumption contradictions that you prepared. Is that correct?
Yes.
Can you summarize these contradictions, please?
Sure. The first one's about the reclamation costs at $45,000 per acre. I think even Mr. Cuthbertson testified if you had 1/10 of an acre, which if you look at our 7,800, that's about almost 2/10 of an acre. Which is a pretty common size for our well locations and tank batteries. So it's not surprising to me that that number was used. It's just it's high as they're applying that to every location should be $45,000 an acre and not or $45,000 per location, not $45,000 per acre. And if you look at the reclamation costs on a specific level, and you start to look at on a map and measure the acreage that needs to be reclaimed, they're very small size, very small relative to the size of an acre. The other thing was, they're requiring remediation of soil suitability parameters at all these sites at all levels. They're treating these soil suitability parameters for reclamation as contaminants, just like they they have a threat to human health and the environment. And so they're remediating SAR no different than they would remediate benzene, which is misguided. They're remediating, they're assuming large amounts of excavation that remain incomplete, but then they demand that you excavate until upon discovery until you get clean on the sidewalls. So like I said, how can you have more remediation left to do when you're demanded by the ECMC to continue to excavate till you're clean on the sidewalls? It's a contradiction in their assumptions. They've assumed excavations, the remedial assumption at all these sites, and they put 8% into in situ remediation. That's a contradiction in itself. They use an extra inflated number for in situ remediation, yet they assumed that all sites really had excavation, and they assume that we should be excavating, including to the point that we dewater the excavations in order to dig. The monitoring periods, we talked about that for post remediation, are really long. It doesn't make sense to remediate or to do monitoring of groundwater really long if you're requiring excavation to the extent that they are, and the source removal and smear zone removal and over excavation of naturally occurring background materials to the extent that they do, that you would have a plume remaining in the groundwater. So it's a long assumption about how much time it takes to clean up groundwater. We talked about the dewatering already. Here's an easy one, that they assume source wells for installation of groundwater assessment, but they won't let us backfill excavations in order to put in source wells so that we can see what the groundwater looks like at the source area, as opposed to just immediately down gradient. So that's another contradiction. The reclamation time of 2 years. If we told our landowners that they weren't going to be able to grow plants for 2 years because we're reclaiming the surface, they would have our heads. That growing season is literally a couple of weeks when they plant, and they start crops growing right away. So to say you've got to monitor revegetation for a period of 2 years at most of these sites when they're in agricultural fields, it's an absurd assumption. And overly elevates the amount of reclamation costs for a given remediation site. And then again, the NFA for the SAC 811, I think it's appropriate to have granted that NFA. I think the data support the granting of an NFA, but I also think that it's valid at the other SAC sites with similar site conditions. And for that matter, I could probably come up with a list of 40 other sites with similar concentrations to what the SAC 811 has that should also be closed, but have not been approved by the ECMC.
Thank you for that. And with that comparison of some contradictions in ECMC assumptions, I believe I'm concluding my direct examination of Mr. Peterson. Reserve his testimony on redirect, if any, and for rebuttal.
All right, thank you for the testimony. I believe that this witness is up for cross-examination by staff and then the other lawyers. Mr. Boudreau.
Thank you, Chairman Robbins. I was wondering if staff might have 10 minutes to meet with my client so that we can get our thoughts together for cross-examination.
Yeah, that's fine. Let's just take our afternoon break. Let's return at 3:20.
Thank you.
All right, this is the Colorado Energy and Carbon Management Commission. It is 3:20 on October 24th, continuing docket 230400117. At this time, Mr. Boudreau, I believe you are entitled to initial cross-examination.
Thank you, Mr. Chair. Hi, Mr. Peterson. Are you aware that KPK had a number of responsible party actions before this commission?
Excuse me, Mr. Peterson, I believe you're still muted. And I also think that the webcam is not the one that should be activated.
Yeah, I'm not sure what's going on with that, but I can try and look towards this computer.
The laptop camera, go ahead and do that. If we can get more direct eye contact, that'd be great. Thank you.
Okay.
Sorry for the interruption, Mr. Boudreau and Mr. Chairman.
Yeah, let's go ahead and start over. Repeat the question.
Thank you, Mr. Chair. Mr. Peterson, are you aware that KPK had a number of responsible party actions before the commission?
Not specifically, no. I know of sites where we are claiming other responsible parties, but I don't know where those are at in the process of finalizing or getting a determination.
Thank you. I'd like the commission to take administrative notice that KPK recently dismissed a number of responsible party actions, including docket number 220-20009, another one for McCallum 220-200-032, North Quebec 220-200-028, Hines 220-200-031, Suckler Brown 220-200-030. Mr. Peterson, I believe you testified earlier that staff included a number of sites in Exhibit 10 for which KPK says it's not responsible. Is that accurate?
I don't know that I said that. I'm not sure what you're asking. There are sites that we have open that KPK is not responsible for, but I don't know that was part of my testimony.
Can you list out those sites, please?
I don't have the list in front of me of all the sites that there are other operators, but
do you know how many there are?
I can think of two off the top of my head.
And what are those called?
The Boxer and the SAC 1 tank battery.
And who has the list of sites that KPK that staff included, but KPK says they're not responsible for?
I'm not sure what you're asking. We have a list of all the sites that the ECMC has a list of.
Earlier, your attorney suggested that it was unfair for staff to include those locations, but KPK has no pending applications to hold third parties responsible. Isn't that right?
Are you talking about the opening statements about Boxer?
I'm talking about your testimony earlier where you said staff included sites that you thought were inappropriately included because there are other parties responsible for them.
No, I said they included other sites that we didn't include because they didn't have Form 27s. Okay. But if you look at my estimates, if you look at my table for those site assessments or those site estimations for remediation, even sites that we dispute remedial actions or responsible parties for are in there, like the Boxer sites are in my assessment as well as the SAC 1 locations.
Thank you. Correct me if I'm wrong. I seem to remember during your testimony that you'd mentioned a number around in the region of 400,000 per month. Does that sound right?
I just grabbed that off of the amount of remediation costs from the CPA agreement that was on one of the slides presented by others in testimony.
Okay, so that number was meant to represent what exactly?
I understood it to represent the amount of money that KPK had been spending on a per month basis.
To comply with the CPA, is that correct?
Correct.
On a per month basis, correct?
Correct.
So if we were to extrapolate that for a year, what would that bring us to?
4 million times 12, right?
I mean, 400,000 times 12, about 4.8 million,
12, yeah.
Which is significantly more than you estimated for all of KPK's known remediations, correct?
Well, we're talking about the known remediations that are remaining, not the known remediations that have already been remediated. So that $400,000 a month is money that has already been spent on remediation and not remaining to be completed. So it's conceivable that you could have been spending $400,000 a month for a year or 2 years prior, and then only have $3 or $4 million of remediation total remaining. So you wouldn't extrapolate that forward on historical costs.
Do you know how many spills KPK has had since the CPA?
Not the exact number off the top of my head. No.
If I represent to you that it's 72 new spills, would that sound about accurate?
Yeah, it sounds accurate. It's a rate a little bit slower than I think other operators have.
Thank you. I believe you also testified that it's not unreasonable for KPK to be able to excavate 1,000 cubic yards per day. Is that right?
That's correct. Well, not KPK. My assumptions are based off of assuming a third party would do the remediation, not KPK, because we're supposed to estimate that the ECMC would be performing these remediations, not KPK internally. So
thank you.
Yeah.
Do you know whether KPK was performing excavation and removal at the 3 Farms site yesterday?
They were.
Do you know how many truckloads were removed from the 3 Farms site yesterday?
I have not been informed on that yet. No.
If I represented to you that it was 2 truckloads, would that sound about accurate?
That sounds about all. It sounds about all the remediation that was required at that site remaining. So 2 truckloads is probably right.
How many cubic yards is that?
About 20 yards.
How typical is it for KPK to actually excavate 1,000 cubic yards per day?
I would say it's not typical for us to excavate 1,000 cubic yards today. I'm just in my assessment of 1,000 cubic yards, I'm trying to establish the rate on what does it cost for that operator to take a backhoe and dig a yard of soil, not what does it cost, what rate does KPK perform it at? I'm trying to establish a unit rate for the act of excavating.
But it's a rate that, it's an excavation rate that KPK doesn't regularly achieve. Is that right?
Well, if we were using a third party that lined up 1 million trucks and we had the ability to excavate at that rate, we could meet it. Certainly a third party would be able to remediate that at that rate if their sole job in life was remediation. As a consultant, I've hired excavators to remediate soil, and if you're in the job of digging soil and disposing of contaminated soil, you can do that that rate of digging in a given day, especially when there's no utilities, there's no surface use to worry about, and you got wide open spaces. It's not hard to dig 1,000 yards. I mean, each bucket load of dirt can be upwards of 5 yards, so doesn't take that many grabs of soil to hit 1,000. Okay,
but what I'm asking about is what does KPK actually do, not what could they theoretically be done with 1 million trucks? So 1,000 cubic yards a day is not typical for KPK, is that right?
It's not typical for KPK, but it might be typical for a subcontractor that ECMC would employ as part of the financial assurance implementation.
Thank you. That's all the questions I have on cross-examination, Mr. Chair.
Okay, thank you. Any cross-examination, Mr. Sura?
Yes, briefly. So, Mr. Peterson, towards the very end there, you were talking about the staff's assessment of the $45,050 for per acre for reclamation. Is that right?
Yeah.
And did you say, and I want to make sure that I didn't misunderstand you, did you say that seemed about appropriate given the fact that a lot of your locations are less than an acre in size?
I think if you look at our $7,800 of reclamation per location, if you multiply that out, we're just under 45,000. Maybe it's a little bit lower.
If I could just share my screen with you.
I hear what you're saying. The number itself, I think, is on the conservative side, because I've looked at other operators' estimation of reclamation costs upwards of about $20,000. So I think it's still a high number.
So this is the different 18 sites that you have and the tank battery acreage that you claimed, and this is the estimated reclamation cost for those tank batteries. Does that look about right to you? And I can send this to your attorney as well.
I may ask what the source of this table is, Mr. Sura.
Thank you. The source is Exhibit D, your own Exhibit D.
Thank you.
Yeah, if these are what we provided you, then that's accurate. I mean, what we're finding as we have spent more time looking at the actual site area that requires reclamation, that these acreages are overestimated, sometimes by a factor of 2. So,
And so you stated initially that you thought that $45,000, may be reasonable, and then you said maybe that's an overestimate because it might be more like $20,000. Would it be surprising to you that you're looking at an average of just about $10,000 an acre for reclamation costs, according to your own acreage and your own assessment?
So it's a difference of about 25%, roughly.
Yeah, you're 25% of the 45,000 is correct.
Yeah, those don't. Yeah, that seems all right. I think the unit rates that the ECMC used are overinflated because of the scope of work that they put into the reclamation, and the assumptions made into that unit rate are overinflated as far as what's required.
Okay, so you're changing your testimony now. They're no longer reasonable. They're overinflated. I appreciate it. I don't have any further questions.
Okay.
Object to the argumentative question at the end. And it mischaracterizes the witness's prior testimony.
I'll let you address that and redirect here in just a minute. Mr. Lewis Prescott.
Thank you, Chair Robbins.
And before we go any further,
get that taken down.
Yeah, let's take that down. There you go. Thanks. Okay.
Good afternoon, Mr. Peterson. Started at KBK in May of this year, correct?
Yes.
And how many remediations has KBK completed since you started in May?
What do you mean by completed?
Approved by the ECMC.
Well, there's lots of remediations that happen during the Form 19 process that don't require ECMC approval. So I'm not sure what you're asking. If you're asking how many sites we've performed remediation on in the 5 months that I've been here.
I can rephrase it. How many sites have been remediated and reclaimed since you started?
To where we get site closure?
Correct.
None.
You testified that KBK has had many Form 27s denied by ECMC staff, right?
Correct.
So in those situations, ECMC staff is not agreeing with the proposed plan for remediation that KBK is putting forth, right?
I would disagree. I don't think it's disagreements about the proposed plan. I think it's disagreements about whether or not we've answered their condition of approval or answered a question that they posed exactly, or that we used a word that maybe they didn't agree with. For example, I had a Form 27 denied because I didn't include the words capillary fringe when I talked about that we were planning to excavate the Vados zone. So these are the types of reasons that we get forms denied. It's not about the remedial approach very often.
Sure. So anecdotes aside, you've had many Form 27s denied in your 5 months.
Objection. The anecdotes aside, mischaracterizes the witness's first-hand knowledge response.
Can you rephrase, Mr. Lewis Prescott?
Sure, Mr. Peterson. So back to the question. KPK has had many Form 27s denied for various reasons, right?
Correct.
And some of those reasons, in your opinion, are for grammatical errors. Some of those reasons may be because the remediation is simply not able to be approved. Is that fair?
I would say they're not able to be approved. They're being denied for one reason or another that aren't really substantive to the remediation approach or our desire to get to closure.
So it's a disagreement between how KBK wants to get to disclosure and what ECMC sees as necessary.
It's a disagreement about what approaches are most effective. It's a disagreement about what compounds are naturally occurring and what compounds are a result of KPK's operations. And it's a disagreement about the terminology that we're using or the misunderstanding of questions, particularly conditions of approval that we believe we've answered, that they deny that we've answered. And so we're arguing about or debating about answers to questions that we think we've answered and they think we haven't.
Thank you, Mr. Peterson. I think we got there, and I think it's a lot of what we've seen today in staff's presentation versus KPK's presentation, and a difference of what the different parties believe is necessary to complete a remediation correctly under the rules. So my question for you is, if KPK is submitting proposals for remediation and attempting to remediate based on a plan that's not approved by the ECMC, how can we accept your estimates of what remediation will cost?
Well, they're not just rejecting my approaches, they're rejecting the industry's standard approaches. I'm using consultants that work for other operators that are proposing similar approaches, similar estimates of costs for remediation, and those are being rejected for KPK, but not for other operators. So I'm not sure I understand your point.
Well, I'm trying to understand your point, and it sounds like your point, and correct me if I'm wrong, is that ECMC is simply picking on KPK. Is that your position today?
I don't know if it's picking on, but there's certainly a level of discretion that that KPK faces that is not mirrored by what my colleagues in this business are experiencing.
All right, and going to your testimony from August, do you recall that?
Yes.
And my notes indicate that you testified that some remediations have low costs, some remediations cost $500,000. What is the highest site remediation estimate that you put into Exhibit S for KPK?
Looks like $209,000.
Okay, so that's less than $500,000. So is your position that remediation for other companies can be $500,000, but of KPK's 100+ sites doesn't get to $500,000, doesn't even get to half of that?
No, that's not my position.
So are you disagreeing with your previous testimony under oath?
No, you said that I said remediations can occur for a low dollar amount and that they can occur as much as $500,000 amount. I stand by that. That's true. The fact that I don't have a site here that meets that threshold of dollar amount doesn't make either false.
And you looked at all of KPK's open remediation sites, right?
That's correct.
What's the longest period that one of them has been open?
Years and years of disagreements about what site conditions are, what natural occurring background site conditions are, what level of responsibility KPK has. So it's a variety. Some are open for several months where we're able to clean it up and close, and some are go for several years where we disagree and debate the science and the site conditions.
But you haven't had any closed since you started, so it's not really a several months situation for KPK, is it?
Well, under normal circumstance, it would be. I think that many of the sites that we're proposing right now have no further action requests. We believe the site has been remediated to the extent of the rules, but we are in disagreement with the state. So if you're asking if I think there should be more sites closed, I think yes, because we have done quite a bit of remediation. We disagree with the science about what remediation remains.
So again, going back to the figures that you came up with, those are based on your understanding of what remediation requires. Is that right?
They're based off of my experience in the business, what I've seen other operators do, what I've seen in this business performing this type of work for other operators. Yeah, I think it's
confirm. I think you said this already, but just confirm that that's based on what ECMC would have to pay contractors to complete these remediations, not KPK's internal accounting, right?
Yeah, that's what we were asked to do, report or assign costs, assuming that KPK wasn't doing the remediation.
Thank you, Mr. Peterson. Nothing else.
All right, as is normally the course, Mr. Jacobs, I believe we would have commissioner questions followed by redirect on your part. Are you comfortable with that approach?
That's fine, Mr. Chairman.
All right, commissioners, this witness is open for questions. Commissioner Messner.
Thank you, Mr. Chair. Mr. Peterson, I wonder, one of the first notes I have here is about your qualifications, your resume. And you indicated that you worked for then COGCC as a consultant for a time. Am I correct there?
That's correct.
And it looked like, although I haven't gone back and reviewed your resume, I just looked at what was on the screen. So I may be incorrect here, but correct me if I'm wrong, but you've not worked as a consultant for COGCC since 2020?
2012.
2012, okay.
Yeah.
And at that time, the mission of COGCC was to foster oil and gas development, is that correct?
I'm not thoroughly versed on the mission of the COGCC, but it sounds correct.
Okay. And currently, the mission of the Energy and Carbon Management Commission is to regulate oil and gas for the protection of public health, safety, welfare, the environment, and wildlife resources. Are you familiar with that?
Yeah, I believe those same types of protections or desires were in the original commission's mission as well, to protect human health and the environment.
Yeah, and the legislature has given ECMC the statutory authority to regulate oil and gas in the state. Is that correct?
I don't know. I'm not a lawyer or an expert on legislation. So.
Okay. Well, I guess my question to you then, based on your testimony, which I have to be honest, at times I found very arrogant. But do you believe that ECMC rules apply to you and your client?
My client, I'm not sure.
Are you and your employer, sorry, not your client?
Yes, absolutely. The ECMC rules apply to KPK.
All the rules?
Absolutely.
Okay. And so do you think that in applying those rules that they were designed to be a negotiation between you and ECMC?
No, I do not. I think the negotiation piece are built into the rules when it comes to background conditions, and that those are established by the operator. And so you have to negotiate background conditions because
but the final authority is ultimately going to lie under the statutory authority of the ECMC. Is that correct?
Correct. And those authorities can be challenged based on science. And that's what we're attempting to do.
Sure. And there's avenues to do that, but you're not doing that here today, are you?
It's always our practice to use good science. So I'm doing that today. I do it tomorrow. I'm constantly trying to use good science to get to the correct answers and to achieve the compliance with the rules.
So are you indicating then that only some of the rules apply then, just based on your opinion?
No, I am not indicating that at all.
Okay. That's the only questions I have right now.
Further questions, Commissioner Cross?
Thank you, Mr. Chair, and thank you, Mr. Peterson, for your testimony today. I want to first touch on you responded to a question from Mr. Lewis Prescott about some closures as he was kind of getting into that issue, and you said there's also some Form 19s that we have. Would you agree that if a Form 19 is out there, it is a known remediation?
It's a known remediation, but it's not what's in the rule as far as the financial assurance.
Are you a lawyer?
No, but I've read the rule and Form 19s were included. So I'm not necessarily disputing Form 19s or Form 27s. All I'm just telling you is the estimates that we made. We had the Form 27s originally, and we went back and added those Form 19s. So there's not a dispute on the inclusion or the exclusion, only from the standpoint of the rule applicability, which that's not my area of expertise.
So your area of expertise is not whether a Form 19 should be included at all.
Correct. I'm based on my understanding on the rule and what my direction was by council.
Okay, and so my simple question then is, if a Form 19 is out there, it's a known ongoing remediation.
Yeah, if you have a spill, it needs remediation. Yeah.
I'm going to talk about some of the assumptions that you talked about that staff put forward. The first of which is you had a lot of concern with some of the cost breakdowns. And would you agree that Mr. Duranlo's assumptions, as he put it during his testimony, were based on the Colorado Division of Oil and Public Safety reasonable cost guideline rates?
Some of the assumptions that they made were based off the OPS rates. Yes, that's what they stated.
And do you have a serious concern with the rates provided under this reasonable cost guideline rates?
Yes, I think I raised those objections in my testimony.
And so the basis of your objections to the use of these rates is that you think you can get better rates.
I think they're overinflated for its application. I think that the state has a great database of applicable rates for the industry that they're regulating and the sites that they regulate. To go outside to an uncomparable type of remediation site, only that they are similar in contaminants, that they both have petroleum hydrocarbons, seems unnecessary and misguided, because those site conditions, the site parameters and remediation approaches for those sites are different than what you might do at an EMP site.
I think it would have been more appropriate for staff to reach out to numerous contractors to determine what an appropriate overall remediation cost would be for 146 different sites in preparation for a financial assurance.
No, I think that it would be more appropriate for them to query their own database of of recommended remediation costs that operators provide on a regular basis in Form 27s.
If we could, Mr. Jacobs, if you could have your associate pull up, I believe it was slide 12 from your presentation. I hope I have that number right. I believe it was talking about the assumptions with respect to in situ remediation. So I was a little confused during some of your testimony here. So the assumptions provided with the staff exhibit 10 talked about in situ remediation. And for example, the first bullet says that there can be technical limitations on excavation that make it unsafe. And yet your attack on the assumption was that excavations can be unsafe.
What's the question?
I'm curious as to why you have an assumption talking about excavations can be unsafe when their own in situ remediation assumption is that excavations may not be able to be conducted in a safe manner. So I'm curious as to why the attacks on excavations here when staff is also saying excavations can be unsafe.
Yeah, I think the point that I'm making is that the state has assumed that we would be doing excavation to a grand extent. And what I'm saying is that excavations aren't always safe, just that they have. And so they have said that excavations are what needs to be done in almost all of these circumstances. But there are situations, site conditions, as well as contaminant locations, mechanisms for transport, soil type, that don't make excavations the right approach. One of them, which is safety of excavations greater than 20 feet. So if your plan is to excavate deeper than 20 feet, I would say that's an unsafe assumption that you would want to choose another method of remediation besides excavation.
So, and I want to follow up on a couple of your parts of your response there. You said, I believe in grand amount or something like that is what you just said with respect to what they want to do with excavations here. But didn't you also testify that the amount of in situ remediation that ECMC is requesting is actually far greater than what's normally done?
So there's the definition of in situ remediation that both KPK and the ECMC is using is specifically isolated to active in situ remediation as opposed to passive.
So you have a concern that staff wants to do more excavations than in situ remediation, but you also criticized the amount of in situ remediation that staff proposed as part of their costs.
Yeah, and it sounds contradictory, but it's not. If you were proposing a remediation that's in situ, and you got rid of source removal and you were doing some monitored natural attenuation of the remaining contaminants, you wouldn't necessarily put in an in situ type system, and you wouldn't necessarily go excavate more soil. So both of them can be true in those circumstances.
Okay. And what is your response to Mr. Duranlo's testimony that although 9 of your Form 27s have proposed in situ remediation, you're only proposing in situ remediation in 2 of those situations?
That's because my experience has been in the last 5 months that any effort or request or intention to collect site data to investigate whether in situ remediation would be appropriate have been denied. And so
it's not a matter of what you've proposed and working off what you've proposed. You just assume that it's going to be denied, and so you're not using that as part of your calculation for what a remediation would actually cost.
Yeah, I have to go off the precedent that's been occurring the last 5 months, which is keep excavating, continue to excavate, and any data collection or attempts to not excavate or to question whether or not excavation is the appropriate remedial solution are met with denial or resistance or disapproval.
Okay. And then if we could look at, I believe it was slide 26, as you started looking through some of the specific sites. Maybe it was slide 25 where you started looking at the specific sites. So I just want to make sure that I understand some of your arguments here. So with respect to the ACNO2 site, you said that the estimate from staff is almost $80,000. The estimate from KPK is $1,200. Is that $1,200 that has already been spent, or $1,200 that you anticipate spending additional?
$1,200 to spend additional.
And what would that $1,200 include?
The laboratory analysis of the samples that were recently collected, and the reporting.
So under your position, this site is done. It's just a matter of making sure that the analysis comes in as clean.
Correct. And I'd also argue it was never a reportable spill to begin with.
Okay. And then I want to look at the next one, slide 26, the Greeley National Bank B number 1. So this again, the $16,000 is moving forward, not what you've spent on it, correct?
Correct.
And you said it has 5,500 cubic yards of soil excavated. Do you anticipate more soil needing to be excavated or not?
No, this site's been backfilled. I don't anticipate digging any more soil.
Okay, and so what is the $16,672 consist of here?
According to the ECMC, I need to go advance more soil borings to demonstrate that the groundwater data I have presented is valid.
So you think it's just soil borings and again laboratory analysis here?
Yeah.
Okay. And then I want to talk about and I know I'm gonna mess it up, so I'll just say slide 28 here, because I don't want to mess up the name of this site. But this is the one where you said you think it's actually more likely to be a different operator or a different source is the contamination here. Is that correct?
I didn't assess a likelihood on who was the source. I said that we don't know the source of that contamination.
Okay, and so for this one, is this one another one that the remediation has been done? What is the 18,000 made up of here?
No, that's the cost to go determine if we indeed have a release at one of our sites. So we're compelled to go confirm or deny the presence of a release just based off of some contamination that was identified in a well put in by the city.
So for here, the ECMC is saying $220,000 to remediate the entire site. You're just saying the $18,000 is to determine if there is actually remediation that needs to be done.
Yeah, I don't know how you could develop a remediation cost estimate of $220,000 with one data point and not knowing anything about where the source is, the direction of groundwater flow, the site's physical parameters, whether or not there's a source area that's attributed to KPK. I don't know how you would estimate that dollar amount with one data point.
Okay. And then the one other question I want to ask about, and I believe it was slide 10 if you want to pull it up, but I don't think it's necessary. But it was talking about the $200, and you said $100 per sample there. Was that $200, did that include the actual gathering of the sample, or was that simply the analysis that was $100 per sample?
That's the analysis, but I said the time to sample a well is less than an hour at $70 an hour. So you're talking less than $180 per sample for groundwater.
And the ECMC estimate was $300?
$305, I believe.
Okay. And was the testimony from staff that the laboratory and analytical costs were taken directly from a competitively bid ECMC contract with an accredited laboratory?
They said they were from a accredited laboratory that they use and have a contract with.
So really your dispute with the testing done there is just simply that you found a better price.
I'm disputing that their costs are overly inflated. And so when they come up with one that's 308 and I come up with a third party cost that is 180, I think that's a big differential when you're looking at unit rates that get spread across 146 sites.
Okay. And then one final question for some of the remediation activities that have been performed thus far on some of these sites. How much of that has been done by KPK's subsidiary?
Nearly all of it.
So the prices that you're talking about, the amounts that you're saying, are all based off of a KPK subsidiary that can do it for less than perhaps.
No, I was told to cost them at third party costs, assuming that KPK was not performing the remediation.
So the overall cost that, for example, that Mr. Lewis Prescott was talking about, the $400,000 per month, or perhaps the $7.2 million that was spent on the CPA sites between November 2021 and January of 2023. That's something that is not based on KPK numbers, but that's all something that's based off of third-party data.
There's a combination of two. I mean, KPK was hiring subcontractors as well as doing some work internally. So it was both of those things were occurring, and that number is reflective of remediation that KPK has done up until the compliance plan agreement was terminated.
Okay, thank you. No further questions.
Commissioner Ackerman.
Thank you, Mr. Chair, and thank you, Mr. Peterson, for being here today and for your testimony. Along a little bit of the same lines, but a little further clarification. First, I wanted to touch base on the forms. A couple of times during your testimony, you stated that some forms seem to be remitted for no cause. Could you clarify that a little bit? When a form is returned to you and you deem it to be for no cause, what's that conclusion based on?
Where they put no conditions of approval on the form denial, and we don't have any other communication from them about the reasons for the denial.
So there's just a form denial with no notes or no follow-up?
Correct.
And what do you do with those forms once you've received those?
We reach back out to the ECMC to try and understand why it was denied.
And are you generally able to get clarification on the denial reasons?
Yes.
And when you do that, does it still appear to you that it's for no cause?
No, obviously they have a reason for what they do. I don't necessarily agree with those reasons. But we have to go elicit that once we get the denial. In the case of the like the sack cheese, where they just said they denied it without review, it seems unusual to me to be able to do that. It doesn't help us really get to the issue, which is discussing and coming up with technical arguments or technical approaches that make sense for everyone, or understanding the technical data in the same way. We don't get that far.
Thank you, Mr. Peterson. I appreciate that clarification. I think that it's helpful to understand that there is dialogue that takes place, and I would agree that that forms returned would hopefully have some further data with them. But I'm glad that you're able to get clarification on all of those, given that there's a significant workload associated with the remediation that you all are doing.
Yeah. Can I just clarify that a little bit?
Of course, if I misstated you.
No, the communication between KPK and the ECMC gets it's very limited in lots of cases. In my experience working for other operators, there's a lot of discussion with the ECMC offline about the approach and what we're planning on doing and getting clarification. In the case of KPK, those discussions aren't allowed. Everything must go through email or through the forms itself in writing. And so I'm left with a position where I'm being asked to go bring them a rock, for lack of a better analogy, bring me a rock. And I go bring a rock, and they're like, well, that's not the right rock. And so I have to go back and bring another rock. And there's not really discussion or even support or clarification that allows me to get answers from them about what type of rock they're looking for. When I ask those types of questions, the response is, that's not for us to decide, that's for you to decide. And so that makes it very inefficient to communicate and provide documents to the state that can ultimately be approved, because we don't have that dialogue or that benefit of really trying to understand what it is they're asking for and us being able to provide it.
Thanks for that clarification, Mr. Peterson. So to make sure that I understand that point, when you get responded to from staff, they expect you or your firm to have the expertise to bring science or examples or remediation that would ultimately comply with the rules.
Correct. And then when it's denied,
they're not necessarily prescriptive about that.
no. And when we try to ask them for some more clarity, because we're getting denial of forms, when we're not sure exactly what it is they expect to see, we make a guess as to what it is they expect to see, and they say, no, that's not what we wanted to see. And so tell me what you want to see. And it's like, well, that's up to you. It's not very effective. It's not very efficient communication and collaboration as far as trying to get sites closed.
Understand your point. Thank you. One more question about the forms. Does KPK submit forms, or have they submitted forms that are approved?
Yes. Actually, we started to get the most approvals that I've had in the last month and a half. Have been more approvals than the last year combined.
Thank you, and that leads to my next question. Can you kind of ballpark the percentage of forms currently that are being approved versus not approved that KPK sends in?
I just did this recently on a flurry of sites that were approved versus not approved. And it worked out to be like of the 16 forms submitted, 4 were approved and the other 12 were denied. But there was a trend along those denials and approvals. The approvals were on spill reports where we're denoting a spill. The denials were on proposed remediation. Those we get approvals to add sites and release sites to the docket, and to add Form 27 initials to the docket. But as we're trying to close them out or make Form 27s for supplemental submittals that show we're documenting, those get denied. So we're increasing the amount of sites that stay open with that trend.
Thank you for the further clarification. And then the further action would be for those that are denied, you attempt to rectify reasons if you have them, or follow up if you need to, and then ultimately hope to submit those for approval. Is that generally the process?
Yeah, with the amount of denials we get, we're running through a single report 2, 3, 4 times in order to get something finally approved. And we're using the same consultants that are getting Form 27 approved on a first submittal. So it's just been a frustrating experience.
Thank you. I appreciate that. I want to shift to one final line of questioning associated with the specific figures that you put up on certain projects. And the questions that Commissioner Cross asked and that you answered added quite a bit of clarification for me. It appears that we need to dive deeper to understand that that a little bit apples to oranges on some sites, but other issues on other sites. But I do appreciate specific examples. And you mentioned a few times during your testimony that figures associated with remediation for the purposes of this hearing are intended to be presented as if ECMC would be doing the work. And then when you gave those specific examples, there were ECMC project-wide estimates. And then my understanding was that the KPK estimates were not dollars spent to date, but were rather the estimate that KPK has for the remaining work on whatever specific project was put up. Is that accurate?
Yeah, I think that's what they're asking for, is known remediation costs for the existing sites. So you would want to quantify what's remaining for financial assurance, not necessarily what's already been completed.
Understood. And then the remaining work, even though you might have disagreements with ECMC staff as to what work is remaining, the remaining work that you've estimated there is the remaining work of what you think needs to be done versus what ECMC thinks needs to be done, or just the overall ECMC estimate?
I think the remaining work that we're proposing on is what is standard practice for the industry and for consultants that would propose remaining remedial scopes of work. So I think they're appropriate assumptions as far as what scope of work is remaining. And I think that the ECMC overinflated those remaining scopes of work to inflate the cost.
Thank you. You think they overinflated them using Division of Oil and Public Safety figures? Is that your testimony?
I think they overinflated using oil and public safety figures. I think they overinflated assuming remedial approaches that would not normally be employed. And I think they overestimated on the unit rates for which the work costs.
Thank you for your testimony and responses, Mr. Chair. That's it for me for now.
Commissioner McGowan.
Thank you, Mr. Chair, and thank you, Mr. Peterson, for hanging in until 4 o'clock in the afternoon. So I want to understand the updated numbers that KPK turned in and the 2.89, I think, for remediation. And those are based on what you all estimate remains in open form 27s. Does it also include form 19s or just the open 27s?
19s and 27s.
19s and 27s. Okay. So did
If I
you
may,
go ahead?
I apologize. 2.9 million, Mr. Peterson, I believe you previously testified, was limited to approved Form 27 locations.
Correct. I misanswered because in those all those sites with Form 27s have Form 19s associated with them too. So I did review those Form 19s with those Form 27s, but the sites without Form 27s were not included in our submittal. So sorry about that.
Yes. Okay, I was just making sure I was understanding. So
Interruption.
no, thanks for clarifying. So if you, I'm sure that you were listening to staff this morning and their desire to make sure that all remediation projects were included. And I'm wondering if you were thinking about that even before staff testified today, and we're thinking about a back of the envelope, how that would change the 2.89 number in your mind.
Well, we did the analysis without or including the same sites that the ECMC did. I think the difference is the dispute as far as which bucket those numbers are supposed to sit in, according to the rule.
So maybe I'm misunderstanding. I was under the impression that your number only included the approved Form 27s. Staff's number includes sites which may not have a Form 27 yet assigned to them.
Correct, but we went through and added that other number. So if we go by what we believe the rule says, we had a number of 2.9 million. If we include the Form 19 sites, it's 3.9 million.
Got it. Thank you. Somehow I missed that. Thank you for the clarification.
Thank you, Mr. Peterson. That was a question that I wanted to ask you about as well. Let me ask this question, and Mr. Jacobs, this may be for a different witness, but I don't want to miss out. I believe KPK's position is that those sites that are subject to a responsible party application, or whatever we call it, that those should not be included in the remediation analysis. Mr. Jacobs, did I get that right in terms of that's the perspective of KPK?
Yes, that was part of my opening statement.
Okay. How many, and I got confused, but how many sites are subject to a responsible party application and should, in KPK's perspective, thus be removed from the equation?
You're asking me that question?
I'm asking either one of you at this point.
That if I may, Mr. Chair.
Go ahead, Mr. Jacobs.
And I'll try to be brief. We referenced 3 locations in my opening statement, the last of which is the Guadagnoli site with the one monitoring well detection by the town of Frederick. And no other evidence of causation or source. And my point there is, if you try to include that in financial assurance, you're now obligating an operator deemed responsible based on that one data point and no evidence of causation to post, in this case, $220,000 for the financial assurance. And we think that violates due process.
Yeah, I understand the argument. I'm just trying to get a sense of what are the
have a list of additional sites beyond the three I gave you. And to, I believe, another commissioner's questions, or rather, Mr. Boudreau's cross, we withdrew without prejudice to refile the pending responsible party applications because those were driven by the requirements of the CPA, and this commission has terminated the CPA. It does not mean we've waived responsible party defenses, but our priority is, keeping our operations going, remediating sites, and meeting our financial assurance obligations. We will eventually get back to responsible party issues, but there's no CPA deadline that is operative currently.
Okay, thanks. So again, I think the answer to the question is there's 3 locations right now that ought to be removed from the remediation analysis. And it's the Guagnoli, and then what were the other 2 names, Mr. Jacobs?
North Quebec and the Boxer tank battery and salt.
That's right. Boxer tank. Okay.
Those were the 3, actually 4 if you consider that Boxer is 2 locations.
Okay. And then you answered Commissioner McGowan's question that if you include the Form 19s that don't have Form 27s, that's another $1 million. Could you, and I don't need this today, we're not going to get finished today, but could I get an enumeration of the sites that only have the Form 19 and don't have the Form 27, just so that I've got that in my notes? So like, I know the sum total is $1 million, but I'd like to know what sites staff is being over-inclusive from your perspective. And if that's somewhere in the pleadings, just point me to it.
If I may.
Yeah, go ahead.
It's the difference between the 146 locations in Exhibit 10 and the 109 locations in Exhibit S of KPK. And those are all listed in those spreadsheet exhibits.
Okay.
The delta is the 40 or so sites that were excluded in Exhibit S and the $2.9 million.
Great, thank you. No more questions for the attorney. Appreciate that. So at this point, I think commissioners have asked all their questions, and if I've got my order of play right, Mr. Jacobs, you're up for redirect.
Thank you, Mr. Chairman. Mr. Peterson, do you recall, I believe Mr. Sura put a table on the screen in screen share, and I believe he identified it as KPK Exhibit B. I'd like Mr. Killian to actually put KPK Exhibit B on the screen in screen share mode. And if you'd scroll forward, there we have that Exhibit B that's labeled. And I believe he also indicated that the average of those reclamation costs was slightly in excess of $10,000. Do you recall that?
Yes.
And do you also recall that Deputy Director Cuthbertson indicated that based on Orphan Well Program experience that Northeast Colorado, Weld County, typical locations, smaller locations like KPK's ran $8,000 to $10,000 in reclamation costs?
Yes, I recall that.
And would the average based on this Exhibit B approximate that range?
It looks like it, just looking at those numbers in quick math.
Very good. Thank you. Just one other question. Well, a couple of questions, but related. You've got 30 years of remediation experience prior to coming to KPK and addressing all of these sites for KPK, correct? I'm sorry.
Trouble hearing you because fire engine.
Yeah, sorry about that. Let's pause for just a second. We've got a fire engine going by. I'll try to speak up as well. I believe we covered that you've got 30 years of remediation experience in Colorado and really other producing basins for major oil and gas companies, correct?
Yes.
And would it be fair to say that the challenge of assuming your position and addressing remediation at these locations for KPK has been challenging?
Very, very much so.
And would it be fair to say that your constraints on communication with staff and the rate of forms denial has been frustrating?
Very much so. I haven't ever experienced it like this before, with any regulatory agency, but also the OGCC or ECMC.
And where I'm headed with this is that I'm concerned that one of the commissioners, Commissioner Messner, indicated that he took your prior testimony as possibly being arrogant, and I want to make very clear, do you have any intention whatsoever to come off as arrogant in your testimony today?
No, and I apologize if my testimony did come off as arrogant. There is a high degree of frustration because the logic and reason that I'm seeing based off my experience in working in this environment doesn't seem to apply when we're dealing with these sites. And so that's the passion that you hear in my voice. It's you know, for my own ego, it's hard to hear that the work you've been doing for 30 years isn't satisfactory when it's worked for every other client except now. It's very, very frustrating.
Thank you, Mr. Peterson. I have no further questions on redirect.
Okay. With that, I believe that we've concluded this witness. Let's procedurally touch base with the lawyers, and we can remove Mr. Peterson from the panel. It's closing in on 4:30. We had set this aside for today. We've still got a fair chunk of, and I'm not saying we're going to stop right now. I just want to touch base. You have 2 additional witnesses, Mr. Jacobs.
I have 1 additional witness on direct and supplemental direct on remediation. That would be Mr. Hines.
Okay. And then we've got case in chief from both Mr. Lewis Prescott and Mr. Sura on behalf of their clients. Looking at this, they've both got 45 minutes outside of questions. I've tried to touch base with my hearings manager. We potentially could try to finish up your case this afternoon, Mr. Jacobs, and then try to come back tomorrow after our morning hearing. We've got a full day set aside for that hearing. I don't think it's going to take a full day. We could probably start back up at 1 or 2. And I'm just touching base right now before we get to the end of the day. Assuming that we can get through this final witness today, does that work for the calendars for the lawyers in the room, Mr. Jacobs?
It works for KPK witnesses and counsel, yes.
Mr. Boudreau?
Yes, Chair, that works for me and any witnesses we might call in rebuttal.
Mr. Lewis Prescott?
Does work for me. I believe my witnesses are listening. I'll ask them to email me if it doesn't work for them, but I suspect that it will.
That's why I'm having this discussion now, as y'all can reach out to your witnesses so we can know by the time we close today. Mr. Sura?
I'll need to do the same. Thank you.
Okay, well, if you guys could go make that check-in while Mr. Jacobs brings up his last direct witness on remediation, then we'll touch base. Does anybody have a hard stop at 5? I don't want to go too much past it, but I'm just want to see if we can get this. Okay, Mr. Jacobs, with that, if you want to call your next witness.
Thank you, Mr. Chair. Just waiting for Mr. Hines to appear on video from our witness room. It'll be just a moment.
Yeah, there you go.
Okay.
Mr. Hines, can you hear us?
Yes, can you hear me?
We can, thank you. I'll proceed, Mr. Chairman.
Very good.
Mr. Hines, good afternoon. Would you please state your name and current employment for the record?
My name is David Hines. I'm a principal engineer at Ramball America's Engineering Solutions.
And what is your area of expertise?
I specialize in investigations and remediations on a variety of sites across the country under various state and federal programs.
Could you briefly summarize your education and work history for us? And I believe that our screen share will show your resume here.
Sure. I have a Bachelor of Science degree in civil engineering and a Master of Science degree in civil and environmental engineering, both of which I obtained at the University of Missouri-Columbia in 1990 and 1992, respectively. I have 30 years of experience in consulting. I'm a licensed professional engineer in Colorado as well as in Wyoming and Missouri.
Your resume is their KPK Exhibit SS, correct?
Correct.
What experience have you had in your career that supports your testimony as an expert on assessing background metal and inorganics concentrations in soil and groundwater to establish cleanup standards at remediation sites and to delineate the scope of appropriate remediation?
I have significant experience in subsurface investigations, remedial actions, both within Colorado and across the country. A substantial number of sites of those are either mining sites or mining related sites where the investigation, remediation, establishment of background were critical to those projects. I have published and presented on a variety of topics, including Superfund sites as well as mining sites.
And you provided a similar expert testimony to this commission in January of this year at the last KPK substantial compliance hearing, did you not?
Yes, that's correct.
Can you please tell us the purpose of your testimony today in this financial assurance hearing?
Sure. I'm testifying on behalf of KP Kaufman Company. The purpose is to discuss how background metal concentrations in soils are used to establish cleanup standards at remediation sites, and specifically how background has affected some of the remediation at remediation cost estimates that have been prepared by staff as well as KPK. I've relied on information provided by ECMC, their rules, as well as guidance from EPA and the Colorado Department of Public Health and the Environment, CDPHE. My testimony is based on my professional opinion. I've used ECMC's exhibits as part of my evaluation to look at those cost estimates as they relate to specifically to background.
Thank you. Can you briefly explain why it's important to evaluate and properly characterize background concentrations of naturally occurring constituents at remediation sites?
It is critical. It's critical to understand natural background concentrations at remediation sites, because then it helps you define those boundaries of remediation. If you don't have that, then you just have to continue to dig and dig and dig, like Mr. Peterson mentioned. It allows you to differentiate between what is naturally occurring in the ground versus what is associated with release. No operator, no responsible party, whether it's unrelated to oil and gas, should be required to remediate beyond what is required due to impacts. It creates a lot of additional impacts on sites, creates unnecessary soil disturbances, provides the potential for stormwater erosion, runoff, wind-blown erosion, additional health and safety impacts from trucks, going back and forth from the site, additional air emissions, what I call collateral environmental impacts, air emissions from the heavy equipment doing the excavation, the trucks back and forth from the site, the dump trucks back and forth to the landfill. So all unnecessary when you're digging up what is naturally occurring background.
Does this also impact the time and expense necessary for remediation?
It does. You end up excavating more soil than is required. It takes additional time and additional costs.
Your experience, are naturally occurring inorganic elements in soil elevated in certain parts of the country above state specific standards, such as the table 915-1 standards?
Yes, many states have higher than normal background or higher than what some regulations call for, particularly in Colorado.
Are you familiar with the guidance documents provided by ECMC, CDPHE, and EPA in determining background for inorganics in soil and groundwater?
I am.
Can you please summarize some of the more significant differences between ECMC, EPA, and CDPHE guidance on collecting background samples and establishing background concentrations for purposes of remediation?
Sure. As discussed this morning or mentioned this morning by staff, the COCG, the ECMC rules have a couple footnotes in the table 915-1 where the director may require additional samples to be collected. And it also, footnote 11 says the director will consider the RSL concentrations up to 1.25 times the site-specific background. It doesn't really give direction on how to calculate that site-specific background, the number of samples to be collected, the distance, depths, those types of things. So it's left up to the operator, as John was recently mentioning, to come up with that, submit it, and then hopefully be approved by staff. EPA has direction in terms of where to take the samples just outside of an area of impact, but they do provide direction, some examples of statistical software that is approved by EPA, what they recommend to use. One of those is the Pro UCL software that staff had recommended to be used on soil spread field, but then ultimately denied the use of that. The ECMC rules have no direction on any type of statistical analysis in order to be performed. CDPHE has knowing that the state has higher than normal background concentrations, just naturally occurring background concentrations, they have created a risk management guidance specifically for arsenic. The CDPHE took some 2,700 samples that the EPA had collected across 44 counties in Colorado to look at what the background concentrations are. And as you can see, depending on the land use, it ranged from 3 to 19. So it's much higher than the table 915-1. The state ultimately selected a 11 microgram per kilogram as the average of all land uses. So the state does not require remediation on anything that's 11 micrograms per kilogram or below. So you could build a house, you could build a daycare as long as the arsenic concentration is less than 11.
Thank you. Appreciate that. Have you developed a professional opinion as to ECMC's approach to determining background concentrations and sampling at KPK's locations subject to single well financial assurance?
I have. There's been a lack of consistency in their approach in establishing backgrounds. As I mentioned, they don't specify the number of samples, the distances, depths, those types of things, or the method to determine that, any statistical analysis. At times, they've provided different direction, and so which causes confusion. It's left to the operator to determine what to do. Many times it gets either rejected or rejected outright or denied. And so all that causes unnecessary delays, additional costs, just in amount of time to get to closure. I think John used the right word. It's just inefficient.
Worked on petroleum hydrocarbon remediation sites in the past, Mr. Hines?
Yes, some in Colorado and others across the state, across the country.
Is establishing background as important in Colorado as in other jurisdictions?
Yes, extremely.
And have you done a lot of work in Colorado?
I have.
Are you familiar with background concentrations of naturally occurring metals and inorganics in soil across Colorado?
I am.
What about table 915-1 values? How do they compare to such naturally occurring background concentrations?
They are extremely low. I don't know that there's any soil in the state. John mentioned, Mr. Peterson mentioned in the Front Range, I think across the entire state would meet those 915-1 standards.
Is that particularly for the inorganics, the metals in soil?
Yes, correct.
I'd like to ask you some specific questions about locations for which remediation estimates have been prepared by staff and KPK. Next slide, please. Are you familiar with the Peltier 2 flow line location remediation ID 19278?
I am.
And what can you tell us about that location and the remediation cost estimate there?
Similar to some of the other examples provided, ECMC staff has estimated 145,000 to get to closure. At this site, as you can see in the photo, it was a very small excavation where it was just a couple feet by a couple feet. So a fraction of the amount of excavation that staff has estimated that it needs to be additional removal. The site has 8 groundwater wells, and this comes down to a background issue that all the petroleum has been removed, but it's the chlorides and sulfates that are common in this area. So the background wells show it as well. So I think staff has, or KPK is estimated to close the site out in order of magnitude less, 14,000 in that ballpark.
Thank you. Next slide, please. Are you familiar with the Lawrence Totems consolidation line location, remediation ID 15811?
I am. This was one of the sites I visited. Very similar to the previous site where there is no petroleum impacts remaining. It's a background issue. Staff has estimated over 140,000. Again, KPK is estimated to get to closure to the remaining amount is order of magnitude less than that, like 12,000 in that ballpark.
Thank you. Next slide. Are you also familiar then with the facility 9 flow line location that we're viewing on the screen share?
I am. This was, I believe, Mr. Peterson discussed this one as well. Staff has estimated 150,000 more to get to closure. Again, as this was a pretty small excavation, very small superficial spill from that road crossing, and 50 yards needed to be removed, not 1,000. So it's a fraction of what should be required to close the site up.
Thank you. Next slide. You've heard about the SAC 811 location from Mr. Peterson and from the prior testimony today, correct?
Correct.
Tell us about your understanding of staff's estimate of additional remediation expense at SAC 811.
So here, the NFA was reportedly granted, so it was unclear what the additional costs were for at this site. So it's unclear to me why there's additional costs here. Now that the site may be reopened, that could be why, but it was unclear to me.
And you've been to this site?
I have.
And is this picture one that you took at the site?
It is.
And that shows the hole that was displayed earlier, now backfilled?
Correct.
And that's based on the NFA that was granted?
Right.
Thank you. Next slide. Are you familiar with the SAC G unit?
I am. We visited all the SAC sites in this area. Very small excavation again. All the petroleum hydrocarbons have been removed. So I believe staff estimated 25,000 to complete this. KPK estimated about half that. Similar with the SAC G unit, the site is all but done. Staff estimated 27,000, and KPK estimated about half that.
Thank you. Next slide. And finally, the SAC 711. Were you at that site as well?
I was. This site was very similar. There is a little, I believe they were excavating there yesterday or today to remove a minor amount of impacted soil, but it would be, a couple buckets load similar to what they're doing at 3 farms. So the cost estimate was much less than KPK estimated.
You can expand on why it's important for ECMC to provide clarity and consistency with respect to establishing background concentrations at a remediation site?
Yes, this inconsistency causes delays. It's up to the operator to propose something in the hopes it gets approved. It contributes to over excavation if you don't have a very defined area, understanding background, and it creates additional environmental impacts like I talked before.
Thank you. Mr. Hines, is there anything else that you would like to share or draw on our attention to with respect to your testimony provided this afternoon?
Yes, based on my review of the exhibits that were provided as part of this matter, my previous review of Form 27, my site visit, it just appears that there's a lack of consistent approach in determining background at these sites for arsenic and other inorganic constituents, which causes delays, causes possible over excavation, it causes these collateral environmental impacts I talked about, additional costs, and it just slows the overall process to get these sites closed out. It appears there is some bias from ECMC staff for over excavation, and that is driven in part by this inconsistent approach to background. And that is reflected in the difference in ECMC's cost estimate versus KPK's. It's my opinion that that approach has contributed to that kind of significant overestimation of the remedial expense at many of the KPK locations.
Thank you. Are there other locations that you direct us to consider that reflect your concerns and opinions, but that we do not have time to examine in detail at this hearing?
Yes, in discussing with Mr. Peterson, there's quite a few. I wrote them down because I wouldn't be able to remember them all, but there's the 1415 Corp C Unit 1-2, Anderson Trust number 1, Costlet 6 Wellhead Line, East Iber Consolidation, Facility 7 Consolidation, State 14 Flow Line, Gilson 2A, John Wygant Consolidation, Coke Tank Battery, Milton Nelson, Moser 1A, Morgan A1, Music McClintock 5, Paul Hines, Pete Montoya B1 number 2 flow line, Stromquist 4A, UPRR 43 Pan Am I5, and UPRR 50 Pan Am D1.
And these are sites that are comparable to the ones you testified about more specifically this afternoon?
Correct.
In terms of background concentration.
Background issues causing delays.
Right. And we can provide that list for convenience to the commissioners and counsel for the parties if that would be helpful. With that, I want to thank you for your direct testimony, and I have no further questions for Mr. Hines on direct. Reserve rebuttal and redirect as necessary.
All right, unmuting myself. This witness is available for cross-examination, Mr. Boudreau.
Thank you, Mr. Chair. Hi, Mr. Hines. Thanks for appearing so late. Have you ever been asked to provide a site-specific analysis of background concentrations for any of KPK's known remediation issues?
No.
Has your site-specific analysis, to your knowledge, has ECMC ever denied a form submitted with a site-specific background determination?
I've been told that there's some that have been denied because of that.
So when you say you've been told, you mean you don't have personal knowledge of it?
No.
Are you aware that ECMC is an implementing agency for the groundwater standards and classifications set by Water Quality Control Commission?
Can you repeat that?
Are you aware that ECMC is an implementing agency for the groundwater standards and classifications set by WQCC?
No, I was not aware of that.
Okay. And the reason I'm asking you about this is to get to your discussion about table 915-1, where you say that the standards are lower than what is naturally occurring in the typical soil here in Colorado. So to expand on that, are you familiar with Regulation 41 regarding groundwater protection?
Yes.
Okay. So considering that, doesn't it make sense that table 915-1 is set using soil screening levels for groundwater protection if the pathway to groundwater is complete?
It is, but because the state has such high background, there is room to use other standards, and that's why the Colorado Department of Public Health and the Environment has adopted a different standard for soil specifically.
Okay. Sorry, one second. But does 915-1 have other standards?
It does.
What are those standards?
Well, there's the soil suitability standards in there. There's other metals, but I was specifically asked to focus my testimony on metals.
Okay, thank you, Mr. Hines. No more questions, Mr. Chair, from staff.
Mr. Lewis Prescott?
Thank you, Mr. Chair. Good evening, Mr. Hines. First question, you gave some opinions today.
Yes,
You prepare an expert report related to this matter?
I did for the previous time I testified
You mean back in August?
in January.
Oh, okay, but not with respect to this hearing?
No,
Okay, so the opinions you gave today, you haven't disclosed yet in this case, is that correct?
correct.
Okay, with that, Commissioners, I'll move to strike the expert opinions provided today for failure to disclose.
Check to the motion.
Yeah,
If I
Mr.
may,
Jacobs?
this witness has provided his expert opinions previously to this commission without any refuting testimony. That's known certainly to staff counsel, to these commissioners. His opining on the same and similar issues in this proceeding does not require the submission of an expert report.
Mr. Jacobs, and maybe it's just late in the afternoon and my lawyer hat got turned off about 5 years ago when I took this job. But is Mr. Hines, you've not moved that he be an expert, right?
I believe he is an expert and qualified as an expert. And I've represented that he has expert experience in my description.
I understand that. I just didn't hear the actual moving
for his admission as an expert thus far in this proceeding. No.
Okay. And then Mr. Lewis Prescott, your objection is that was potentially testifying as an expert witness?
Correct, Mr. Commissioner, or Mr. Chair, that was my interpretation based on the background given and opinions given, which frankly were expert opinions requiring sufficient scientific, educational, experiential background. So to the extent those are intended to be given under the rules of evidence, they need to be disclosed, and they have not been disclosed in this case, hence my motion to strike.
And were his opinions previously disclosed, in this proceeding, Mr. Jacobs?
No, they were disclosed in the January substantial compliance hearing, although we did describe generally in our pre-hearing filings, Mr. Hines' scope of testimony. And so there was notice to Mr. Lewis Prescott, his resume indicating his substantial expert remediation experience was provided as an exhibit in a timely manner. And there were no prior objections to either the description of his testimony or his resume.
All right. Mr. Sir, did you want to weigh in? I see you visualized yourself.
Yeah, I visualize myself. We are going to have an expert qualified tomorrow, and his testimony was put forward months ago. My reading is the same as Mr. Lewis Prescott's, that you can't have someone qualify as an expert without revealing that testimony ahead of time.
But I'm not hearing that his testimony today is relevant as an expert witness, unless I'm missing the ball here.
Chair Robbins, if I may.
Yeah, please.
If there's no intention to qualify him as an expert and his opinions are not expert opinions, and are not being given the weight of an expert opinion, then I'll leave my motion standing if and when he is qualified as an expert. So we don't need to go through this again, but I will move on and we can leave this issue open.
I think that's fair. Mr. Jacobs, are you comfortable with punting at this point?
I am comfortable with that and just leaving things where they are and allowing the commission to give the weight that they deem appropriate to Mr. Hines' testimony.
Okay, then let's do that. I agree with that. Mr. Lewis Prescott, did you have further questions?
Just a few. Thank you, Mr. Chair and Mr. Hines. Sorry for the interruption of the questioning here. You talked about flow lines and some specific flow line remediation projects. And I just had a couple questions regarding remediation of KPK flow lines. Is it fair to say that a good number of KPK's open remediation projects involve flow lines?
I'm not sure. I didn't go through site by site, so I don't know which are releases and which are flow lines.
Okay. Are you familiar with KPK's flow lines generally?
Yes.
And some are made of fiberglass. Is that right?
I'm not sure what they're all made of.
Okay. Do you have experience with fiberglass flow lines?
Yes.
And what happens if a fiberglass flow line breaks? Does a spill occur?
Yes.
Okay. And how is that remediated? What steps need to be taken if you have a broken fiberglass flow line underground?
Similar to any other release, you would excavate the soil, remove the source area, and then monitor the site, do an investigation.
Okay. And what happens to the flow line? How do you get that back into utility?
That's not part of my testimony. I don't get involved in the operations side of things.
So you don't know what happens beyond there's a spill here that needs to be excavated, backfilled, reclaimed, and then how the operator goes back to conducting business and production. That's outside of your realm.
Yes.
Okay. Thank you. That's all.
Okay, Mr. Sura, did you have cross-examination?
I don't, Chair, but I would like to take Mr. Jacobs up on his offer to send that list of the locations that are being contested by Mr. Hines's testimony, so I can look over that over the evening.
Yeah, I think that's a good idea for all of us. So let's get that filed if it's not already filed.
We can do that. Thank you.
All right. With that, Mr. Jacobs, we're going to do commissioner questions and then redirect. Is that fair?
That's fine with me, Mr. Chairman.
Mr. Hines, you articulated a number of different locations in which you disagreed with the number that staff has put on it, and you, in most instances, articulated specific different numbers that KPK would put on it. You did not give a number for facility 9 flow line. Do you have a number there?
I didn't. I couldn't recall that off the top of my head.
Okay, and you did not. You did not give us a number on SAC 811. Do you have that information, or could you get it?
I don't. We can get that. I can get that.
Okay, and then SAC 711 did not have a number. Okay.
Okay.
Point being, let's try to get.
Sure.
If we're going to do this exercise, we should have numbers for all of them. Commissioner McGowan, you had raised your hand.
Thank you, Mr. Chair. And thank you, Mr. Hines, for joining us again today. I think I asked similar questions in January when you offered your testimony. Regardless of what you think about our Table 915 standards, are they required as part of our rules?
Yes.
And does the operator have the obligation then to meet those standards?
Yes.
And is there an avenue within our rules for the operator to show background levels that are different than the Table 915 standards and work with staff on cleanup to just the background standards?
There is a way, but it's not very clear. It's very subjective. That attempts to try and determine that background aren't always successful. There is no direction from ECMC in terms of statistical analysis. I know in discussing it with Mr. Peterson, that he suggested doing averages, that got denied. Doing a t-test, which is a common statistical test that I've used on Superfund sites here in the West, that got denied. The ProCL got denied. So it's just there is a process to do it, but it's just not very efficient, and it just causes delays.
So thank you. I think I'm struggling with differentiating between what is necessary for financial assurance versus operator frustration with what we do for remediation projects, regardless of how frustrated an operator is. These are our rules, and those rules must be met. And therefore, we have to figure out what is still left for remediation projects.
Right.
Thank you.
Thank you.
Commissioner Messner.
Thank you, Mr. Chair. Just a couple of questions, because I'm just trying to get to I think in my mind, what the root of the testimony is, but and I don't want you to take this the wrong way. So, but is it your opinion that ECMC staff, associated with these analyses are incompetent?
No, not at all.
Okay. And that many of the staff that are reviewing these things and coming up with these figures and doing these evaluations and analyses have equal to or perhaps more experience than yourself in these type of proceedings, or these this level of expertise around remediation and reclamation. I mean, is that a fair statement?
I wouldn't say that in that way. ECMC staff has more experience on the ECMC sites, on oil and gas sites, but I have significant experience in determining background at other sites.
Okay, but decades of experience from ECMC staff, individually and collectively, over 100 years of experience, in doing this type of work. And with that, is it fair to state that, in looking at ways to remediate and reclaim sites, and remediation specifically here, obviously, there can be different approaches that people with similar level of experiences might take. Is that a fair statement?
It's a fair statement.
Okay. And in doing that, there's not always one correct way or one incorrect way. Is that a fair statement?
No, there's ways that are more efficient, but that could be ways that are more costly and ways that are less costly.
But in the end, there are different ways to be able to accomplish ultimately what it is to get that site reclaimed or remediated to a point that it's safe. Is that fair?
Yes.
Okay. Thank you.
Further questions from commissioners? All right, seeing no further questions, any redirect, Mr. Jacobs?
Just looking over my notes. Just one clarification, Mr. Hines, you've reviewed KPK's Exhibit S, have you not?
Yes.
And that contains the estimate of remediation expense for all locations on which KPK has performed an analysis as previously described by Mr. Peterson. Is that your understanding?
Yes.
And so the Facility 9, SAC 711, SAC 811, KPK estimates are contained within KPK Exhibit S, are they not?
Yes.
Very good. That's all I have.
All right. Thank you. With that, Mr. Jacobs, are you done with your case in chief on remediation? You're muted.
We are.
Okay. Okay. I believe we are going to conclude for the afternoon. We have a hearing tomorrow that starts at 9 a.m. It's our normal business agenda. It has nothing to do with this matter. I am informed by looking at the docket as well as discussions with hearing managers that we should be done hopefully in the morning. AAG Davenport, if you could visualize, I'm looking for some support on a continuance motion. Back in my local government days, we needed it to continue to a time certain, but we're uncertain as to when we're going to have this time to get together tomorrow. Should we continue to 1 p.m. and then if we're not ready at 1 p.m., we will so inform everyone by putting our little placket out there, and then we'll show back up as soon as we can. Do you have any ideas on a motion? Oh, and before we go there, Mr. Sir and Mr. Lewis Prescott, are your clients available, witnesses available tomorrow?
Dacono's witnesses are available. Thank you.
Town of Frederick's witnesses are available as well, and I would truly appreciate having a date and time certain to begin that testimony.
Yeah, no, thank you both for checking in with your clients and your witnesses. We've already heard from Mr. Boudreau that staff's available and from Mr. Jacobs that KPK's available. AG Davenport, I just bought you some time. Do you want to provide me some perspective on a motion?
Thanks, Chair. And I just note, Mr. Jacobs does have his hand up. So, but I'll respond to your question too. I think this commission's practice has been to continue to a specific date and time when it continues a motion, when it continues a matter sort of in as little a time period as the next day. We don't have a legal requirement to do it to a specific time if everyone's here, though obviously Mr. Sura has requested a time, and I think it may be efficient so that everyone knows when they return. I think you can continue the hearing to tomorrow to a specific time. You can continue it to when the business that is scheduled for tomorrow concludes. Both of those would be reasonable options, I think.
Okay, well, when the business agenda concludes, we're going to want to take a short break to get some lunch, I would think. So, and I understand that perhaps hearings manager Thomas emailed council suggesting 1 p.m. So why don't we say 1 p.m. and then if for some reason 1 p.m. is not looking like it's going to be doable, I will have the hearings manager open up this docket, open up the Zoom, and post that what alternate time it looks like we're going to all be here. And I know that the hearings manager also has ready access to all council of records, so we can do that. Mr. Jacobs, I know you have your hand up.
Yes, I just wanted to get a time check from the hearings manager, Mr. Chairman.
Yeah, okay, great. Well, let's let him gather that. Mr. Thomas, if you could get time checks for everybody, that would be great. Other than that, I would move that we adjourn for the afternoon and reconvene tomorrow at no earlier than 1 p.m. So that would be our motion to continue this matter to October 25th at 1 p.m. Do we have a second?
Second or move? I'm not sure. Did you move or?
I think I moved.
Did you encourage a move?
I think I moved. So we've got a motion and a second. We're not going to leave until we get time checks, but all those in favor of the motion to continue to tomorrow at 1 p.m. signify by saying aye. Aye.
Aye.
Aye. Any opposed? All right, this will be taken up tomorrow no sooner than 1 p.m. And hearings manager Thomas will be in touch with council if it looks like the 1 p.m. time is going to be a problem.
Yes.
Mr. Thomas, do you want to provide time checks to councils?
Certainly. Staff has 29 minutes and 30 seconds remaining. KPK has 36 minutes and 45 seconds remaining. Frederick has 73 minutes and 18 seconds remaining. And Dacono has 33 minutes and 2 seconds remaining.
All right. Well, there you have it. With that, we will adjourn for the evening since we've already had our motion, and we'll see some of you at 9 a.m. for our normal business docket, and then we will reconvene this matter at no sooner than 1 p.m. Have a good night.